I can't do the hard. Good afternoon. Welcome to the regular Sunshine Ordinance Task Force meeting of July 26th. We do not have two chairs, even though it says that on the agenda. I'm Hope Johnson. I'm the new chair, and even though we do not have Member Nee here, I would like to thank him very much for his service the last 2 years as chair. Mr. Reston, will you please call the roll?
Yes, Madam Chair. Member Snyder?
Present.
Snyder present. Member Nee? Nee absent. Member Cawthon?
Here.
Cawthon present. Member Manny? Manny present. Member Washburn?
Present.
Washburn present. Member Knebber? Knebber absent. Member Costa?
Present.
Costa present. Member Wolf?
Here.
Wolf present. Member Chan? Here. Chan present. Member Johnson?
Here.
Johnson present. Member West?
Here.
West present. Madam Chair, we have a quorum.
At this time, the chair would like to move that we excuse Member Nee, who is away due to a family emergency.
So moved.
Second.
Second.
Is there any public comment on the motion to excuse Member Nee?
Yes, I'd like to understand what you mean by the word excuse definition-wise. Does the term excuse mean that, you know, his performance or lack of it thereof for the last 2 years? Since you did thank him earlier for his exquisite performance in denying me due process and everything while he was the chair, I just want this to be on the public record. Thank you.
I will respond just briefly that we do have a rule in our bylaws about unexcused absences, and then you would be referred to the Board of Supervisors. So that is why we are making this motion. Is there any further public comment? Seeing none, public comment is closed. Mr. Clerk, will you please call the roll?
Yes, Madam Chair. Member Snyder?
Aye.
Snyder, aye. Member Cawthon?
Aye.
Cawthon, aye. Member Manny? Manny, aye. Member Washburn?
Aye.
Washburn, aye. Member Knebber? Knebber absent. Member Costa?
Aye.
Costa, aye. Member Wolf?
Aye.
Wolf, aye. Member Chan?
Aye.
Chan, aye. Member West?
Aye.
West, aye. Member Johnson?
Aye.
Johnson, Madam Chair, we have 9 ayes. The motion passes.
Thank you. Mr. Clerk, have you heard from Member Knebber?
Madam Chair, no, I haven't.
Okay, for now, we will wait and see if he shows up late. So we do have a couple of agenda changes and possible agenda changes. And we'll start with the parties in case 11044 and 11051, which are items 11 through 14 on our agenda, have requested a continuance. We do require a 3-day notice to request a continuance without a motion, so we'll have to move to continue and vote. Do I have a motion?
I move that we continue these items.
Second.
Is there any public comment on the motion to continue the items? Seeing none, public comment is closed. Mr. Clerk, will you please call the roll?
Yes, Madam Chair. On the motion to continue the items, Member Snyder?
Yes.
Snyder, aye. Member Cawthon?
Aye.
Cawthon, aye. Member Manny?
Aye.
Manny, aye. Member Washburn?
Aye.
Washburn, aye. Member Costa?
Aye.
Costa, aye. Member Wolf?
Aye.
Wolf, aye. Member Chan? Aye. Chan, aye. Member West?
Aye.
West, aye. Member Johnson?
Aye.
Johnson, Madam Chair, we have 9 ayes. The motion passes.
Thank you. The items 11 through 14 will be continued to our next regularly scheduled meeting. One other change I'd like to present to my colleagues is, for health purposes, we are interested in, if both the respondent and the complainant are present, in moving to after item 10, the complaint filed by George Wooding against Rec and Park, which are currently items 23 and 24. So we would then hear those right after item 10.
Do we need a motion to do it? Move that do we need to a motion?
Yes, we do.
I move that we make the agenda change.
Second.
Is there any public comment on the motion to move items 23 and 24 to after item 10?
I'd like to thank the task force for making an accommodation for Mr. Wooding. Thank you.
Is there any further public comment? Seeing none, public comment is closed. Mr. Clerk, will you please call the roll?
Yes, Madam Chair. Member Snyder?
Aye.
Snyder, aye. Member Cawthon? Cawthon, aye. Member Manny?
Aye.
Manny, aye. Member Washburn?
Aye.
Washburn, aye. Member Costa?
Aye.
Costa, aye. Member Wolf?
Aye.
Wolf, aye. Member Chan? Chan, aye. Member West?
Aye.
West, aye. Member Johnson?
Aye.
Johnson, aye. Madam Chair, we have 9 ayes. The motion passes.
Okay. Okay, we are going to, Mr. Clerk, will you please call the first item on the agenda?
Madam Chair, we have one more request for continuance.
We do. Okay.
That would be file number 11035, which is item number 9.
And who has requested the continuance?
The respondent has requested it.
And did they provide a reason?
I wasn't given a reason. It was made just before I entered the room.
Thank you. Is Marlon Crump present? Mr. Crump, the respondent has requested a continuance in your case. Yes.
Okay, here's the deal. I respectfully decline through email that I do not wish to have this into a continuance whatsoever because I'm making a significant transition. So their request is denied by me at least.
Okay. I'm not sure what the pleasure of the task force is, but I will say that I did take. Did you watch the video of that particular? Mm-hmm. And it may be. Well, I'm reluctant to continue it to Mr. Crump. It may be difficult to have a conversation with them about their comments to you. So I just want to let you know that if they're not present, they're not going to be able to respond to some of our questions that I know I have about it. So that would be a disadvantage to you in some respects.
Well, honestly, between each and every task member here, I didn't want to be here at all because this is the 3rd week that I've come to this. They keep playing all these damn games. I'm sick and tired of it. And, you look at the video, you see them interrupting my public comment.
Well, I'm just letting you know.
Yes, I understand.
So you still would like to go forward with your case?
Well, only for the day only, because like I said, this is the last time that each and every one of you on this board may actually even see me here. But I don't want to keep wasting my time, your time over the same old, bullshit. I'm excuse me for saying that, but you get to the point you just get tired.
Okay, thank you.
Yeah.
Any opinions from the task force?
Did they
Member
say
Cawthon?
why they wanted the continuance? And could you review for me how many times Mr. Crump has been here?
Mr. Crump's case came before us, the full task force, at the June meeting. I do not know, Mr. Clerk, was there a pre-hearing at the complaint committee? Or no, nobody from the complaint committee is here.
And also, they didn't show.
They did show last time, but we had not seen the video that the police officer provided.
And did they say why they couldn't come today?
Well, last meeting, Detective, or is he a Sergeant Falvey, he had said he could not be here.
3 meetings.
3 meetings? So they did do the complaint committee. Member Wolf?
Yeah, my concern about this is when a respondent doesn't show. That, in my experience, going back to 2005, usually after the second time, it usually goes to the complainant. That's the way, and it's by a vote, but it's always been we're not going to wait for the respondent to show up. It's treated as if the defendant, one of the parties didn't show up in a court case, in that kind of way. And I think it's a way to dispose of the issue and to also send a message.
All right, then we will continue with, we will not continue, we will go forward today with Mr. Crump's complaint. Mr. Clerk, will you please read the first item on the agenda?
Yes, Madam Chair. Item number 1 is the Compliance and Amendments Committee has recommended that Street Artist Program Director Howard Lazar be referred to the District Attorney and the Board of Supervisors for failure to comply with the order of determination in file number 11023, William Clark against the Arts Commission.
Okay, I would like to just take a moment to remind the task force and the parties in these first 6 orders of determination that we are not rehearing the case, that this is about, we've already determined what we believe is disclosable or what should or should not have happened, and we're trying to determine if the order of determination as we requested was followed. So in this particular case, we had determined that the San Francisco Arts Commission should have provided William Clark with oral information, and he did not do so. There were documents provided, but they did not receive the oral information that they requested. At the Compliance and Amendments Committee, the San Francisco Arts Commission just repeated that it had provided the documents and was not required to, again, produce a document that didn't exist or create a document that didn't exist. And it was forwarded here to the full task force because we are trying to find out what we would like to do because the order of determination was not met. So if the parties during their time could keep that in mind as they speak, it would be very helpful, and it would help limit the amount of time we spend on the orders of determination. Is the complainant present? You have 5 minutes.
I'll be brief and not to rehash things, but very specifically, I have not received the explanation from the Arts Commission yet as to why Ms. Russell's job classification was changed from a senior clerk typist to a museum curator. As I've explained to all of you before, I don't think the job classification is appropriate for her job, and she received an increase in pay as well as benefits as a result of this. I wasn't informed didn't find this out until I was able to get some information as a result of the Sunshine Ordinance, which informed me that her job classification had been changed 5 years earlier. So the Street Arts program has been paying for this, her job classification and benefits at a higher rate of pay than I believe her job actually qualifies for. So I feel that these increased benefits and pays contributed to the fee increase that the street artists had to pay last time. So I have not received anything in writing, nothing verbally, and I would still like to have an oral explanation as to why her job classification was changed to a museum curator. Thank you.
Thank you. Is there anybody in the audience to present facts or evidence in support of complainant? Seeing none, is the respondent present? Could you please state your name?
Certainly. Good afternoon, Commissioners. I'm Jill Manton. I am the Director of Programs for the Arts Commission. I'm the number 2 executive at the Arts Commission, and I believe that I can successfully address Mr. Clark's complaint. In the 34-page document that was provided to him was a JAQ, which is a job analysis questionnaire. It's a standard form issued by the Department of Human Resources when a staff person requests a reclassification, and the director of the agency, the appointing officer of the agency, is willing to consider that classification before it can be made effective. The employee must fill out a job analysis questionnaire which details their job descriptions, and then DHR, Department of Human Resources, in this case it was our former representative, Ms. Jenna Lee, reviews the job scope and looks at city job classifications to see which job classification would best align with the scope of work performed by the employee. And so in the documents that Mr. Lazar provided, and which I reviewed with him today, I found the job analysis questionnaire, and I found a written comment by Ms. Jenna Lee from Department of Human Resources saying that this work is consistent with the job described by or performed by a Curator 1, 3541. So that was the basis for making the change. So I believe that the information was contained in the documents. Perhaps Mr. Clark doesn't know the terminology for reclassifications, but it's a standard instrument used by DHR to evaluate the work of an employee and make a decision about a change. And sometimes it's approved and sometimes it's disapproved. So if I can answer any questions you may have, I'd be happy to.
That will come after.
Okay.
At later time.
Thank you.
Is there anybody in the audience to present facts and evidence in support of the respondent? Seeing none, the matter is with the task force. Member Washburn?
First, a comment about this particular matter. There are several violations that we found, and one and particularly important one is that there was never anyone sent to our many hearings. There were at least 3 on this matter to present who was knowledgeable about the situation, and this was very frustrating to us. And I don't want us to lose sight of the fact that we found a serious violation to 67.21E. But I also have a question of Mr. Clark. I'm just wondering if what we just heard from the respondent, if that information was in fact in the materials you received, was...
This is the JAG, but that doesn't answer my question. My question is, why was she given a pay raise and a job increase? Her JAG does not explain any of this stuff. This is a copy of it, which you all have a copy of this. And it's just communications back and forth between human resources and them. Yeah, I don't want to go on. I just want to answer your question.
Okay. All right, thank you.
Member Wolf?
I just want to cut to the chase here. We're not going to retry this case. The case has already been determined. We already found a violation. Mr. Clark was given documents he didn't request. He was then charged for those documents he didn't request. And I'm sorry? That's a different one. Okay. Is this not, Mr. Clark, is this not the case that you were...
He was charged with a fee.
No, I was charged for documents, a bunch of things that were included, but all I'm saying is that the information explaining why it was necessary, the JAG that was given doesn't tell why it was necessary to change her from a senior clerk typist. Her job function did not change.
I'm not concerned about so much of the detail. I'm more concerned about whether you mentioned earlier in your testimony that
right.
you were expecting some verbal communication.
Yeah, because he said that he answered that he would not release the doc. He said some of the documents I asked for were protected and he would not release them. And I said, well, I would like an oral explanation of why she was changed.
Well, if the information is protected, then whether it's on paper or in voice, it's protected.
Well, yeah, he claims it was protected. I'm asserting that it wasn't protected because this had to do with personal.
Right. Okay. So I'm not going to retry that part
Right.
of the case. I just want to make sure I'm on the right.
I
on
understand.
The right
No,
page
I
with this.
understand
Okay.
because you're confusing this with
Right.
another
You
issue.
have so many of
Right,
them.
I
yeah.
understand.
So, Mr. Clark, what you're saying is that explains that the document they have explains why she fits a certain qualification, but what you want to know is what was the reason why they had to change it in the first place and give the raise.
Not quite. No, I disagree that the document explains how she fits. I'm asserting that they put a square peg in a round hole. They changed her classification and concocted reasons and rewrote things so that her qualifications may have tried to fit for a curator one,
Have you talked to them since?
We're not
our
talking. They
complaint?
refuse to have a discussion with me at any time at this point.
Okay, thank you. Is there any further questions about whether the order of determination has been met? The respondent and then the complainant will each have a rebuttal period. The respondent has up to 3 minutes.
Members, I'm Howard Lazar, and I don't know how to respond other than the way I've already responded, and certainly not to reopen the case, but I can assure you that the information that had to be redacted was redacted through the offices of the city attorney, and it was checked out, and I go with the city attorney. I don't want to give you any conjectures to respond to his question. I only have documents, and if the documents didn't answer it, it didn't answer it. And that's all I can say.
Thank you.
And I think we're still within the 3 minutes, I hope, so I'll speak very quickly.
I would prefer not to have two people speaking. I'm sorry.
Okay.
It's
I just want to respond that, you know, this JAG is definitely, all this stuff is nothing. It doesn't answer my questions. And that the communications between HR, Human Resources and the Arts Commission were all done by Mr. Lazar. There was months where they were sending emails back and forth, and HR was telling Mr. Lazar, her qualifications, her resume is incorrect. Her qualifications don't fit the circle, and tell her to rewrite it over again. Do this. Let me suggest that. And right from the very beginning, it was Mr. Lazar who initiated this job function change. So even though there aren't documents explaining why this job function was changed, giving her a 10% fee salary increase in benefits, Mr. Lazar is the person who worked with HR and Ms. Russell to do this, and he initiated this whole process. So he has to know why it was necessary to give her this fee increase. For him to say that he has no idea is, you know, he's the director. He's the one who did all this. If any, he's probably the only, maybe now that Mr. Kinsella is gone, he's probably the only person who knows why this is done. Or actually, Mr. Kinsella wasn't present at the Art Commission when this occurred, so I'll withdraw that statement. But Mr. Lazar was the one who initiated this. He's got to have a reason for it. Thank you.
Thank you. The matter is back with the task force. Member Wolf?
So the order of determination was the failure to send somebody who was knowledgeable at the time of the meeting of the original complaint about the information. So there was no way that
That's half of it.
I understand
Okay.
that's half of it, but that's the part that I'm speaking on. So because we have, if we're going to take any action, that's kind of the actionable part that I want to speak on. And then I'll wait for other members to talk about other items so we can come up with an appropriate motion. But my concern is how many times the complaints have come that somebody has been sent who doesn't have full knowledge of the information, and under the Sunshine Ordinance it's required. And I think that's really important. It wastes a lot of our time. If you were to count up how many, the actual time of all the items, had they been heard today, it would have been over 9 hours. So, I think for these items to constantly be coming back, we're not able to provide a level of satisfaction or at least closure, and we keep continuing these items. I think we need to find at least in violation for not sending a knowledgeable representative.
Member Costa?
So I will certainly echo Member Wolf's sentiments about the not sending a knowledgeable representative, but I guess I just want to clear something up. My impression was that this item got forwarded back from the Compliance and Amendments Committee because there was also in the determination that we felt that Mr. Clark had not received information that was indeed disclosable, which he had requested, and that he still hadn't received that at the time of the Compliance and Amendments Committee, and so that we're voting whether or not to refer this case to the district attorney and the Board of Supervisors because of that in particular. Is that
Yes,
right?
that is correct.
Okay.
Member Snyder?
Yeah, just in an effort to sort of clarify the procedural status of this case, and anybody who thinks differently, please correct me. But I think all we're deciding here, all that's in front of us to decide, is whether we agree with the Compliance and Amendments Committee's conclusions as to the violations of 2 sections of the statute. And if we agree with those, then it seems like the motion would be to refer this case to the district attorney, not to find a violation, because we've already found the violation as a full body, and the Compliance and Amendments Committee has found that the order of determination was not complied with. And so I think all we're doing here is deciding whether we agree and whether to forward it to the DA.
Is that a motion?
Yes, I would move. I would move to. I'm not sure the language we usually use here, but I would say affirm the conclusions of the Compliance and Amendments Committee and forward the matter to the District Attorney's Office. Before I actually make that motion, I wanted to ask DCA 3, is the typical, when we receive something back here at the task force from the Compliance and Amendments Committee, do you recall if we typically vote to affirm or if we vote to adopt the conclusions of the Compliance and Amendments Committee, what kind of verbiage we use and what the procedural mechanism is?
Through the chair, Member Snyder, the vote is determined by the agenda description, and the agenda description says that the committee has recommended a referral for failure to comply with the order of determination. It's an independent this is an independent vote by the task force, so you would simply take a vote on whether you should refer for failing to comply with the order of determination. If I might suggest something clarifying here, the motion would be for finding that there's a failure to comply with the order of determination, and there's 2 sections of that. It orders that it finds that they violated for failure to send a knowledgeable representative and for the failure to provide the oral information. I was not at the complaint committee, but the administrator tells me that the department sent a representative there, and they have a representative here. So it appears that they've been complying with, at least from appearances, with that part of the order since the order was entered. And perhaps I'm wrong about those facts because I wasn't at the Compliance and Amendment Committee. And then separately, there's the failure to provide oral information. So my suggestion, if you're going to make a referral, is to provide findings of fact to support the 2 violations that you're going to refer. That way the organization, the entity that gets the referral, will have your reasoning to support your conclusions.
I would just like to add to DCA 3's description that the representatives that we had appear before the Compliance and Amendments Committee was Mr. Matos, who simply read and could not answer questions. So that is partially where that came from. And then also I wanted, before we make the actual motion, I wanted to ask DCA 3. It's my understanding that to refer something to the district attorney, there has to be a crime involved. Should that actually be the attorney general?
I can take a look in the Sunshine Ordinance to see if there is something there about it being a misdemeanor. But referrals to the district attorney are for investigations into criminal violations, yes.
Member Wolf?
In the ordinance, it speaks specifically on cases like this where it's below willful failure. In 67, I think it's 67. I think it is 6723. I don't have my ordinance in front of me, but I think it's either in E. It's in 6721 where it mentions the failure to comply would be or can be or may be referred to the district attorney or the state attorney general. Whether or not it's criminal or not is of no consequence. The ordinance just specifies that it can be referred there.
Okay, I'm just going to read it. It says, if the custodian refuses or fails to comply with any such order within 5 days, the Sunshine Task Force shall notify the district attorney or the attorney general, who may take whatever measures she or he deems necessary to ensure compliance with the provisions of this ordinance. It's 6721E. So, Member Snyder, did you want to make your motion with facts, or?
Yeah, let me think about it. Let me study this for just a second.
Member Chan?
I think I recall something about, when we do send it to the district attorney, it has to have some type of criminal element of at least deceitfulness, some type of willing failure, but with some type of criminal aspect. Because I know, guarantee the district attorney will probably shoot it down.
DCA 3.
Through the chair, there's no restriction in the ordinance that would keep the task force from making a referral to the district attorney. My comments were directed at the authority of the district attorney to bring an action from on the basis of that referral. The district attorney prosecutes crimes. They can be misdemeanors, citations, felonies, whatever they may be, and they can be local or state laws that are violated, but they only prosecute for the criminal prosecutions. Now, they do have authority to, in some circumstances, to bring civil prosecutions under some state statutes, but those are not applicable here.
Member Wolf?
It just, the thing is the ordinance reads as it does. I'm not going to try to interpret what the job of that particular office is. The ordinance says that we can do it, and that's what we're planning on doing. And it's up to them how they want to dispose of it. It's only our job is to refer it, and it's up to them to determine how then to carry out the violation of the city law, which essentially is also state law, most of it. So I don't want to try to interpret what the district attorney or attorney general can or cannot do. That's not our job here. Our job is just to do what the ordinance provides us with authority or jurisdiction to do. And we are in full, as DCA 3 confirms, that we have the ability to forward this on to the district attorney or the attorney general, and they may take whatever measures they deem necessary. It's not for us to determine.
I would definitely encourage us to either make a motion or not, rather than having really long discussions through well past the 15 minutes. We have quite a long agenda. Member Snyder.
So I will I just quickly point out that the agenda item actually notes that the Compliance and Amendments Committee recommended that this be referred to the DA and to the Board of Supervisors. So in accordance with that, I'm going to move that we refer this item to the District Attorney and the Board of Supervisors based on the facts as they are laid out in the order of determination. And so that's the motion. And then as a clarifying statement, I'll say that the facts on which we're basing the referral to the DA and the Board of Supervisors are laid out in the order of determination. The task force, I think, now could decide that new facts have come to light that change what the order of determination said or change the status of it. And anybody, obviously, in the task force can so move, but I think it's sufficient to base our conclusions on the order of determination, because the question we have in front of us is whether we're going to refer the violation as it's found there to the DA and to the Board of Supervisors.
Is that a motion?
Yeah, so
I'll
I
second.
moved, as I said. I won't repeat the motion, but yeah.
And your second?
I second.
Member Costa?
So I'll try to keep it brief too. I might disagree slightly with what Member Wolf was saying. I think that certainly the ordinance does give us the leeway to make this recommendation or this referral, but I think that it would actually behoove us to keep in mind, the sort of duties and normal operating procedure of the party that we're forwarding it to. If we're sending it on to somebody who is not going to do anything with it because they only look at criminal cases, I think that that's a sort of. I think that the more that we can sort of operate within the guidelines and the standard operating procedures of other agencies and other governing bodies, the more seriously our orders of determination will be taken and our referrals will be taken. If we send this on to the district attorney,
Are you making a friendly amendment?
I would make a friendly amendment to remove the referral to the district attorney, but keep the referral to the Board of Supervisors.
Not to replace the district attorney with the attorney general?
I would be open to hearing logic for that, the logic behind that. But I also just wanted to make another brief point, and that's that adding to Member Snyder's comments about facts, I think that another fact would have to be added, which is that at the time of the committee hearing, there still had not been compliance with the original order of determination. Is that
I understand what you're saying. You're saying that it's not just the order we're
Right.
referring, but that it was a continued non-compliance.
Exactly.
Is there a second to Member Costa's motion to remove? Is there discussion on that? Member Wolf?
Yeah, I disagree with that. I mean, we're here to uphold the not only Sunshine Ordinance, which parts are local. Most of the other parts are state law, which are covered under the jurisdiction of the district attorney. District attorney comes under the guise of the attorney general and has the jurisdiction of handling local law. I just disagree that we are to determine what their job is or isn't. We can't send it to the Ethics Commission unless we find it being willful failure. Okay, so I disagree with this. I'm going to vote no on this amendment.
I have to agree with Member Wolf. I don't think that the Board of Supervisors has been any more responsive than the Ethics Commission, and I really feel that we need to try a number of different options, including the district attorney. But we also need to move forward with this. We cannot keep taking 45 and 50 minutes every time these cases come before us. So let's do the call. I'm going to call the motion on the to amend. Public comment on the motion. This is on the motion
This
to
is
only send it to the Board of
absolutely on the motion.
Supervisors. Okay.
Member,
Yes, that's what I was trying to say, that it's the motion. This is public comment on the motion to send it only to the Board of Supervisors, to amend out sending it to the district attorney.
hold my remarks. just that, because you're already 10 minutes overdue and 10 minutes late getting to my item because of the exuberance of member Costa. It's not your job to decide that, as Member Wolf informed you. DCA 3 didn't mention to you California Code 1222, which may well be misdemeanor, but it's not up to you to decide whether the district attorney is going to pull out 1222 out of his rabbit hat. So I would encourage you to withdraw your amended motion and stick to the job that you're supposed to do here. And I respectfully ask that you not pull this stunt when you get to me.
Task Force members, Ray Hartz, Director, San Francisco Open Government. And I would also ask that you pull the change to the motion and send it both to the Board of Supervisors and to the District Attorney. The reason I say that is what has recently transpired with the Ethics Commission. You sent them 18 different referrals, and they ignored 18 different referrals, giving them a perfect record of never lifting their finger to help any citizen gain access to public records or public comment. And so basically the decision really is, are we going to say, well, they probably won't do anything anyway, so we won't send it, which is a self-defeating prophecy, a self-fulfilling prophecy, or do you send it there and hope that after a while, and they've got 15 or 16 like the Ethics Commission did, and the civil grand jury looks at it and it becomes now a public embarrassment to them that they haven't done anything? That is a very powerful thing. If you hold them back, you say, well, they aren't going to do anything, we won't send it. They say, well, we didn't do anything because we didn't have anything to do anything with. But if you
Mr.
send it to
Garza,
them,
you will remain quiet while people are speaking, and I'm not going to say it again. You can say whatever you want when it's your turn to speak, but do not interrupt public.
if you send the motions to the appropriate people, you have done your job. And what they do about doing their job is their business and their responsibility to answer for. You shouldn't be trying to answer or figure out who's doing what or who isn't doing what, because you have no control over that whatsoever. You found violations. You've gotten a basis for sending that on to the appropriate parties. I would send it to any appropriate party that might do, hoping that one of them will have the decency to act in the appropriate manner.
Thank you. It's my turn for public comment. Unfortunately, I would like to comment on this because what's going to happen when you do refer it, let's say, to these people that you're going to refer it to, the Board of Supervisors, the District Attorney, and they don't perform, just like the Ethics Commission didn't perform? Are you going to go ahead and offer more false hope to all the complainants that come here and say, well, you know, our hands are tied. We did our job. You know, that's all we're responsible for. Is this the Ministry of Sunshine, where the truth holds no weight, where reality is a black hole, where useless decisions that aren't enforced for the complainant, where you only harm them by continuing to give them false hope, knowing full well what the outcome is going to be, and then to say, well, you know, we did our part? Well, you know, it's really interesting because in Nazi Germany, the excuse that the guards used while they were pushing the Jews into the oven was that they were doing their job too. It didn't make it right, especially with knowledgeable people knowing that the game is rigged and then not being accountable for it. That, my dear chair, is false hope.
Thank you. Any further public comment?
Robert Clark, I can understand the gentleman's cynicism, but as one of the people involved in this, I would ask that you withdraw your amendment and go straight to the district attorney, because even if the district attorney does nothing, it gives us an opportunity to talk to the district attorney about what we believe has been a fraud upon the street artist program community and a fraud upon the citizens of this city, because we believe that this woman was given this job classification in a manner that was done by Mr. Lazar that does amount to defrauding the city and the street artists, because the evidence that we presented to you clearly shows that there was a back and forth where things were changed. The HR department told Mr. Lazar, oh, you got to change this, and make sure after she changes it, you tell her how wonderful her job qualifications are. And as you read the emails, that's exactly what happened. So I'm just respectfully saying, I have no high hopes or anything, but I want to go through the process and one of the things is for us to go to the district attorney, and we'll take it on with them, and we'll see what happens from there. Thank you very much.
Thank you. Is there any further public comment?
Good evening, task force members. Thomas Piccirillo. I oppose the friendly motion amendment by Mr. Costa, and would urge you to send the matter to the district attorney as well as the board of supervisors. Although I do believe Mr. Wolf misspoke when he said that you could not refer this matter also to the Ethics Commission. The Ethics Commission has jurisdiction on serious and willful violations, but you also have the authority and perhaps duty to send the matter to the Ethics Commission on an order of determination. It doesn't have to be a serious violation for you to refer to them. But we all know that the Ethics Commission has not been enforcing orders of determination. So the task force wanted to try another jurisdiction. Clearly, the district attorney would be that jurisdiction. Whether or not they enforce your orders of determination remains to be seen. But at least minimally, you ought to give the district attorney's office a chance to enforce the orders of determination. There doesn't have to be any criminal activity. The sunshine spells out when orders of determination are not complied with, the district attorney has jurisdiction, just like the Ethics Commission and the Attorney General. So again, I oppose the friendly amendment and urge you to enact the original motion. Thank you.
Is there additional public comment on the motion to remove the district attorney referral and only refer to the Board of Supervisors?
I think you should add the Ethics Commission. The ordinance clearly provides that the task force can refer violations to an enforcing body, which the Ethics Commission is. They need not be willful. The violation here, there are two actually, but the one dealing with the substance is a failure to comply with an order of determination, and that's a requirement under 6721. So I'd add the Ethics Commission, and the reason I think is the more cases that are over there, the less likely they are to trash them. And we're working, as you know, on regulations that will allow for enforcement, and they don't require willfulness. So it's important to get this stuff synced. The other thing I might mention, that Mr. Lazar walked out as you were, that shows his respect for this organization. And not just the members, but the people here, including myself, who have waited and wait our turn. Thank you.
Is there additional public comment?
I would like public comment on
You,
the main
you already
motion.
had. You already spoke, sir. I'm sorry. Thank you.
You don't take.
You already spoke on this. We will, but this is on the second motion. The matter's back with the task force. Oh,
I think you should send. I think you should send the letters, whatever, to any and all body agencies and the members of the press, because we're at a point where we're losing faith. I mean, I filed 3 complaints, and I'm still not getting the documents that I filed for. So the system isn't working, and they're just going to go back to an organization that doesn't have respect for the community or the public anyway. So I just think anybody, everybody, and we're at 1820 now. What happens when we stack the numbers up to 100, 200, 300? So you didn't do nothing for 300, 200, 300 times. Just stack it, somebody's going to figure out that they are just almost criminally negligent of doing their job over at the Ethics Commission.
Thank you. Is there any additional public comment? Seeing none, public comment on the second motion is closed. Member Chan?
I agree with Mr. Grossman. I was wondering if we could add ethics.
We have a motion on the floor to remove the district attorney.
Afterwards, can we add ethics? Yeah.
Even if it's not on there. Member Cawthon?
What I'm going to say refers to all the compliance and amendments referrals to us. They spent a long time on this matter before they made their referral to us. They did talk to the department as well. So I don't have a problem with accepting their referrals. And the other thing I want to say is that we have a huge agenda tonight. And this has taken us a long time, and we have 5 more CNA referrals. So I would move that we strike the friendly amendment and follow the suggestion of the Compliance and Amendments Committee and Mr. Snyder's original motion.
You're requesting it? I don't think we can do a motion to.
No, that's my comment.
Yeah. In light of the wealth of opposition that has been stated, I will certainly withdraw my motion. If I could just clarify in 10 seconds, I was not trying to pull any sort of move as was suggested by some of the public. I was really trying to make sure that the matter was being forwarded on to the most appropriate parties. I think if the more we forward matters on to parties that don't consider themselves to be appropriate, the less seriously our referrals get taken in the future. So, thanks.
Okay, so now we're back to the original motion, and that is Member Snyder's motion that it be referred to the district attorney and the board of supervisors based on the facts presented in the order of determination and the fact that there was continued noncompliance following the committee hearing. I have a quick friendly amendment to that, which is I would like to add the San Francisco Controller's report to our whatever we send that was on the San Francisco Arts Commission. Have a second to that motion?
Okay. I'm okay with it. Adding to it.
Snyder?
Yeah, that's great.
Is there any public comment on the motion?
So which motion are we on? It's just the main motion
Now it's the main motion to refer it to the district attorney, the board of supervisors.
Thank you for clarification. As Mr. Grossman pointed out,
Can you speak into the microphone?
I'm sorry, as
Thank
Mr.
you.
Grossman pointed out, Mr. Lazar and his other knowledgeable rep, feeling a bit of heat, walked out. It's nice that they've complied since the order. It would have been nicer if they had complied before the order. So maybe they're getting it, that when you order them to do something, they should think about complying before you get to the order stage. On this particular motion, I would like to suggest that when the Compliance Committee debates for hours and makes a recommendation, that you may not subtract to it, but you certainly should add to it if you think it needs to go to ethics or if you think it needs to go to the Attorney General. Because at compliance, when you discuss my case on 113, I can distinctly remember, and I may have the sunshine for the minutes of that meeting, that there was a motion made to refer my case to the Attorney General, which now does not appear in the written agenda. So although the Compliance Committee thought that they were referring me to ethics, the DA, and the AG, only 2 of them made it into the actual motion adopted for the minutes. So I recommend you do not subtract, you do not debate on what they took a long time determining. If you want to have a short extension to add, you can add, but you can't subtract.
Good afternoon, Commissioners. I'm Mike Adario. I'm the liaison chairperson for the San Francisco Street Artists, and I would like you to refer this to the supervisors and to the district attorney. A little context about our program. It's sometimes thought of as a city program, which it is, but it's totally paid for by the members. We receive no money from the city. So if this job description was up to a second tier or to a curator, we paid for it. The members paid for it. The members that you see out on the street doing fun sketches, selling their artwork like myself, any of those members pay Howard Lazar and at the time Evelyn Russell's full salary, benefits, retirement, everything. We pay it all. We get no money from the Arts Commission. I mean, this whole program is upside down like that. That's why we're so concerned about this. For her to go from a clerk typist to a curator is, we weren't aware of this, first of all. They never told us this, and it's ridiculous. She is not a curator. This woman had numerous complaints against her. There was sexual harassment complaints made between staff, and we want to know if this was a quid pro quo that she got this raise because of the sexual harassment complaint. And she was discriminated against.
Can you limit your
some of her-
comments to the motion? I'm sorry.
Okay. Well, I wanted to give you context. Also, I would agree with putting the controller's report in to talk about this office, how they lost their money, our money was stolen, it was misallocated, and this is the controller saying this. So it's not a frivolous complaint. We want to know where our money went and why she was made a curator. But thank you so much. I appreciate it.
Thank you. Is there any further public comment on the motion?
Just a point of order, 5 o'clock is coming very soon.
Is there any further public comment on the motion? Seeing none, public comment is closed.
So I call the question.
Okay. Mr. Clerk, will you please call the roll?
Yes, Madam Chair. On the motion, Member Snyder?
Yes.
Snyder, aye. Member Cotton?
Aye.
Cotton, aye. Member Manny?
Aye.
Manny, aye. Member Washburn?
Aye.
Washburn, aye. Member Costa?
Aye.
Costa, aye. Member Wolf?
Aye.
Wolf, aye. Member Chan?
Aye.
Chan, aye. Member West?
Aye.
West, aye. Member Johnson?
Aye.
Johnson, aye. Madam Chair, we have 9 ayes. The motion passes.
Motion passes. And this matter is referred to the District Attorney and the Board of Supervisors with an attachment of the Controller's report. It is now almost 5 o'clock. Before we begin the next order of determination, we're going to hear general public comment on matters not on the agenda.
Thomas Piccirillo.
You will
Madam
each have 3 minutes. I'm sorry, Mr. Piccirillo, for interrupting you.
Sorry?
I just wanted to state that each person would have 3 minutes to speak before we
Thank
started. I
you.
apologize for interrupting you.
Okay, thank you. You spent 1 hour on one item on the agenda. Clearly, you need to tighten up the discussions so that the complainants here tonight can all be addressed. I read your bylaws. If you read Section 9 of your bylaws, it sort of recommends to you how to lay out your agenda. And what it suggests, Section 9 is not mandatory. It says you may, but it suggests that you put the new complaints first. And then the other matters should follow. That's only fair to the new individuals that can't get public records or can't speak during public comment. Saying that, again, I'll reiterate that you can't spend 60 minutes on one item on the agenda if you have 30 items on your agenda tonight. It's just not fair to the people that come here tonight with new issues before you. Thank you.
Thank you.
Task Force members Ray Hartz, Director, San Francisco Open Government, and I will respectfully disagree with Mr. Piccirillo. These things take as long as they take, and if you're going to do what's right, everybody needs to have their say. If there's one place where members of the commission and the public should have an opportunity to say what they want, it should be in the very body that is supposed to enforce that throughout the city. So, it drags on sometimes, but That's the nature of it. I would like to just make a very general public comment relating to the last case and one of the comments that was made about they don't talk to me anymore. Somebody in the city has gotten the wrong impression that if I'm a city employee and I don't like you, I will just refuse to deal with you. And that is a responsibility of my job. I don't have the option of saying, I don't like you, I don't like what you're up to, I don't like what you're trying to do, and therefore I'm going to simply refuse to communicate. And so often when I put in public information requests, what I get is a person who will simply say, I need a 14-day extension. You say, well, how can you decide if you need a 14-day extension when you have no idea what I'm asking for? You're saying it's going to be voluminous, but I haven't asked for anything. I've asked for assistance in identifying specific documents, and I may just want 1 or 2 documents, and this may be something that you can respond to immediately. It might be something that you can go to a file and pull out copies of a report you sent to the mayor's office or to the Budget and Finance Committee or the comptroller, which would answer all my questions. But instead what they do is they say, oh, we need 14 days, and then they go out and drag every piece of crap they can find, and they throw it out there and say, oh, well, look, we're being responsive. And no, it was just a delaying tactic. And then they send people here, as has been mentioned by someone else, that is disrespectful to you. These are people who expect, as members of city government, to be respected for their position and their experience and so forth. And yet when they come here so often, they come here acting like they're dumber than a box of rocks. I don't know what's going on in my department. I don't know why that happened. I don't know who ordered that. And it's like if you gave those answers to their bosses, they would be fired. But they don't have any problem coming here or sending people here who may be sent for the very purpose they don't know and can't answer your questions. And I think the only way you get the respect is when someone does that, you call them out and say, you know, I don't mean to be insulting to you, but do you have any idea why they sent you? Because you don't seem to be able to do anything to move this forward. And I think that, going back to the original part about these taking long, is why many of these hearings take way, way too long. It's the simple fact that you have to tell these city agencies, we demand the respect. You're going to give it to us whether you like it or not, and if you won't, we'll find you guilty. That's it.
Good afternoon. Peter Warfield, Executive Director of Library Users Association. With respect to the previous comment, I certainly think it would be very beneficial if the task force would look at some of the requirements of the ordinance and perhaps help to strengthen and clarify people's understanding with respect, for example, to oral information. I think there is a sense in some places that we don't have to say anything to you as though oral information is never mentioned at all in the Sunshine Ordinance, and as though the only response that they are allowed to get away with is just the provision of documents. And I've certainly experienced that. The Ethics Commission heard your referral about the Sue Cawthon case at its last meeting about 2 weeks ago, and it was very interesting. I understand, I haven't had a chance to look at your agenda. I understand that's not on this agenda at all, which I think is unfortunate. It would be nice to have a bit of a report. And I can certainly tell you that they unanimously voted to send a letter to the mayor finding not only a willful violation, but recommending that the president of the Library Commission, who silenced Sue Cawthon at a Library Commission meeting 2 years ago, basically should be sacked. There was some interesting commentary that I thought was happening at that meeting by the Library Commission president, Jewel Gomez, who did show up at that meeting. And I thought it was pretty shocking and pretty appalling. Among her comments were that she said she felt assaulted by the speaker at that Library Commission meeting, the speaker who was overwhelmingly sort of overpowered by the podium, and who has been in some press reports perhaps unflatteringly described as somebody, let's just say, who is not certainly physically any kind of a threat whatsoever. And I think personally, from knowledge of the person's behavior, I would agree with that. It hasn't anything to do with physical qualities, but with mental ones. And then she went on at some point when, I believe when it looked like the goose was cooked, she started in with what was really willful, she said, was that this body had the temerity, that wasn't her word, but what was really willful was her term. And then she went on to say that this body scheduled its meetings about that Library Commission action, her action, at meetings that she could not attend. I would appreciate very much also if your chair, who observed something outside the room, might make a comment about that. I think that would be helpful. Thank you.
Thank you.
Hi, Marlon Crump, writer, journalist, revolutionary legal scholar, quote unquote. So, when I came up here earlier, I heard you, Ms. Johnson, mention about you guys have already reviewed the tape. So, if that's true, if each and every one of you have already reviewed the tape, you would know that this is the same governmental body that people use all the time when they file OCC complaints. They are, so believing.
Mr. Crumpy, this is an only general public comment, so we can't have a discussion about your case.
No. I was talking in general,
Okay.
not just about my case. Okay. So, the reason why I came up with this public comment talking about this particular issue is to, I want you all to think about, that these are the people that everybody are relying on to have a fair and just outcome about their case. So, as I promised, I'm not going to say anything about my case, but I want each and every one of you to think about how people can just lie, how someone can just be prejudicial. And I mentioned people were talking back and forth about, personal feelings. Well, I'm sorry, but this is reality. If someone does not like you, they are going to compromise your case. They may even throw it, underneath the pile and say, whatever, so what. That's the reality. And as soon as y'all look over my case, whatever, that's that for me. That's it. So I'm gonna leave it to each and every one of you up here to decide, whether or not, whether it was any violation or any grievance, whatever. But that's all I really want to say about that. But I really want y'all to think about what I'm saying, and whether you care or not, this is the last time you're going to see me here, because, you get to the point, you get tired of the, I'm not going to say the word, I said earlier, the BS word, but that's the reality of the whole thing. Some people don't want to hear you, so they'll just go this way, and, thank you.
Thank you.
Good evening, Commissioners. My name is Pastor Gavin, and this is my first time here. It's interesting because it does take a while to have democracy. So I do applaud you for trying to be thorough, because we're all seeking justice as we come before you. I would just like to ask that you consider some of the people who are here with me tonight require reasonable accommodations. And I didn't state that in the beginning. As I said before, this is the first time I've ever appeared before you, but I do have a few seniors, and one does have a reasonable accommodation in regards to walking, and thank you.
Thank you.
Yeah, Steve Zeltzer, United Public Workers for Action. I've been involved, and I've seen a number of instances of systemic cover-ups, systemic malfeasance by the district attorney's office, by the city attorney's office, by Mickey Callahan, the human resources director, which they disregard the city rules and policies. There's cases of discrimination where they refuse to provide documentation to workers in the planning department. It seems there's a system of corruption here in San Francisco. And that's why they're ignoring this commission, which is supposed to address some of the issues of compliance with the rules and transparency. So my suggestion to this commission is that you actually start to compile a record of what's happening and where it's happening, and put this together and send it to the grand jury and publicize it. I mean, there are rules which should be followed. If they're not being followed, you have to examine why aren't they being followed. Why are city officials coming here and say they don't know anything about the rules, or they don't know what happened consistently? So I know that it's difficult, and you don't want to spin the wheels or spin wheels, and that's what seems to be happening. So that's my proposal, that you actually document that, do a study of the complaints that have been filed, how they're being addressed, and if not being addressed, and who's not addressing them for the systemic causes. Thank you.
Okay, my public comment today refers to a lot of things. I've been here over 10 years to see the systemic failure, to see the false hope, to see the duplicity, to see everything. Now, a while ago, I had a case in front of you, case 10038 for Tom Waddell, having released for denial of emergency services and things in that manner. And at that time, I didn't realize I had to leave my due process rights at the door to have my case heard. I wasn't informed about a rule which you have subsequently changed, that speaks to the fairness of the decision making. The rule that you've subsequently changed after my hearing, in which I notified the chair that I wasn't having due process because I had 5 out of 6 people who were here vote for me, but yet the motion was defeated. The new rule that has been changed in my favor, inclusive of the argument that I made to the old chair that the rule denied due process. Now, unfortunately, because the rule denied due process, and I was telling you at that particular point in time, and now the rule has been changed to not reopen all these cases, is the same exact principle that the DA violated in the Brady incidents. In the Brady incidents, both sides are on a level playing field. In the Brady incidents with the DA, the complainant or the defendant was not informed of what the other side was doing or was required to do, or that their officers had prior misconduct or whatnot. So it was stacked. It was rigged. The procedure was rigged. Based on the fact that they had a rigged procedure, they were denied due process, and that entire thing is still going forward. We have the exact same thing here. My due process was denied, and I was informing the chair. Now, when the chair denied me the due process, I wrote him and I said, well, why are you doing this? And he said, oh, well, it's because the city attorney interpreted it this way. Well, now that's a valid argument. If you stuck with it, didn't stick with it, now all of a sudden you're going against the city attorney's advice and changing the rule. What? Were you incompetent before? Were you negligent? Were you not able to have critical thought and to see that the issues in front of you were such that a person was being denied due process because of the rigged system? I still have my case sitting out there, 10038, that I have been waiting to refile because of the rigged process. And now I'm being told, well, we're probably not going to reopen all these cases in which we screwed everybody with our rigged process, because we've just admitted that the process was rigged. Oh, excuse me, let me see if I've got this right. Well, maybe we just didn't admit that the process was rigged, but we changed a process that was correct, I guess. Can't have it both ways.
Thank you.
I am surprised Mr. Warfield had to remind you that there should have been a follow-up report on today's agenda about Ms. Coffin's case at ethics. I was so proud of Mr. St. Croix and his commission for having found Joel Gomez had violated proper conduct, that following their vote, I tried to approach her outside in the hallway to congratulate her on being the first commission president to have been referred to ethics. And I also wanted to congratulate her that she was the first person that had been referred to the mayor for removal for improper behavior. You know what she did? She took her jacket that she had dropped on the floor She snapped it at me. The woman didn't just lose it with Sue Kaufman 2 years ago. She's still continuing to display that she's still losing it. So I would like to formally request that this body introduce a motion, hopefully tonight, or put it on your agenda for your August meeting, to also write a letter to the mayor saying that this body supports what it was that the Ethics Commission did in getting the first commission president in San Francisco history referred to the mayor for removal.
Thank you. Is there any additional public comment?
I want to start off that, Chris, you might need to adjust the microphone. It's very hot and it's excessively feeding back. With that said, I would like to hear some policy and procedure regarding video submission, because I submitted video for the coming case up, and with the ones that I submitted with the Jane Kim incidents, there was video that could have been submitted. I did come with a DVD tape, so I would like to hear some conversation regarding that, because I do believe you're missing like evidence that would be presented. So, and I guess I'm also concerned with the idea that the Board of Supervisors or the Rules Committee or whatever, they can filter information through the clerk, and that information might get disposed of somehow. So those are some of my things. Okay, I think the mic sounds a little bit better, so.
Is there any additional general public comment on items not on the agenda? Seeing none, public comment is closed. Mr. Clerk, will you read item 2?
Yes, Madam Chair. Item number 2 is the Compliance and Amendments Committee has recommended that John St. Croix of the Ethics Commission and Tanya Letigue of the Controller's Office be found in willful violation and official misconduct for failure to comply with the order of determination in file number 11013 Patrick Monash Shaw against the Controller's Office and the Ethics Commission, and that the matter be forwarded to the District Attorney and the Ethics Commission for enforcement, and a copy of the referral letter be sent to the San Francisco Civil Grand Jury.
Thank you. Again, I would like to remind the task force that it's very difficult if we spend many hours on the orders of determination. I understand we want to give it a thorough vetting, but we've already heard these a number of times, and when, just to recap, our order of determination is requesting that the Controller's Office and the Ethics Commission turn over some redacted correspondence, and before the Compliance and Amendments Commission, it was pretty straightforward. The Ethics Commission and the Controller's Office say that all documents, no matter what, are confidential, and they won't turn over anything, no matter what. And that, in fact, even the information of whether or not an investigation has been open or closed or is going forward or is anything is confidential. That's their stance. The complainant is present. You'll have 5 minutes.
Thank you, Ms. Johnson. I appreciate it. I would like to compliment the members of the Compliance Committee who determined that even if the charter provisions that the Ethics and Controller's Office relied on were applicable, under CIPRA, investigative files at Ethics are not exempt from disclosure. I think the Compliance Committee understood that the confidentiality provision on which the Ethics Commission relied in Charter Section C3.699 only applies to investigations, and then only to investigations relating to campaign finance, lobbying, conflicts of interest, and government ethics, which Mr. St. Croix must surely know. As you know, and as the Compliance Committee knows, the CIPRA, or if you were to review the provisions of CIPRA that call for confidentiality of particular public records. The only one with any possible relevance to the public records involved is subsection 6254F. But 6254F. But subdivision F of 6254 is likewise inapplicable because it doesn't compile investigatory files for correctional law enforcement or licensing purposes. And the Compliance Committee understood that Mr. St. Croix is not the CHP, he's not the police, he's not the sheriff. I think the Compliance Committee understood that the investigations of the Ethics Commission, particularly those related to violations of open government law, do not rise to the level of traditional criminal law enforcement investigations. Thus, the confidentiality that the Ethics Commission seeks to invoke is not permitted by law, and the Compliance Committee agreed with the order of determination. The Compliance Committee got it that official information based on assurances of confidentiality are insufficient to justify withholding pertinent public information from the public. That's San Gabriel Valley Tribune versus Superior Court, a California statute. You'll notice in Mr. Threed's instructional memo that came out really late yesterday, almost by design, incorporated foreign jurisdictions citations. What has Arizona law got to do in California? What has Wisconsin law got to do in California? Were those citations raised to help the defendants or to give you any kind of meaningful guidance? I urge you not to subtract Member Costa, but merely to add to the recommendation that's coming to you from your Compliance Committee. They gave you very precise wording, even though they dropped, including the Attorney General, which had been mentioned in the motion that had been made to adopt it. So I urge you to unanimously adopt the Compliance Committee's recommendation as it was written, or if you want to add something to it. And as Chair Johnson reminds you, do not adjudicate this again. Do not let the respondents attempt to come up here as they did at compliance and try to adjudicate, re-adjudicate, and introduce new information. Please support your Compliance Committee and their recommendation.
Thank you. Point of order, Mr. Manette Shah, can you please just yes or no, did you receive any additional information from Ethics or a Controller's Office since the Compliance and Amendments Committee?
No, they remain quite stubborn.
Thank you. Is there anybody to present facts and evidence in support of the complainant? Seeing none, are the respondents present? No comment from the Controller's Office. Mr. St. Croix, you have 5 minutes if you are.
Sorry, I have nothing to add to our prior statements or correspondence.
Thank you. Is there anybody in the audience to submit facts and evidence in support of the respondents? Seeing none, the matter is with the task force. Member Washburn?
I didn't bring my notes with me from our meeting, compliance and amendments. Do any of the others of you remember whether we included the AG?
We did not. The only reason I remember that is because Mr. Grossman got up and very distinctly asked us why, what we would have it referred to as the district attorney. versus the Attorney General.
Okay.
I know we had discussions about it.
We decided not to include the AG. Okay. Well, then I move that we adopt the recommendation of compliance and amendments and forward this matter to the controller, or to the controller's office. Oh, excuse me, I'm sorry, the district attorney and the ethics commission, and also send a copy of the referral letter to the civil grand jury that's been investigating the ethics commission.
Seconded.
Do we want to add, as Member Snyder did the last time, that based on the facts and evidence and the order of determination?
Yes.
Member Snyder?
And this may be obvious in the motion, but I think it's important that we specify that we're going to forward the order of determination along with any letter of referral. In other words, attach the order of determination that we're talking about.
Is that, I'm sorry, is that normal procedure, Mr. Clerk, to attach the order of determination when you refer it?
Yes, Madam Chair, it is.
Thank you. Is there any discussion on the motion? Seeing none, is there any public comment on the motion? The motion is to accept the referral of the Compliance and Amendments Committee and refer the Controller and the Ethics Commission. It's
Okay, no, I see the motion. No, now I understand. And yes, I do have a comment on it. My comment is, let's say all this happens, and you do refer it to the Ethics Commission, and you refer it to all these people, and nothing comes of it. In the future, when you have an order of determination and shove it up to ethics, will Mr. St. Croix recuse himself because he's been, accused of this, even if the other side doesn't do anything, that you send it up to, if they decide to sit on it? I'm wondering about character, and at what point character, makes people have to recuse themselves from hearing things. And from what I'm seeing here, we're having a lot of doubts about his character and, other people's character. And if these are the people in charge of the Ethics Commission, it just stands to reason that, if we're questioning their character and we're having to send it up, and if we send them stuff in the future, well, how can they even make a decision if we don't trust their character? Just thought I'd ask the question.
I think this is probably one of the most important cases that has come before the task force in at least the years that I've been appearing, because what it brings into focus are a couple of things. It brings into focus the views of the staff of the Ethics Commission, supported by the city attorney, which are in direct contrast to the views of the task force on some of these issues. And it also illustrates the confusion, I think, that the executive director of the commission has between the role of the staff and the responsibilities of an executive director to the commission as a whole. I don't honestly see how the Ethics Commission can hear this case. There are two elements to it. There's the enforcement element of a violation, which is being sent to them under 6730C, and then there is the finding of official misconduct for which they have no rules, and which is not a dismissible matter by the staff. It can only be heard. It cannot be dismissed by the staff. So I would expect that it's going to get sent out, and it's important that the task force monitor that as best it can and see what happens. But I really think this is a critical case for the future, not only of the task force, but for the Ethics Commission and its responsibility to the community and the citizens of the city. Thank you.
Thank you.
Good evening. I'm Dr. Maria Rivero. I'm one of the two whistleblowers that was involved in the case that you all are hearing. And I wanted to thank you guys for not only striking a chord for open government, but also what happened here is an injustice. There was an injustice to the patients at Laguna Honda. That was the number one injustice. And then a secondary injustice of having two long-term physician employees of the city now no longer able to work for the city because of retaliation. Our experience with the situation has been that what happens is that these high-level officials, such as the two folks that are being named here, Ms. Lettigiou and Mr. St. Croix, have no downside to going along with things, even if they know it's wrong. We saw that with the administration of Laguna Honda as well. If you don't go along with it, you lose your job and you lose your position. And if you do go along with the wrongdoing, then what happens is you get promoted, maybe, but you definitely get to keep your job. And that just is not acceptable. Thank you very much.
Thank you. Is there additional public comment?
Yeah, if there was an issue whether or not the Compliance Committee made the recommendation to refer this to the Attorney General, it seems that you have the minutes on your agenda tonight, looks like, item 33. If that was the Compliance Committee, was that the July 12th? No?
Yeah. Yes.
It was June or June?
July 12th.
July. Okay, so you have the minutes attached to your packet as to what the Compliance Committee recommended, which brings up another interesting issue regarding keeping minutes. But in your packet, you have the minutes. So I do recall, though, there being some discussion about referring this matter also to the Attorney General. But the minutes speak for themselves. They're exactly as given. Thank you.
Is there additional public comment?
Yeah, it seems that the systemic violation of the rules and the procedures in the city have to be also placed at the foot of the mayor of San Francisco. And since you say that you, as a commission, should place it before appropriate bodies, I think you should send it to the mayor of San Francisco. The mayor has the authority to remove these people from their positions as managers and as chairs of commissions if they're not doing their job. They have the authority to do that. It's a management decision. It's the mayor's decision. And I think it's appropriate to put it on the mayor. What is the mayor doing about it? If they violate the ethics, if they violate the rules, is the mayor going to take any action? Thank you.
Thank you. Is there additional public comment on the motion? Seeing none, public comment is closed. Is there any further discussion among the task force? Mr. Clerk, will you call roll on the motion to refer to... Oh, I'm sorry. I apologize. I'm sorry. I have to ask the respondents first. Do you have anything to add? Thank you. Let the record show that both the controller and Ms. Lettigiou and Mr. St. Croix from the Ethics Commission denied their opportunity to rebut. The complainant will have 5 minutes.
3 minutes.
I'm sorry, 3 minutes.
Thank you, Chair. I hate to be such a stickler on process here.
It's my first time chairing, so thank you for your assistance.
Not on you personally, just, in general. So Dr. Maria's Rivero's comments break my heart. Bob Neal used to be president of the resident council at Laguna Honda. He passed away. Sister Miriam Walsh served Laguna Honda for 20 to 30 years. She's passed away. I think they are outraged what happened with the patient gift fund, and that it took Ms. Lettigiou's staff 9 months of delay before they would even lift a finger to look under the rug to find where that $350,000 went. There's more. The audit period was artificially manipulated. Where's the balance of maybe $750,000 that went missing? How long is it going to take to get to that part of this scandal? It's already taken 7 months to get here. I started this records request in January. It's now July. I absolutely commend Mr. Seltzer for recommending that you add something to your motion before you take a vote. He's right. The mayor can remove both of these high-level officials and should. To the extent that Jewel Gomez was rude to a member of this body pales in the comparison to the elder financial abuse in which senior officials at Laguna Honda thought that they could simply change the administrative code, start siphoning money out of private donations to patients to fatten the gizzards of staff. The mayor should hear from you. The mayor should hear your outrage over what was done and why it has taken 2 years to get to this point. Whether St. Croix has the chutzpah to recuse himself isn't the issue. The issue is that you need to amend your motion and bring it to Mayor Lee's attention. If he wants to run for mayor, he should have the balls to do something about this.
Thank you. Does anybody support the complainant with facts and evidence? No. No. All right. Is there any more discussion among the task force? No. We did public comment on the motion. We did it. Mr. Clerk, will you please call the motion? Please call roll on the motion. Member Washburn?
I'd just like to hear a little discussion about the idea of sending this to the mayor's office. I don't know whether, Bruce?
Just a point of order. Just a point of order that we not discuss it unless somebody makes a motion. Then you have the opportunity to have the discussion about it. Otherwise, I would just say either make the motion so we can talk about it, vote it up or vote it down, or keep it rolling.
Well, then I'd like to make a friendly amendment to the original motion that I made, I believe, to also refer this matter to the mayor's office, with a letter to the mayor's office.
Who was the second?
I'll second.
Agree.
Yeah, I'll agree.
Is there any discussion on the motion? Is there any public comment on the motion to add the mayor to the referrals?
Actually, there is. I've had a very interesting experience with Mr. Lee, not as mayor, but as city administrator. A while ago, went to go apply for Healthy San Francisco. I'm unfortunately a person who doesn't have any health care. You know, I haven't been denied health care at Tom Waddell, haven't been denied health care at Haight-Ashbury Free Medical Clinic. An oxymoron, I understand, but, you know. I was also denied Healthy San Francisco. When I was denied Healthy San Francisco, Mr. Lee was the city administrator, and I followed the correct procedure to appeal my denial of Healthy San Francisco up to Mr. Lee, the city administrator, and I was told by his secretary, Olga Ryson, I believe, that they don't take complaints. And I said, well, let me see if I've got this right. If you don't take complaints, then how can you fix a problem? well, we never have received a complaint, so we don't take complaints. And so I was stymied. It left a very bad taste in my mouth about Mr. Lee's capabilities as far as doing what he's told, being a toady, all these other things, no problem. As far as doing what's right and all these other things, in my opinion, by the way I was handled by his office, which of course, you know, never receives complaints, so that there isn't a reason to fix or to correct anything, really leaves a lot of suspicion in my mind about whether this mayor is even competent at this particular point in time for this referral.
Thank you. Is there additional public comment on the motion?
Yeah, Thomas Piccarello. It might be wise by the task force to get an opinion from the city attorney, if you can, since it's not on your agenda, sending a letter to the mayor, whether it's appropriate that you could do this without agendizing what you're now making the motion for. Thank you.
Is there additional public comment on the motion? Seeing none, public comment is closed. The matter is back with the task force. Mr. Clerk, please call the roll on the motion. And this is with the amendment to add the mayor.
On the motion, Member Snyder?
Aye.
Snyder, aye. Member Cawthon?
Aye.
Cawthon, aye. Member Manny?
Aye.
Manny, aye. Member Washburn?
Aye.
Washburn, aye. Member Knebber? I'm sorry. Member Costa?
Aye.
Costa, aye. Member Wolf?
Aye.
Wolf, aye. Member Chan? Chan, aye. Member West?
Aye.
West, aye. Member Johnson?
Aye.
Johnson, aye. Madam Chair, we have 9 ayes. The motion passes.
Thank you. Before we go on to the next item, out of fairness to all of the complainants and everybody who's here, I really urge people to limit their comments, not in time, but in scope of exactly what we are talking about. That there's a lot of people here, and we have a huge agenda, and we've gone on way too long. So I really urge you, and I'm going to start to really kind of respect that rule a little more, that you have your 3 minutes and your 5 minutes, but you really need to focus on either just the motion or whatever it is that we are actually talking about at that moment. Mr. Clerk, can you please read item 3?
Yes, Madam Chair. Item number 3 is the Compliance and Amendments Committee has recommended that John St. Croix of the Ethics Commission be found in willful violation and official misconduct for failure to comply with the order of determination in file number 11014 Patrick Monet Shaw against the Ethics Commission, and the matter be forwarded to the District Attorney and the Ethics Commission for enforcement, and a copy of the referral letter to be sent to the San Francisco Civil Grand Jury.
The complainant will have 5 minutes.
Thank you. I deeply appreciate your vote on 113 because there are so many related issues in 114. I'm not going to belabor my points here. Other than to
Can you please speak into the microphone? Thank you.
Other than to remind you that someone who's invited me to join them on LinkedIn just tried to scuttle a very important key point of this, of referring the matter, even administratively, to the mayor. I don't appreciate that. And you certainly do not need to put it on an agenda that you're going to consider referral to other bodies than what you've put on the agenda. That's nonsense. It's pure nonsense. Complete waste of testimony. I hope you will, again, add and pass what your compliance committee deliberated over, because it's high time in this town that John St. Croix be found before be referred to his own commission, where Mr. Grossman has made it very clear. This time, Mr. St. Croix is not going to be able to dismiss this administratively, and he's going to have to put it in front of his commission, where they will have to take a vote on whether to hear the matter themselves or refer it to another jurisdiction, as Mr. Herrera has set precedent. This time, Mr. St. Croix doesn't get to wiggle out of it. And this time, to keep him from wiggling out of it, I hope you will give me another unanimous vote.
Thank you. Is there anybody to present facts and evidence in support of the complainant? Seeing none, the respondent will have 5 minutes. Let the record reflect that Mr. St. Croix has denied his opportunity for 5 minutes. Is there anybody in the audience to present facts and evidence in support of the respondent? Seeing none, the matter is with the task force.
And do we need a motion?
Yes.
Do we
Yes.
need a motion?
Yes.
I move we accept the recommendation of the Compliance and Amendments Committee.
Second.
Is there any further discussion? Is there any public comment on the motion? Seeing none, the respondent and then the complainant will have 3 minutes. Again, the respondent does not wish to speak. Let the record reflect. Mr. St. Croix is in the audience. And the complainant will have 3 minutes.
I hope
Perfect.
you will take administrative note that the respondents in both 113 and 114 couldn't respond. They know what they did, what they have done withholding those records to date is wrong. They know that they're guilty of willful failure. You have found them to have engaged in official misconduct. Member Coffin, I would like you to consider, along with your peers on this body, that it's going to look pretty silly referring 113 additionally to the mayor, but not 114? Can that stand, that half of the case goes to the mayor and Mr. St. Croix walks away without having to face his boss? How can that be? When this goes back to discussion of this body, I beg one of you to reach into your ethical core. I'm not talking morals. I'm not talking the right thing to do. I'm talking your ethical core. And introduce a motion that both 113 and 114 be referred to the mayor. Anything less would send absolutely the wrong signal. Thank you.
Thank you. The matter is back with the task force. Member Cawthon?
You know, I have no objection to amending the motion to add the mayor. I think the mayor should be hearing more about the kinds of things we are doing and what our recommendations are.
Is that a motion to add?
It's an amendment
Amendment?
to my own motion.
Second, accept?
I agree, yeah.
Is there any additional discussion? Is there any public comment on the amendment to add the mayor?
Will there be general public comment afterwards? I mean, because yes, I want to make a comment, but I want to do it at the right time. Is this only
I'm
on the
sorry, I'm
motion,
not-
or will there be
this is-
general public comment about this case?
It's public comment on the amendment.
But so there'll be public comment on the case later. Okay. I want to be.
There,
Dr. Derek Kerr.
didn't we just?
I'm
I'm sorry, sir. Go ahead.
Dr. Derek Kerr. I'm in favor of the amendment. Mayor Lee was the original administrator of the whistleblower program, so this would be relevant to him. Also, I wanted to add that Dr. Maria Rivero and I were the original whistleblowers on the gift fund, the Laguna Honda gift fund, which is the core of this sunshine issue. And we're 100% in support of Mr. Monette Shaw's issue with this gift fund problem. Thank you.
Thank you. Is there any additional public comment on the amendment to add the mayor?
I think I need to make one correction. The executive director of the commission is appointed and removed by the commission, not by the mayor. So if the idea is that maybe the mayor might remove Mr. St. Croix once he receives the letter, I'm not sure that would happen. The mayor can remove his appointee to the commission, and that may be appropriate, leverage. I do want to mention one thing that I think I'll hold it. Thank you.
Thank you.
Members of the task force, Ray Hartz, Director, San Francisco Open Government, and I agree with the amendment. I support it strongly. I think one of the problems is that if we only refer a few things to the mayor, he may not get the impression that you get sitting in these meetings that there are a lot of city agencies and departments who are flagrantly in violation of sunshine, and a lot of boards and commissions who flagrantly violate it in denying public comment and things like that. And unless these things go to the mayor, and the mayor sort of sees, wait a minute, I wouldn't have thought this was a problem because I only see one or two of these every so often, and now I'm starting to see 5 or 6 or 7 a year. It has to give him a heads up, and he has to realize that as the major runner of this city, all of the department heads report to him. And it is his responsibility to ensure all the departments and all the department heads are complying with sunshine. And unfortunately, what happens is a lot of times these get referred back to the department, and it is in their best interest to keep it quiet, to make it so silently disappear. And if it starts to come out, then maybe the mayor will take a little board of a stand and say, we have a commission out there, they have a job, they're spending a lot of time and energy doing it. They certainly don't deserve the negative comments from the city attorney and his representatives, and they certainly deserve the support in getting this law to work in the city. But the only person who has the power to do that citywide is the mayor.
Is there any additional public comment? Mr. Threet? There's already been public comment on the full motion, but we amended it, Mr. Threet. Does that mean we have to have it with the full motion and the amendment? I would have done it the other way. So public comment on just the amendment is closed. We've accepted the amendment. So now we don't have to vote on it.
Didn't we have public comment on the motion? We did have public comment.
The problem is what happened is that we made the amendment and the second accepted it, so we don't have to vote on it. So we should have had a motion. We should have had public comment on the motion as amended, but we did not.
The confusion is if you're going to make a friendly amendment, then you got to use the word friendly, okay? Because friendly amendments have a certain procedure. If you're going to make an official amendment, then let's say it's something that drastically changes the motion, that has to go through the same procedure as any other motion. Once the amendment has been approved, if approved, or not approved, then you have the final motion, either changed or unchanged, and then you have your final public comment on that.
But it was final because it was the maker of the motion and the second that accepted.
I know, but then you proceed to amendment.
I understand, but now in light of the fact that there are people who want to speak on the full motion, I'm going to open public comment for the motion as amended, adding the mayor.
I'm I'm so confused at this point, I don't know, so I'm just going to make my comment and hope it's at the appropriate place. Unfortunately, you know, these two cases involve Mr. St. Croix. And I believe I have in my hand case 10038 that was submitted to the Ethics Commission. So I guess this makes 15 out of 15 that have been sent up to the
Sir,
Ethics
I'm going to
Commission?
limit public comment to the motion. Are you addressing the motion to
Well,
add?
that was my question. So this
something?
isn't general public comment on this thing?
This isn't a case. It's just about the order of determination. So all we're going to have is a motion of whether to enforce it or not. So I don't want to limit your.
Public comment, period, general public comment. I thought they had. Okay, I'm asking. I want to do it correct.
Sorry for the confusion. The matter's back with the task force. Is there any discussion?
Call the question.
Mr. Clerk, can you please call roll on the motion with, as amended, to add the mayor?
Yes, Madam Chair. Member Snyder?
Yes.
Snyder, aye. Member Cawthon?
Aye.
Cawthon, aye. Member Manny?
Aye.
Manny, aye. Member Washburn?
Aye.
Washburn, aye. Member Costa?
Aye.
Costa, aye. Member Wolf?
Aye.
Wolf, aye. Member Chan? Aye. Chan, aye. Member West?
Aye.
West, aye. Member Johnson?
Aye.
Johnson, aye. Madam Chair, we have 9 ayes. The motion passes.
9-0.
9-0. That was the mistake. Can you please call item number 4?
Item number 4 is the Compliance and Amendments Committee has recommended that Karen Xelea of the San Francisco Municipal Transportation Agency be referred to the Ethics Commission for failure to comply with the order of determination in file number 11016, addresses and errors against the SFMTA, and for assistance in the production of records that Mr. Cisneros seeks.
Are the complainant and respondent present? Is the respondent present? The complainant will have 5 minutes. The record will reflect that the respondent is not present.
Thank you, task force members. First, for giving me an order of determination, which they did not follow. Okay, first let me address the letter that was dated June 13th from the MTA to the Sunshine Task Force regarding the order determination.
Mr. Cisneros, we went through all of this at the Compliance and Amendments Committee, so it would really be helpful if you would address whether or not you've received any documents.
I received nothing.
Okay, then proceed.
Where do we go as far as from here, from this point of the Sunshine proceedings, as far as the SFMTA, because they failed not to even adhere to the Sunshine Ordinance, nor do they care to even be in here after you summons them. And it seems like any type of employee of the city and county of San Francisco which invokes the Sunshine Ordinance is later dismissed from their duties. As a 9163 transit operator, there's many other transit operators that you will see in coming weeks up for dismissal for invoking this ordinance. If the task force, if it's good with the task force, I could give you the order of dismissal regarding me. There's 3 others that you'll hear tonight also. Whenever we invoke this ordinance, we get dismissed. There's no transparency in city government anymore. I never thought that I would have or be dealt with this way in a public sector, and I've worked private and public sector. This is the worst I've ever had in my life. There has to be some type of justice here for the employee. Management and city officials, they can't keep on putting the blame on the low man on the totem pole. It just, it kills me. At this point, I don't know where the task force can point me to or give me some type of justice in this matter. But as you see, the SFMTA is not here. They're in transitional period, nor do they care. Thank you for your time.
Mr. Cisneros, did you say you had a letter of dismissal?
Yes. I could
was-
give it to the task force. If they like, I made copies.
What's the date on it?
July 20th.
Yep, thank you.
Would you like copies just to pass out?
I don't know, does the task force need a copy? Are you? That's okay, thank you. Is there anybody in the audience to present facts and evidence in support of the complainant? You have 3 minutes.
Good evening, Task Force. My name is Dorian Maxwell. I'm too up for dismissal for coming before this panel. Not only once, but twice. The SFMTA has to be held accountable. You see they have any lack of respect for this ordinance, and they're not even present in this room. I really don't know where to start. I think that Ms. Elia, along as the whole MTA staff, need to be referred to the Ethics Commission, as well as the mayor, and as well as the Department of Justice, to have or the civil grand jury to investigate the business practices that goes on within the SFMTA. That's all I have to say.
Thank you. Again, is the respondent present? The respondent is not present. Is anybody in the audience here to present facts and evidence in support of the respondent?
Yes, Steve Zeltzer, United Public Workers for Action. This is an outrage.
Are you speaking on behalf of
I'm
the
speaking on
muni?
behalf of the complainant. No,
But
I'm not
we-
speaking. The union should be here.
We've already closed the
you've closed the-
discussion, but
okay.
feel free to, we'll have public
You'll have
comment
public-
on what's going on. Sorry about that. Is there anybody in the audience to speak on behalf of the respondent? Seeing none, the matter is with the task force. Member Cawthon?
Did the respondents say they weren't coming, or did they indicate why they were not coming?
Mr. Rustem?
Through the chair, I did not receive any correspondence from the agency.
Thank you. Did you notify them?
I notified them on Friday afternoon.
Thank you.
Well, I think that we any motion that we have, we should add a violation of 67.21E, failure to send a knowledgeable representative.
Well, we have, that would just be one.
What's that?
Is there a motion?
I'll make a motion. I move that we accept the recommendation of the Compliance and Amendments Committee, that this be referred to the Ethics Commission for failure to comply with the order of determination, and add a violation of 67.21E in addition for failure to send a knowledgeable representative.
Second.
Is there any discussion on the motion? Member Wolf?
Yeah, just for the maker, with regards to referral to the Ethics Commission, the recommendation was to a specific person. It was to Carolyn Celaya of SFMTA, and that if we're sending it to the Ethics Commission, is that for any specific? Is it just in general we're sending it the item, or are we sending it for her violation, like of willful failure?
I don't know if we have to be that specific. I'm just recommending that we accept the recommendations of the Compliance and Amendments Committee, and in addition, add failure to send a knowledgeable representative. So, you know, I'd like to do it in a generic manner just so that we can move the agenda. I don't know that it's necessary to restate what we say in the referral, but if somebody wants to do that, that's fine with me.
DCA 3.
Through the chair, because the referral itself in the agenda item mentions Ms. Celaya, if you simply, the motion is to accept the recommendation that, and it would include Ms. Celaya as part of the referral.
My concern is that usually when we send items to the Ethics Commission, we state specifically if it's for willful, usually that it's for willful failure. And that's not what I heard in this motion. I was just questioning the maker if that was her intention, to include or not to include willful failure, because the direction of this action is going to the Ethics Commission.
My motion was to accept the recommendation of the Compliance and Amendments Committee, which speaks for itself.
DCA 3.
Through the chair, the agenda item doesn't say willful failure. It says for failure to comply, which is less than willful failure.
Okay.
So if the task force would like it to read willful failure, you will need to include that in the motion.
I'm willing to do that.
You mean willful failure for, you're asking her to add 6730.34?
I'm not asking him. I was just questioning what her intention was in making the motion, since the direction of it is going to the Ethics Commission. Usually the task force, when it sends items, orders of determination to the Ethics Commission, it's for willful failure. If we have the opportunity to send any item to the Ethics Commission, this one didn't state for willful failure. I'm just questioning the maker what the intention is.
Okay, I understand.
My intention is to accept the recommendation of the Compliance and Amendments Committee, which spoke to failure to comply with the order of determination, and also for assistance in the production of the records Mr. Cisneros wants. So that's my motion. I'm happy to add willful failure to the language.
Member Washburn.
I'm reviewing the minutes from our July 12th meeting, and there was some discussion about whether or not we wanted to include willful, and apparently we decided not to. So I would defer to what we decided at that meeting, because we had a full hearing and deliberated about that.
Well, I think that the referral of willful is for tonight's not appearing. Is that why you wanted to add 6721E, Member Cawthon? Because they did not appear this evening?
Yes, 67.21E, to add that to the recommendation of the Compliance and Amendments Committee.
Is there public comment on the motion? The motion is to accept the referral to the Ethics Commission of Carolyn Celaya and add 67.21E for failure to appear tonight.
Yeah, Steve Zeltzer, United Public Workers for Action. I think, again, it seems like, you know, complaint after complaint, there's willful disregard of this commission, refusal to respond. And in the case of the MTA, there seems to be systemic retaliation against employees, not only who file complaints with this commission, but file complaints with Cal OSHA over the state of the buses, the health and safety of the buses. This is a serious issue. It's not just these employees; it's the health and safety of people of the city, the public who use the transit system. So I think that there has to be some accountability, and I agree that these officials, who are paid by the people of San Francisco to be responsible to the public, have to show up here. I mean, we pay their salaries. They don't have the time to come to this hearing and respond one way or the other? I mean, it shows contempt for the city and the people of San Francisco who pay their salaries. That's part of their job. I would say that, yes, you should pass this amendment and also send it on to the mayor. And also there should be an investigation if city employees are being retaliated against for making complaints to this commission. Because what does that mean? That means keep your mouth shut. If there's a violation of the rules of the city, don't say anything. Don't tell anybody, because you'll be retaliated against. It's a reign of terror for the public workers of San Francisco. That's what we're seeing here tonight. And that has to stop, and it will stop, because it's not just one person. It's one person after another who's saying this. Doctors, others who are saying this. This is a scandal. And this has to be brought to the attention to the mayor, Mayor Ed Lee, and to all the candidates in San Francisco that this is unacceptable. Thank you.
My name is David Reardon. I'm a San Francisco resident, born and reared here, and a Muni driver. And I want to support the motion to bring this to the Ethics Commission and tell you that I personally perceive unethical behavior on the part of most levels of supervision that I've dealt with, breaking the rules, being dishonest, retaliation, as Mr. Zeltzer said. I myself had to go all the way to arbitration to protect my job because I was trying to follow the rules and I was attacked by my superintendent. And also, our trust fund has been stolen from us.
Please limit your comments to the motion.
Oh, I was just speaking about ethical behavior. I was just pointing out.
I understand.
Okay,
I
that's
apologize.
Fine. That's
But
okay.
we-
I'm just here to say, yes, that's appropriate, and there is rampant unethical behavior on the part of SFMTA management.
If you want to address the absence of a representative from the MTA with a willful failure, you might pick the person who runs the MTA. You can't get the commission as a whole if they have one, but you certainly get the executive director or the whoever is the responsible executive for its operations and administration. So you can either direct it that way along with a specific one against Carolyn Saleha, and I think you will have it. Thank you.
Thank you.
Ray Hartz, Director, San Francisco Open Government. I strongly support the motion. I do want to posit another reason for them not coming, and I think it's one that is probably more common than we would like to admit, and that is not necessarily contempt of you or what you do, but a simple acknowledgement that what they've done is wrong. They have no excuse for it and no way of wheedling their way out of it. So their final response is, I won't go, because that's just going to be that much more embarrassing. I think any of you who saw the Ethics Commission hearing with Jewel Gomez, she basically got up and slit her own throat by they've just finished playing the thing where Ms. Coffin was shouted down, and Ms. Gomez got up and said, "Oh, I was being abused. I felt I was being abused." And I'm thinking, if any reasonable person looked at that, I don't think they would think you were being abused. I think it would be the other way around. So I think, unfortunately, the reason the SFTA may not be here is a simple acknowledgement of their inability to present any sort of a reasonable justification for their actions.
My name is Michael J. Bernardo. I'm also a Muni operator, and I also would like to speak in support of Mr. Cisneros. This constant firing has got to stop. This is a union town in
I'm sorry,
San
sir.
Francisco.
Can you please limit your comments to the motion?
Yes, because of the fact that you can't keep allowing them to fire people. This is not Alabama. This has to stop. And if these department heads don't like it, they could get the hell out of my town. I'm tired of it. Thank you.
Thank you.
Okay, well, maybe this is the appropriate place for me to present this. This is in concern to the fact that you'll be sending this up to the Ethics Commission for failure to comply. I think that's the motion, so I guess I can talk about it. once again, my case, 10038 was sent up to the Ethics Commission, and this must be 15 out of 15 times that they have failed. And if I remember correctly, you guys were supposed to issue new regulations for the Ethics Commissions to start enforcing your thing. So if you were to refer this up, my God, they failed 15 out of 15 last times, and you haven't had any new regulations, so why should they not fail again? So, given the fact that they'll probably fail again, isn't it once again leading off with false hope? Just thought I'd ask the question.
Thank you. Is there additional public comment on the motion? Seeing none, the motion, we're back with the task force. Is there additional discussion? Member Costa?
The one question is that raised by Mr. Grossman about whether or not the failure to send knowledgeable representatives should be directed at a specific individual. I don't know if we want to discuss that any further.
I'm sorry, I didn't hear what you said.
Oh, sorry.
It
Whether
should be
the
directed to who?
should be directed to a specific individual rather than the agency as a whole.
Well, I think Mr. Grossman was saying that you could pick a department head, which we're not doing it as we were going to. It would be Carolyn Celaya that we would be directing it to. Now, I will caution the task force, and perhaps the complainant may weigh in, but if we do name a different person, it's been our practice in the past to put that on an agenda so that they have an opportunity to appear. So that portion of it, we may, if you would like to do that, we would potentially separate it out, or we would otherwise, if you combine them all, potentially have to continue it to the next meeting, because we would have to give that particular person an opportunity for due process to appear before us.
I would like to move this motion. I think that MTA has, there are a couple of MTA matters on here, maybe even 3, and I really think it's inappropriate for them not to show and not even to call or respond to Mr. Rustum. So I would like to call the question. If anyone wants to amend this, and then that would be a separate issue.
Mr. Rustum, will you call the motion as it stands?
On the motion, Member Snyder?
Yes.
Snyder, aye. Member Cawthon?
Yes.
Cawthon, aye. Member Manny?
Aye.
Manny, aye. Member Washburn?
Aye.
Washburn, aye. Member Costa?
Aye.
Costa, aye. Member Wolf?
Aye.
Wolf, aye. Member Chan? Chan, absent. Member West?
Aye.
West, aye. Member Johnson?
Aye.
Johnson, aye. Madam Chair, we have 8 ayes. The motion passes.
The motion passes, and the order of determination will be referred to the Ethics Commission as recommended by the Compliance and Amendments Committee, as well as adding 6721E for willful violation, not willful, for violation of not sending a knowledgeable representative. Before we call items 5 and 6, is there a representative from Supervisor Kim's office and a representative from Supervisor Farrell's office here? Only Supervisor Kim? Okay, Mr. Clerk, will you please call 5 and 6 together, because the Compliance and Amendments Committee had recommendation was a letter combined of both.
Okay, Madam Chair, the Compliance and Amendments Committee has recommended that the task force send a letter to members of the Board of Supervisors regarding email retention in file number 11028, Charles Spitz, and against Supervisor Jane Kim, and file number 11030, Charles Spitz, against Supervisor Mark Farrell, and also to remind them of their obligations under Section 67.21C.
The complainant will have 5 minutes.
Yeah, I think I just have several problems with this amendment. One, when I did look at the documents from the city clerk, it just proved that there was several documents missing. You know, I filed 5 letters of recommendation, and I can only find 1. Then they say there's letters about my conduct that they didn't like. I can't find any of them. You know, and then you look at other documents, you know, they're like Sean, sort of out of point, but they sent emails to everybody. They didn't send them just to one person. So it's just the wrong document. And furthermore, I would like the person from Jane Kim's office to prove that they sent me anything other than that big stack of emails after the hearing. You know, they lost in the hearing, and then they don't say nothing to me. You know, the SRO meeting that I went to go apply for, they just pretty much said like I was invalid as a human. They definitely implied that, and they just, no, this is the wrong motion. And what makes it worse is you're gonna send this motion to their peers, which probably do the same types of things, if not worse. And they're probably just going to throw this in the trash as soon as they get it, and nothing is going to be happening. And I still am not going to get the documents that are probably floating around somewhere, you know, because in my SRO appointment, there were documents. There was one document that I submitted that was in that file that wasn't in the file for the Shelter Monitoring Committee. So the documents are floating around somewhere, and chances are I'm not going to ever see them. You know, she says there is something is wrong. I'm not getting information I'm looking for, and I want to hear what he got to say.
Okay, Mr. Pitts, I just want to let you know that Mark Farrell's aide did arrive as you were speaking.
Hopefully he's got some documents for me. You got any documents for me? Hope? Did you say hope?
Is there anybody in the audience to present facts and evidence in support of the complainant? Seeing none, while I called the two cases together because there's just one aide here, but the letter was intended to go out from the Compliance and Amendments Committee in combination. Well, the respondents will have 5 minutes. If you need a little bit of extra time because there are two of you, we can accommodate that.
Hi, good evening. Catherine Stephanie, Legislative Aide to Supervisor Mark Farrell. And since I appeared at the Compliance Committee, I just want to know what exactly you would like to hear from me again tonight. I think it would help better inform my comments. As I stated at the last hearing on this, we turned over everything that we had. I explained our process. I did let you know that we were late, and we have corrected that. We have a new staff person that missed it by a day, so I think actually a day and a half. So I don't know. I'm unclear as to what exactly you would like me to explain. Is it the same thing that we've gone over at the last hearing, or is it to provide input on perhaps the letter in response to Mr. Pitts about where the documents, as I stated, the clerk is the official, the clerk of the Rules Committee is official holder of all the documents. They're still there. The file is still there, and he's more than welcome to approach the clerk's office for those documents. As I stated at the last hearing, I'd be more than happy to help him in that regard, but we do not have anything additional because we turned over everything that we had. So if you have any questions for me, I would really love to be able to provide any kind of help in this regard and help you form what type of letter you might be writing to the clerk of the board for that matter.
We might have questions, but it might be after. Did you want to add anything? You're attaching your comments to hers. Is there anybody in the audience to present facts and evidence in support of the respondents? Seeing none, the matter is with the task force. Member Wolf, I would just like to say one quick thing to Ms. Stephanie, and that is that at our last, at the compliance, we made this recommendation based on the fact that the order of determination, there was some confusion about your retention policy, that there was a problem, exactly as it reads here on the agenda. So that is what we're trying to, they've made a recommendation that this is what we do, so that's what we're speaking to. If that clarifies perhaps Member Wolf can clarify it even further with his comments.
So as with these two and the previous four items on the agenda, these are just recommendations for how the task force should dispose of the order of determination. What level of enforcement, who it should go to. It's already been determined that there was a violation that is now cannot be contested. And so once the violation has been made by the task force and it's been ordered or referred to a committee for compliance, if compliance has not been made at that point and not satisfied by that committee, then the committee makes a recommendation. It either makes a recommendation to say nothing more to do with this, and it goes away, or and it's solved or completed or what have you, or it comes back with a recommendation for some specific action. So if there was an order of determination to produce a document, and after we have found in violation, the documents were not provided for within 5 days of that order of determination, then that person is indefinitely in violation, and then there has to be some disposition for that. So here, the recommendation of the Compliance and Amendments Committee was to send a letter to all the members of the Board of Supervisors regarding the email retention regarding email retention in their policy, and to remind them of their obligations under 6721C. That is the recommendation from the Compliance and Amendments Committee. That is what I suppose somebody is going to make a motion about, and so that's what we're here for. So if you're confused or not sure what you're supposed to be commenting on, your comments would be related specifically to that that context. And that's for in the future, for any item that comes back from a committee with a recommendation.
And so you found us in violation of not turning over documents?
In this recommendation does not find violation.
The order of determination did, though.
The order of determination did. But the recommendation from the Compliance and Amendments Committee was to send a letter to this is how we're going to dispose of it. Okay, we're going to send a letter to the Board of Supervisors, all the members of the Board of Supervisors. That's how we're going to dispose of it. In other cases, you've heard that we've sent it to the Ethics Commission or we send things to the mayor or what have you. This is how the Compliance and Amendments Committee has determined the best, or it in its wisdom, to be the way it wants to.
To clarify it, though,
enforce
is at our Compliance and Amendments Committee, we had originally found a violation that you did not turn over, that you needed to keep withholding to a minimum, and that you failed to respond to a request for information. But at the Compliance and Amendments Committee, you had explained to us, along with Supervisor Kim's office, that is all that you had, and that you didn't keep documents, that some documents were deleted, that you relied upon the clerk's office. And because you had discussed the retention policy, this was at the Compliance and Amendments, I mean, we can't ask you to turn over documents that you're saying you don't have. So that is part of when we were following up on the violation that we had found. Does that make sense? We had originally found a violation of not having any documents, but when we followed up on it, you said you didn't have any more, that you turned over everything that you had. And so then there was a question of we had asked you if you had sent Mr. Pitt to the clerk's office, and you had said if you had known that was something that you could do, then perhaps you would have addressed that. In addition, that's the 6721C that's referred to in the agenda.
Right, and for future I will, but at the time when the request was made, I had no idea who Mr. Pitts was. I had never seen him. I had no idea of his knowledge of whether or not he could get to the clerk's office. I had no idea whether he knew he could even go to the clerk's office for documents. I did what we always do, which is search our documents pursuant to the request made, and then turned over everything that we had. And
I understand that. So the recommendation from the compliance and amendments is to send a letter to the Board of Supervisors that there needs to be, that there needs to be an email retention, and that it's causing some confusion, and then to remind them of the obligations that you were just discussing, to refer a requester to the appropriate place to find documents if that's where they are. If you rely, since the board is saying they rely on the clerk to keep those documents, which we discussed at the compliance and amendments.
I think that's good. I think maybe in the letter to include, like when we respond to requests, say this is all we have, but if you want a thorough review of all the documents on file, you can contact the clerk's office or the rules committee clerk. Here's Linda Wong's number, here's Linda Wong's email, and that way I think if we include that in our response back, they'll then know that there's another place they can go that is the official keeper of all the records, and I think Mr. Pitts would have had the document in hand at that point.
Okay, thank you. Member Wolf?
Yeah, so I just want to say that it's, each and every employee has a responsibility as a custodian of records. So whatever records that you have in your office, just because the clerk may have the same, you may think has the same, it's really the obligation, not obligation, it's the opportunity for the public to be able to corroborate. If there's multiple documents from various different departments, and let's say they get some from this department and they get some from another department, but there's 3 more pieces of different documents from a different department on the same subject, it's their ability under the law to be able to collect those documents. So just, the point is that it's the right under Sunshine and the California Public Records Act for every individual to request any documents from anybody. Okay,
I do understand that.
Okay, so I'm just saying that in
But you
general.
do understand, though, that the clerk has to keep documents in which my office does not.
I understand that,
Okay,
but there are certain documents that you must keep because
understand
there
that.
is a retention policy
understand
for every single kind of piece of paper. We've sat with the clerk on this and reminded them about the email retention policy, and that's something that they're reviewing. So. And there may be, for some supervisors that are new that and may not know, or even for staff that have been around a long time that may not have been taught or have knowledge of how what the retention policy is or how it's supposed to work. That's what this is really all about. This is about, let's get it straight. That's really what it's about. And so here, the complainant feels that he has not gotten all the documents, that there are documents in this department, documents in this office, documents held by this person. He's trying to find every single document that he submitted. He can't even find the documents that he submitted himself. That's his own testimony. So he's on the goose chase for it. And so that's what this is all about. And what we're finding here is that there has been some violation on him of the ordinance on him by you and by your offices, and and the response from the Compliance and Amendments Committee is to recommend to send a letter to the Board of Supervisors, just reminding them and to review that there is an email retention policy, and also that to remind you of the obligations under Section 6721C. That's the crux of what we're here for today.
I was unclear when I left the meeting last time that we were found in violation. I thought I explained it, that I turned over everything we had. At that point, the only possible violation that I thought could have been found was the one that we were a day and a half late on our turnover. I am talking in the microphone.
It We had originally found the violation, which is how we ended up finding out about the retention policy. So we were following up on the order of determination. We're not reversing the order of determination at the Compliance and Amendments Committee.
Okay, that's helpful.
Mr. Pitt had not gone to the clerk's office when we had the Compliance and Amendments Committee meeting. He had not gone there yet. So
Has
we
he
didn't.
gone now?
Well, Mr. Pitt said that he did go to the clerk's office and he didn't have his own documents there at the clerk's office. Is that what you testified to, Mr. Pitt?
He's going to speak.
I'm going to say that, but then there's also documents. This document here, it also
Can you
says...
just answer the question, though, because we're not rehearing the case. Can you...
my
Did you go to
application
the
gone,
clerk's
other
office?
Other letters were missing.
From the clerk's office?
Yep. I'm missing a lot of stuff.
But is it from the clerk's office?
I went to the clerk's office.
And they were not there? Your own submissions?
Nope, not there.
So since the supervisors rely on the clerk, it may be that you need to make a request to the clerk's office to find out if they're keeping those documents.
So I send another request in requesting for more documents. The same
Well,
documents again.
it would be to the clerk's office because you've found out, you've uncovered sort of this hole in the retention policy that the Board of Supervisors has. So it's something that we didn't realize was going on before you brought the case to us. At least those of us that have not heard a case like this before. We didn't realize, we were shocked when Supervisor Ellsburn said he deletes his emails. We were very surprised by that. And he said he relies on the clerk's, if they're relying on the clerk to keep these, we need to know if the clerk is actually keeping them.
Okay, but
So-
the problem with that is the emails that I got from Jane Kim, they're not in this file here.
Is that from the clerk's office?
Yep, they're not there.
So all I'm saying, though, is that Jane Kim and Supervisor Farrell and Supervisor Ellsburn have all told us that they rely on the clerk. So we're going to have to aim in that direction to find out what the clerk has and does not have and if they're properly keeping those documents. It's unfortunate, but every investigator has to do more than just one thing, including us. You've seen me up here many times. I've had to go to videos. I've had to go and read other documents. It's unfortunate, and I'm sorry that it is that way, but it takes a little bit of digging to sometimes get to the point of where you want to go. And this has pointed you in the clerk's office.
So I go back to the city clerk and ask for the information again, which they'll probably give me a copy of this file again.
And you'll find a violation, and that now they're saying that's what they rely on. They won't really be able to say that if they're going to point at, then you'll know
Right. So
if it's truly missing.
So I'm just running in circles, and I still don't have my information.
You're not running in circles. You're not going to get everything that you want from an organization that's big like that from one place. And unfortunately, I'm trying to help you out. There's no rule that says that they can't rely on the clerk for that. So
I've been to 4 places. And I get a different answer from somebody else. Everybody else gives me something different.
But your complaint is not against the clerk, and you didn't include the clerk in your complaint. So it's difficult for us to find any kind of a violation against them, and they're saying that's who they rely on without having a complaint against the clerk. And certainly we'll mention that in our letter, because that's what the email retention is about.
But they're all supervisors. They're all on the same level. So
It doesn't work that way. That's not their rules, and I can't change their rules.
I'm saying it should go above to somebody above them to do something, because it just looks like a backroom deal. They throw out my application and they just appoint whoever they want.
Yeah, that's true.
Well, I mean, just think about it when you send your application in. Just think about that.
Think about it when mine goes in.
Well, I mean, they might be in the back room, throw out your documentation, and then...
I know we're getting a little bit sidetracked, but even if they had all your documents, they can still appoint whoever they want.
I mean, they can pick who they want, but is it fair that they just throw your application out? Is it appropriate?
It's not appropriate, but We're only the watchdogs. We don't have the authority to tell them what to do.
Well, I'm saying send it to somebody above them, not just their peers who are going to just ignore it. The Ethics Commission, the mayor's office, the city attorney, send it to somebody besides
Mr.
just
Pitt,
their
I
peers.
feel for you, but there's no rule that they violated.
No, I'm saying send it to somebody. Send it to somebody that will at least, send it to the mayor's office. Send it to somebody. You send it to...
CC them, you were asking us to CC the mayor on this?
Yes, somebody.
Thank
Yeah.
you. Is there any further discussion?
I had a point.
I'm sorry, Member Costa.
It's okay. I mean, it is bothersome to me that, it seems like 6721C, I mean, maybe you can tell me what you think about this, but it seems like it sort of carries with it that it should be the responsibility of the supervisors, in this case, to really see the request all the way through. It doesn't seem right that Mr. Pitts should have to file a whole nother complaint with the clerk. It's okay, it's acceptable that the Board of Supervisors in this situation is saying, we rely on the clerk of the board to retain our documents. But so that means Mr. Pitts should have to file a whole nother complaint with the clerk? That doesn't seem right. It seems like them telling Mr. Pitts that the clerk is the appropriate person to go to because they're the custodians of the records in this case is sufficient, and that should surface any and all documents related to this case. That the initial complaint should be applied, I think. And in this case, if he's saying that his application is missing, I think that's completely inappropriate. It seems like I don't know what else I can say besides that.
Well,
I think my other
Mr.
contention
Pitt,
is-
I'm sorry, you're going to have to wait. That one thing that happened during compliance and amendments that I want to mention is that both Member Snyder and Member Wolf wanted more time to research the retention policy before they got involved in that level of detail. Because at the time, Mr. Pitt had not gone to the clerk's office. So you may want to speak to that. Member Wolf.
So with that, I met with the previous chair, Chair Nee, with the clerk and the supervisor of all the commission clerks. And we spoke about this particular item with regards to the retention policy. Their eyebrows did go up. They weren't quite sure what it exactly meant and whether there was a requirement for, and I finally got a copy of the retention policy, and what the requirement was for holding onto emails by individual supervisors. The policy says that there must be a communications log of emails, telephone calls, visitors, so on and so forth, okay, by each supervisor. But there was nothing in the retention policy that spoke of retaining emails. Now, they may have a particular rule outside the retention policy that I don't know about that may say you can keep them for 7 days. I know the Good Government Guide has a pretty good area that talks about how long or the pertinence of email. But if the testimony of the supervisor and or any custodian of record is, I don't have the documents, other than saying or admitting that they deleted the documents, okay, then there's nothing much we can do about it. All we can do is hold them in violation. That's all we can do, okay? And here at this point, we're finding that they need a strong reminder that they have an obligation. And we went through this quite a bit, as you know. I know it's probably not going to be what you want. And I just want to say, and I agree with Member Costa in part, if I was concerned about the happenings of a traffic control device, a traffic light somewhere, and if I went to the MTA and got information from them, because that's what they control, the decisions over that, but who installs it is Department of Public Works. And I went to Public Works and I got two different answers, okay? It's not the fact that one department is in control of all the documents, and then that's the end. Each and every person that touches the information is a custodian and must reveal. So that is kind of the crux of what Mr. Pitts is going through. He felt violated by the experience he had. He went on an investigation to find every single document that he could find, and there beyond.
Wait.
And
Mr. Pitt refused to go to the clerk's office. That he did not go before the Compliance and Amendments Committee, and that was really difficult for us when we were talking. I understand and I sympathize with what Member Costa is saying, and I agree in part. But you wouldn't go to the clerk's office when they directed you.
I disagree
Sir,
with
I'm
that.
sorry,
I
you're gonna
disagree with that because see, I didn't
turn
I
the
don't
mic
understand
off.
how this I don't understand how this process.
Mr. Pitt.
You expect me to know how to do all of this?
Mr. Pitt, you picked up documents from Mr. Ellsburn, from Supervisor. Mr. Pitt. Mr. Pitt, are you going to listen? Are you going to have us? Are you going to help us? You picked up documents from the clerk's office from Sean Ellsburn, and then you told us you didn't know where the clerk's office was. You're making it very difficult for us to make decisions. And then you refuse to go to the clerk's office. Now, I understand what is happening. I understand. But it was very difficult for us to find violations under those circumstances. It wasn't until now that you brought to us that you couldn't find your own documents. So it was very difficult for us. It wasn't as cut and dry as it is now that you have gone. You refused to go to the clerk's office. You also told me that you didn't know where the clerk's office was, though you testified that you had been here. You had been to the clerk's office before. I'm just explaining to you that you made it very difficult for us to find a violation. Sir, you're being very disingenuous right now, and you know it, and I know it. Yes, you do. You had been to the clerk's office. It was very difficult for us. I understand. You did not say that. You told us you didn't know where it was. Well, now that you've brought this information, if you had told us that, it would have been easier for us to have this conversation. Sir, why didn't you tell us this information when we needed it? All right, I apologize for having this argument with you, but I'm just trying to explain to you that if you don't bring us the information, it's very difficult for us to have a complete discussion. You did not help us, is all I'm saying. It's very difficult.
I'm the citizen. You're supposed to help the citizen.
We tried to help you. We're trying to help you now.
Look at this. He didn't help me. They refused to help me. I mean, Jane Kim.
Sir, you're making contrary statements to what you made before. That's all I'm saying now. And if we had known.
I didn't understand. I just submit them documents and I get documents back.
All right.
But I didn't understand their time.
All right, I'm going to continue with your hearing. I'm going to continue with your hearing. Please sit down. I'm going to continue with your hearing. Is there any more discussion among the task force?
I would move the recommendations of the Compliance and Amendments Committee.
You mean to the letter?
Mm-hmm.
Move forward.
Second.
Is there a second? Is there any discussion?
If I may.
Member Costa?
There is an unresolved problem here, which is that it has come to light since that Mr. Pitts has gone to the clerk and has gotten information from the clerk. And it sounds like there has emerged no such communications log with all of his, emails. There's correspondence. There's no record of the correspondence that he has, all the correspondence that he has had about this matter. What happens with that?
As a point of, DC, through maybe you're going to answer what I'm asked, but as a point of order, if new information is brought forward, is it something we would continue? Because it's not on the agenda, so we can't necessarily open it again.
Through the chair, this is a hearing on an order of a determination that's already been made, and if there's new information that comes to light during the hearings on those that could indicate separate other violations, then the complainant can file a complaint about those. But the clerk's office and the there was this two supervisors' office are the respondents in these two matters. If the clerk's office has separately committed violations of the ordinance, then they would need the opportunity to come present their case about that.
Thank you. Member Wolf?
Just a point of order, you can also re-refer it back to committee for more discussion and more investigation, and, you know, you can, you know, leave the item open in that kind of way too.
Member Washburn?
I was looking back at the minutes from the July 12th meeting and also looking at the wording of our recommendation, and it's to send a letter regarding email retention. I think that's broad enough that we could incorporate what Member Wolf learned in his conversations with staff. So I think our intention was to bring this matter to light to the Board of Supervisors to make some recommendations on how to move forward and how to be better in compliance. And I think we can incorporate what we've learned tonight and move forward. I'm not in favor of sending this back to compliance and amendments.
Is there public comment on the motion? The motion is to send the letter to the Board of Supervisors as on the agenda.
I'm a little confused by this entire thing because you're going to be sending a letter to the Board of Supervisors, who supposedly is the authoritative figure above you when somebody breaks an order of determination, asking them, the Board of Supervisors, if they know what the policies are. Huh? Aren't they supposed to know what the policies are? Aren't they supposed to train their people properly? Aren't they supposed to circumvent all these problems that might come up? Are they not educated? Could they have not foreseen this? Are they third graders? And if they're third graders, why are we referring your orders of determination up to them and the Ethics Commission and everybody else? Just thought I'd ask the question.
Thomas Piccirillo, I concur with the comments by Mr. Costa. You did not give the remedy that Mr. Pitts was seeking in his sunshine complaint. The proposal now is advise supervisors of their email retention. Mr. Pitts' sunshine request is much broader than emails. He asked for any and all communications that the supervisors had, either with him or any of his opponents. And they told you there weren't any communications. They just decided to sit down in the Rules Committee and then vote on the three candidates, right? Come on. They lied to you. The frustration of Mr. Pitts is that you didn't do anything about them lying to you, other than now you want to send a letter advising them of the email retention. He asked for any and all communications. Mr. Pitts did actually go to the clerk's office after you advised him to go to the clerk's office. That clerk's office, the file is empty. There's no, his 3 letters of recommendation by other people were not in that file. Where are those? So, you know, I'm surmising that, you know, the favorable material for Mr. Pitts was dispersed amongst the supervisors and never put in that file because it's not there now. Jane Kim, Supervisor Farrell, Supervisor Alson all lied to you. It's unfortunate that you couldn't prove their lies, but you did not give Mr. Pitts the relief that he was seeking when he came in front of this task force. And this letter advising him of email retention is of no benefit to Mr. Pitts. Thank you.
David Reardon, Muni Operator. I'm outraged. As a Muni Operator, I have a rule book this thick that I have to follow. When I'm caught breaking the rules, I get suspended. Supervisor Ellsburn pushed Prop G based on work rules, and now I hear you say that Supervisor Ellsburn doesn't know the rule of email retention. Supervisor Ellsburn is a liar. I've said that to his face. And it's another violation of ethics amongst the people who control the city government.
Members of the task force, Ray Hartz, San Francisco Open Government. The bottom line is rationality has to go in this thing. If I'm a supervisor and I know that there's a responsibility that any communications I have to be maintained, I just can't take this half-assed attitude of, oh, I think somebody else is going to do it. I have a responsibility to say, okay, is this person doing it? Call them up, talk to them, have my staff do it, whatever, and say, are you or are you not keeping these emails so it's all right for me to delete from my files? And if you're not, then what do I have to do? Do I need to maintain them? And really what they're saying is, I don't, as a supervisor, understand the Sunshine Ordinance. I don't feel any obligation to make sure my staff understands it or follows it. I'm just going to make a lot of assumptions, some of which will turn out later not to be true. This needs to go to the Board of Supervisors. The Board of Supervisors, if they are honest about it, will have an open discussion and say, what are the rules? They have the clerk of the board. The clerk of the board works directly for them. And if they're going to be making assumptions about record retention and all this other stuff, then they should sit down with the clerk of the board and have the discussion, say, what do you retain, what don't you retain, what are we required on our own to maintain? And if I can rely on you and be able to come into the Sunshine Ordinance Task Force and say, we had this discussion, and I was told by the clerk of the board that they kept those things, and I relied on that, then you'd know to go talk to the clerk of the board. And I think that's where we are right now, is everybody's working on assumptions rather than actually sitting down and having a conversation with each other to figure out what are the rules, what do we have to do to follow them, and are there any holes? And this is a big gaping hole, as already been mentioned. And so going to the Board of Supervisors, there are 3 in this particular case, but I think we all know there are probably every single member of the Board of Supervisors has some variation of the same tale.
Thank you. Is there additional public comment? Just as a important note that I hear frequently here, it's true that we send things to the Ethics Commission and they don't enforce it. We cannot make the Ethics Commission enforce it. So I would definitely like to see some of you show up at the Ethics Commission and tell them what you're telling us as well. Because on the same vein, we don't write the email retention policy. Sean Ellsburn does know the email retention policy, and he can delete the emails. We cannot write their email retention policy. So we need to also address them. The same concerns you're addressing with us, their aides are here right now. So I urge you to write to them. I urge you to bring these same things to them, which is what we're trying to do, to say this is a problem. We don't write, there's no email retention policy here in the Sunshine. I'm sorry, Mr. Garza, public comment is closed.
I was just going to comment on that.
I'm just telling you, I'm just making a statement that there are many things here that we oversee, but we do not, we can't write the email retention policy. So I'm urging you to go to the people who can. We're trying to do that. We're trying to go to the people who can. It's back with the task force. Does anybody have any comments before I call the question?
I just want to sort of one last time emphasize that I think I agree completely. I agree with a lot of what Mr. Hartz said in his comment. And I think I just want to reiterate that if the Board of Supervisors is going to take the stance that they're relying on the clerk of the board to be the custodian of their documents, then fine. But it seems not appropriate. It seems inappropriate that then they would not have to take responsibility for the completeness of those documents. They're going to delegate that task administratively. That's their business. But otherwise, what? Nobody can submit a complaint to the Board of Supervisors anymore. A complaint to the Board of Supervisors automatically just it's empty. You know, I don't accept that. I think that's where 6721C comes in. I really think it's their responsibility to make sure, you know, a complaint to them automatically transfers over to the clerk of the board's office.
I agree with you, and we did have this discussion. Mr. Sean Ellsburn was here, and I also talked to him. I didn't talk about his case, but he was here, and he tried to reach Mr. Pitt, and Mr. Pitt wouldn't return their phone calls.
I understand.
It's not true. He lied. Can you prove that he called me repeatedly?
Sir, please, you're going to have to please.
I understand in this with the facts that we have for this particular case, I agree. But for the purpose of the letter, I think that point should be emphasized.
Okay.
And I also think that if, after having gone to the clerk of the board, holes in the documentation in terms of what the email retention policy is have appeared, it is absolutely within the right of Mr. Pitts to file another complaint. I don't know. That's all.
Yes.
Clerk, I have one procedural question. Is the tape working properly?
Madam Chair, I have been assured that they are recording it downstairs for me.
Thank you. Because there's a lot of complicated things going on, and I didn't know if there was a problem with the tape. Can you please call the question on the motion?
On the motion, Member Snyder?
Yes.
Snyder, aye. Member Cawthon?
Yes.
Cawthon, aye. Member Manny?
Aye.
Manny, aye. Member Washburn?
Aye.
Washburn, aye. Member Costa?
Aye.
Costa, aye. Member Wolf?
Aye.
Wolf, aye. Member Chan? Chan, absent. Member West?
Aye.
West, aye. Member Johnson?
Aye.
Johnson, aye. Madam Chair, we have 8 ayes. The motion passes.
Thank you. Do we need to take a break? But I want to ask about if we have next, if we can even talk about it. We have to call it to ask that. Can you please call item number 7?
Item number 7 is next steps on Ethics Commission's proposed policy for handling sunshine-related complaints.
This item is on this agenda because way back in June, the Compliance and Amendments Committee was trying to forward this to the Ethics Commission to discuss their regulations. And I had hoped that we would be able to get through the orders of determination quicker. So I wanted to ask the task force members if they feel this is something that they would be able to vote on this evening.
I think so.
You think so? Okay, so these are, the Ethics Commission had sent us regulations. Member Washburn is the chair of the Compliance and Amendments Committee who's been handling this. Would you like to introduce this briefly?
Yes, as you said, this came before us, I believe it was in August of last year, from the Ethics Commission, some proposed regulations on how to handle sunshine matters. We spent many meetings, and I'd like to commend a member of the public, in particular Alan Grossman, for his work on this. Also, Member Snyder for his work as well. We've developed a response to the Ethics Commission's proposed regulations, which is really a complete revamping of them. And we had a couple of principles in mind. One was we wanted it to be perfectly clear to the Ethics Commission that there are 2 types of sunshine matters that come before them. One type of matter would be a complaint that comes directly to them. in which they would be able to have a hearing very much as we have our hearings. In other words, the matter wouldn't have come to us first. But then there are many more matters that you've by now become familiar with, that we have our procedure. We have hearings. Very often the matters then go to a committee, such as compliance and amendments, which comes back here. And then we very often make a recommendation to, or we send the matter to the Ethics Commission for enforcement after the complainant does not receive the remedy that we wish. And what has been happening in the past is Ethics Commission, or the staff does their own investigation and then kind of throws the whole matter out. And this has been very frustrating. So we wanted to recommend that they not rehear anything that we have determined. We are the body that does that, and we want them to more be the body that carries out the sentence, so to speak. So they're the sentencing phase of all of this. We're the ones that try the case. So we wanted the regulations to clearly show these two types of matters. So at this point in time, I'd like to invite, through the chair, Alan Grossman to speak further on this.
Mm-hmm. Anybody has any questions? If you want to, I know that the package was 250 pages, and this was about a fifth of it. So I can either respond to questions or I can talk about what we were focusing on in addition to what Member Washburn was saying. It took a long time. I think part of it was a learning process on our side, and coming to grips with the idea that giving St. Croix and his staff leeway or wiggle room on these proposed regulations was the wrong way to go, and that we had to take a stand basically on a simplified procedure, identifying the differences between a simple complaint that could only be filed before the task force and enforced by the Ethics Commission, as contrasted with a willful violation by a department head or an official that could only be filed before ethics directly. And then, of course, the official misconduct type of findings, which are not supposed to be covered by these regulations at all, since they are unique to the Ethics Commission in that it can enforce findings of official misconduct in 6 or 7 different contexts under the city charter. The other thing, a couple of the other things that we focused on was keeping the staff out of our cases, basically, and letting the commission and the parties duke it out, if they're going to do it, before the commission on the so-called sentencing or penalty phase. And what, in effect, it guarantees is that every case now will get a hearing, every enforcement case will get a hearing before the commission. And the staff will just be the paper shufflers. That's an important consideration. We also eliminated some of the outs that the commission staff had suggested. Well, if they rely on a city attorney advice, they're not really responsible. We've taken that out. We've also eliminated notions of that would allow the penalty to be reduced based upon either misunderstandings or subsequent behavior, none of which were really relevant to what the commission's responsibility was. I think in sum, it's an easier way for the commission to deal with it because they're not equipped to handle simple violation cases, as you can tell from this meeting today. They certainly, with the staff, which they claim is already overburdened, they would have the responsibility of being a prosecutor, which doesn't fit at all. So those are the kind of things that we tried to parse through and fix. And then ultimately we found that the staff's draft was so replete with formalities and other confusion that it was easier for us to simply redo it, which is what Mr. Snyder and I did, basically. So that's pretty much the story. We've got a memo that's going to explain the basic approach that we followed. We explained why their jurisdiction is different in an enforcement case from a willful violation case, from an official misconduct case. And we also will explain how the drill is to be handled once it gets to ethics, if it's going to be simple, direct, and effective, because that is the purpose of these proceedings, and it's the purpose of the law in general. Under the Public Records Act, records cases have priority. They get immediate attention, and that's what they should do at ethics as well.
I have a question. It's my understanding that in addition to your memo that you have explaining that you think we should provide a cover letter.
Well, when at the meeting, what we discussed was the idea that if we just send this over, it's going to hit them. You know, where do they get off telling us what to do? It would be better, I think, to express the fact that we took a long time. What we wanted to do it right, and that we ended up with this redo, you know, as a result of that process, and that we would like very much to have a meeting with them as the Commission and the Compliance and Amendments Committee, so that their issues and our issues, your issues, can be ventilated in the open without the staff interference, which is the biggest problem. I actually left what I was going to read to you. No, here it is. I think this is important because I just took it out of one of Mr. St. Croix's dismissal letters. The task force, pursuant to orders of determination that it issued for records requests, interprets the Sunshine Ordinance sections, to suspend otherwise applicable state law doctrines when it's requested. City attorney record concerns the CPRA, the Brown Act, and so forth. In contrast, the city attorney's office interprets the charter, state law privilege, and rules of professional conduct as controlling in some instances where there is a conflict with the Sunshine Ordinance disclosure requirements. Staff is not charged with assessing the merits of either party's legal interpretation. Instead, staff's role is to make a determination whether respondents willfully violated the Sunshine Ordinance. However, the city attorney is the lead attorney for the city and county of San Francisco, and staff recognizes that the city attorney is a higher authority than the Sunshine Ordinance Task Force. So that gives you...
What is that from?
That came from a letter in one of his dismissal cases. And I've seen it in other versions where because the city attorney is an elected official and you're just appointed, that the city attorney's interpretation is superior. Of course, the members of the commission are all appointed. But this mindset is what has been driving these dismissals. And under the process, the procedure that they still follow, which is inapplicable and illegal as it concerns your referrals, Mr. St. Croix makes a determination of probable cause or not. If he says there's no probable cause to go to find a violation, he sends it up to the commission and in a report, and the commissioners have a total of 5 days from the date they get that, within which 2 of them must ask for a hearing. And if 2 do not, it becomes final. They've never asked for a hearing, except in Ms. Cawthon's case, and they're continuing to do that.
Does anybody have any questions for Mr. Grossman?
One of the things that the guy who did should I have to accuse myself to talk about this? But I have something specifically about what Mr. Grossman just said. They said that things changed after Mr. Grossman won his lawsuit. And things that they did, he said they always met privately and made decisions. He said now, because of Mr. Grossman's lawsuit, they are meeting in public, and my case was the first case that they considered in public.
Okay.
We're hoping these regulations
I'm not sure that it did all of that, because we're still seeing Mr. St. Croix making the same arguments here that we successfully dealt with in the lawsuit. And that was over a year ago, year and a half ago. So, we'll see.
So what we'd be voting on tonight is that we would send these regulations over to the Ethics Commission as a response to the regulations that they had put out. We'll put a cover letter on it to explain why we're sending it, why it took so long with your memo, and then it will go back to compliance and amendments, and it won't come back here again, probably until we have something after a meeting with the Ethics Commission. Member Washburn.
The letter should, the agenda item for tonight says next steps with this, and so I think we, at the minimum, want to have a letter that requests a meeting between compliance and amendments and the Ethics Commission without staff present. So I think that's the next step, is to request a meeting.
Yeah.
And then...
We're sending this over, though, to you.
Right, yeah, sending that over. But, but asking for a meeting. And then the Compliance and Amendments Committee we will discuss strategy and what to cover and so forth.
Well, the staff is going to fight this tooth and nail, because you saw their reaction to the civil grand jury report. They wanted to go right at them. And Mr. St. Croix's comments about the task force that were quoted at length in the New York Times article, some months ago, is an indication of what you can expect. But, it will be tough.
In the interest of time, if there's no questions from the task force, I'm going to go to public comment. Is that okay? So public comment on the ethics regulations proposal.
Yes, Ray Hartz, Director, San Francisco Open Government. I would suggest sending it because they're going to fight it. In particular, Mr. St. Croix is going to fight it, and I don't know whether it's because he simply has had the power for so long to simply not only dismiss your cases, but cases that were referred directly to ethics. I had 2 of them that they just said, oh, well, the city attorney says this or that, and they dismissed them. And I think Mr. St. Croix is going to fight tooth and nail to keep his power, because it is his way of maintaining control over the commission. So I would suggest strongly that you send the letter directly to the president of the Ethics Commission with copies to each commissioner, and let them give it to the staff if they want to. So that way they have no way of ducking, and Mr. St. Croix has no way of disingenuously coming up with some rationale why they shouldn't deal with it. And I think that the most important thing is that a couple of people mentioned that you needed support going to the Ethics Commission. I went to the Ethics Commission hearing in Ms. Cawthon's case, and I've gone several other times to tell them what I thought about the grand jury report and so forth. And this is the old adage, strike while the iron is hot. They have a devil. I still do not think in any way, shape, manner, or form that it was accidental that the first case they managed to hear happened to be on the same agenda with the report from the civil grand jury. They sat there and said, oh, we're not dumber than a box of rocks. We better do something so at least nobody can point at us and say we never did anything. And I think that that impetus is still there because they still have a 95% failure rate in your referrals. And this would be a good time to say to them, hey, you want to clean up your image a little bit rather than just carping at the civil grand jury. Maybe you should make some appropriate changes and do your job.
I may be out of order here, and I know we have all been here a very long time. And 2 hours ago, I asked
I'm sorry,
you
we
to
have to limit your
consider-
comment to the ethics regulations.
Reasonable
I'm sorry,
accommodation. I apologize, Ms. Johnson.
We cannot do this right now. We cannot do this right now.
Because they're very tired, and they're over 70 years old.
I apologize, but we cannot do it right now. This is public comment. It's public comment on an item on the agenda, the ethics regulations. So we need to take public comment on that.
I have a point of order. I was wondering if we could take Ms. Gavin's case.
It's not that I don't have time. We have an item before us. Ma'am, we have an item before us, and we cannot take public comment on anything except that. I apologize. I apologize to you. Ma'am, please sit down. Please sit down. I will answer your question when we are finished with this item. We have to finish with this item.
Could I make a point? Could I make a point of order?
One moment, Mr. Garza. Is it relation to public comment, Member Cawthon?
It's related to this issue that just come up before us. That possibly.
Let us finish public comment on item 7, and then I will come back to you.
Okay,
I thank you for waiting.
Mr. Wolf, I would tell you that that the point of order takes precedence over everything.
Only if it's germane, and it's not. I think what you're about to say is not germane to this particular motion.
If it can wait until we get through public comment, then we'll take it after that. Thank you for waiting, Mr. Garza. I apologize.
It's okay. I mean, we're civilized people here with rational minds, and given facts and reality, hopefully it'll soak in how ineffectual this entire thing is, what a farce it is, how much harm
Are you
it's
going to
done
speak to the
complainants.
ethics regulations? I
I
really
am
have to
speaking
limit.
to the ethics regulations.
Okay, thank you.
I've told you in the past that I've sent letters up to ethics, which they've not responded to. I've told you that your commission has sent things up to the ethics commissions, which they've knocked down. I've showed you number 15 out of 15. Now, my question about this is, when you do send this up to the ethics regulations, new regulations, and you're once again defeated because they'll find a loophole or a way out of it, will you at that point continue to offer false hope and false process and continue to be toothless and powerless and, continue to vex and aggravate us here? Or will you take what I suggested in the first place, which was to step down until you got power, maybe go to the people, at the ballot or whatever and say, the reason we're stepping down is because we keep getting played, and we're doing this because we really do care. We don't want to see this continue. Or will it just continue, once you send it up to the Ethics Commission and they just overrule everything and find loopholes? I think if you dealt with the public and told them what you're really facing here, with all the records, with all the cases that have been sent up and refused, and all the game playing and brinksmanship and everything, and you came out and you said, you know what? We're not going to stand for this anymore. It isn't working. And that's why we're stepping down, because we have the nerve to do the right thing until we're granted not only enforcement power, but maybe we'll also be granted a revenue stream so that we can find these people, so that we can hire outside counsel, all these things. But to continue to play in the box when the box is totally sealed, shut, and thrown in a river that's passing by is not only ignorant, it's demeaning of your guys' intellectual status, I would think. You know, your stature. You know, it doesn't work. You can't make it work. Go to the public. Tell them why it doesn't work. Prove it to them. Prove how this whole thing is a farce. And you know what? You might really get people standing behind you. But to continue to play in the box when you get played and then to pass it on to us, so distasteful. So distasteful.
Thank you. Is there any other public comment on the ethics regulations? Seeing none, the matter is back with the task force. Is there a motion? Oh, I'm sorry, Member Wolf.
I think we already have,
Oh, I'm
don't
sorry.
we already have a motion?
Member Cawthon wanted a point of order. I apologize, Member Cawthon.
It has to do with Ms. Gavin. It's about the agenda. I was wondering if, since we did change Mr. Wooding's item to number 10 because of, I think, physical disability, Ms. Gavin said that the two people with her are senior citizens, and I was wondering if we could move that up further on the agenda also.
I don't think that's I think it's something that we need to address after we finish item number 7, and we will address it as soon as we're finished. Member Wolf?
I just want to say that on this particular item, you know, the Ethics Commission has never had any kind of rules or guidelines or policies with regards to how to dispose of what we send them. And it's unfortunate that they just didn't, you know, kind of develop something a long time ago or apply what they already do in the same kind of way, that it has to come all the way to create a brand new policy at this point. And I think the fact that the work that we've all done on this, including Mr. Grossman, to try and bring something that will get us very, very close to them not being able to just shove it under a rug is really important. It's a good first step, because once it's in there, then you can push it. And I think that that's a really important factor. So up to this point, yeah, not much justice over there. After they adopt what is being put forward, it will be helpful. Whether they adopt any of our recommendations, that's another question. They have their own. They're their own draft. So I just wanted to kind of speak the reality of how this is all going to go down. It's just going to be a pretty heavy fight to get the right policies and the right regulations in place.
Member Cawthon?
I just wanted to mention one of the things I found during my own case with ethics is that there is a list of their jobs and duties, and the Sunshine enforcement of Sunshine Ordinance matter referrals is not one of them. This was mentioned in the papers also. So I think that we should really address that. It doesn't make any sense to me that the ordinance refers things to them, but their work schedule does not include actual action on matters that are referred to them by us.
Is there a motion to move these forward?
Did we already not do that? No?
No.
Yeah, are you talking about?
Chris, did we not make a motion? Oh.
I move that we send this along.
Second.
I would just like to, as a friendly amendment, just kind of reword that a little.
Wait, did we make a motion before?
No, we didn't.
No.
Just that we would accept and approve the document that we worked on, and that we refer them and send them over. Because just to send them over, I mean, I think we should acknowledge the work that we all did by approving the document. It's ours.
Absolutely accepted.
What?
The seconder accepts.
Okay, but what are you?
I'm just stating that the motion that Member Costa made was that we refer the document to the Ethics Commission. I'm asking that we just a friendly amendment just to adjust the wording to say that we approve the document.
To be referred.
To be referred.
Okay, I understand. Is there public comment on the motion? Seeing none, public comment is closed. Clerk, will you please call the roll?
On the motion, Member Snyder?
Yes.
Snyder, aye. Member Cawthon?
Yes.
Cawthon, aye. Member Manny?
Aye.
Manny, aye. Member Washburn?
Aye.
Washburn, aye. Member Costa?
Aye.
Costa, aye. Member Wolf?
Aye.
Wolf, aye. Member Chan? Chan, absent. Member West?
Aye.
West, aye. Member Johnson?
Aye.
Johnson, aye. Madam Chair, we have 8 ayes. The motion passes.
So these matters this document will be referred to the Ethics Commission as approved by the full task force with the memo from Mr. Grossman and a letter. Do you want the chair to write the letter, or do you want it to come from compliance and amendments?
The chair can
Sure.
write the letter.
Okay. All right, thank you. Did we get all that? Okay. We're going to take a short break, but before we do, I'm going to say that this is not a long meeting yet for the Sunshine Ordinance Task Force. We have very long meetings. I had hoped that we could get through the orders of determination in a much quicker fashion, but unfortunately we did not, and I can't rush people forward when they're trying to think things through. We have a long agenda. We're clearly not going to get to all of the cases. I want to let everybody here know that our city attorney representative leaves at 9 o'clock. We can still hear cases, but if you want the city attorney representative present, he will not be present after 9 p.m., and we can push it over into August. I would like to address what Member Cawthon had said, and unfortunately, I do not see a way to move 2 of the cases forward. We have a number of cases that were we have 3 cases that were pushed over from last time, and we have the 1 case that we moved up after that, so it'd be very difficult to move another case up. However, if Pastor Gavin would like to have the case moved to August, we can have it first on the agenda. Unfortunately, we only meet once a month. Are they still here?
Yes, they are.
We're going to take a 5 to 10 minute break.
There's a question, I think.
5 or 10, 5 to 10 minute break. Well, I will make one, but I'm trying to find out what they want to do. Do you want to wait? There's a possibility that your case will not end up being heard. We have to vacate the building at 11 p.m. Okay. Can you come to the podium, please?
Are you saying that in August, that this item would be the first on the agenda?
Yes.
That's your point now?
If you would like to be first on the agenda because you do not want to wait because of the possibility that your case will be heard. Clerk, do you know the date?
Madam Chair, it'll be August 23rd.
It'll be August 23rd.
It's the 4th Tuesday.
The 4th Tuesday. Are you saying that if we
Could you speak into the
that it
microphone?
would be 10 minutes after your break?
No, we
Oh.
cannot move your case forward because we have other cases that got moved from last month, and we have another case that we had to move
so
forward.
you can't move that forward at all this evening?
Unfortunately, no.
And then on the 21st of August would be, the 23rd of August would be when we'd be able to present.
That would be when you could be first on the agenda because we could reserve the space for you now. There's a possibility that if you stay, Pastor Gavin, that we might not get to your case.
I'm new to this, but I think to tell me this 3.5 hours after I have been here, when the first case took an hour, I think it's unfair to everyone who is here. So I'm going to move for a continuance to be the first case heard.
For August? Yes. But Pastor Gavin, I'd like for you to know that each and every case, your case, we have no way of knowing exactly how long they would take, and I apologize, but it will always be that way.
I understand that, but when you go this long, I wish you would break earlier so that people would kind of know that veterans who are here dealing with the task force, everyone has not been before you, so this was our first time, and we did not realize how long you go.
I would not have been able to tell you that until now, unfortunately.
I understand because it takes a long time because you're dealing with democracy. That's something you cannot rush. So I want to thank you.
Thank you. So, clerk, can you please take note that, I'm sorry, I don't know which item it is, that items 21 and 22 are going to be continued to August, and we'll put them first on the agenda. And if you could make note that it is for, again, health reasons. We're going to take a 10-minute break. The Sunshine Ordinance Task Force is back in session. Thank you for your patience. Mr. Clerk, will you please read item number 8?
Yes, Madam Chair. Item number 8 is hearing on the complaint filed by Jason Grant Garza against the Haight-Ashbury Free Clinics for not providing him with documents related to 2 visits he made in 2010.
The complainant will have 5 minutes to present his case.
Before I present my case, I would like to ask a few questions for point of order. I asked for an interpreter. I'd like to know where that interpreter is.
When
for my
did
case.
you
email?
had
I sent an email in the day I got an email saying this case was scheduled, so I asked for an interpreter.
today?
No. I got the email to me on Friday telling me that today you guys would be having this. And on Friday, I sent in saying I needed an interpreter. And I also submitted more additional documents because I asked why weren't they included. I submitted additional documents into my
When did you
complaint.
ask? Did you ask for the interpreter on Friday?
I'd have to check my records. The emails are there.
The only emails that I'm going
It may have
to
been
refer
Saturday,
to
the
the
next
clerk.
day, but regardless, I asked as soon as I was notified. And it's not that I hadn't been asking all along for the whole prior month that this case was going to be heard.
Well, the only email I received was when we referred you to the ADA coordinator and you refused to work with her.
Actually, that's not true, madam. It's not that I didn't refuse to work with her. Actually, the ADA coordinator does not do anything for the constituents. I have a memo from Angela and from them stating that they work only for the task force and for the Board of Supervisors, and they do not work for the public or the constituents.
And I have her email saying
not true.
that she was willing to assist you here.
Right here from Angela Calillo stating the mayor's...
Mr. Garza, I'm not going to have this argument with
There
you.
is no argument. I have the proof of what
I have your email where she offered to assist you. I also told you that if you didn't want to work with that particular...
I don't have that email where she offered to assist me. I have an email where she offered to assist me. I wrote her back. I told her what my problems were, and then she threw her hands up in the air and said she couldn't assist
That
me.
is
I have those emails.
absolutely not, that is a misrepresentation
It is
of
not.
what...
I have my emails. Would
I
you
have
show
my
me?
emails as well.
Well, then would you send them to me, and we'll go from there? Because
I
do
did
have
send them
my-
to you.
I don't have
Mr. Garza, there's a lot of people waiting, and I'm going to tell you this right now. The
All right.
ADA coordinator told you she could not help you with the Department of Public Health, but she could help you with the Sunshine Ordinance Task Force. In addition, I said if you didn't want to work with her, that you would have to go to the ADA coordinator to get an alternative because the mayor's Office of Disability is who handles that. Now I'm trying to figure out if you sent an email to Mr. Rustum requesting an ADA coordinator other than those emails. I'm sorry, an interpreter. What was the
I did ask for an interpreter. All right, well, let's
Mr.
move on. I just wanted this to be on the record so that when I get the tape, you know, these questions will have been asked. And the representation that you're making that the ADA coordinator is there for me, which is false. Because
that
I
is
have the
absolutely not false,
It
and
is.
I'm not
I have
going
the
to.
It can be proven later. We have it on tape now.
I'm
That's
not
fine.
going to allow you to make a statement of something that is fact when we're having a dispute about it.
And I have my set of facts, so why can't
That's
I
from
make that
Angela
statement?
Cavillo. We just had this email
Now,
going back and forth.
the-
Now,
the
do you
next question-
need an interpreter to go forward? You said you asked for one, and I want it
It's
to be
not here,
fair.
so I'm going to have to pass on that. Whether I need it or not, it's not here.
Mr.
All right,
Garza, I'm
secondly-
not going forward in this manner. I'm not participating in what you're doing. I'm not going forward in
Why
this
are you not
manner.
participating? Am I not doing everything correctly? I don't understand.
You're misrepresenting
I'm not. I told you
many,
I'm going forward
many
without an interpreter.
statements.
No, I'm not.
I'm trying. Mr. Rustum, did you receive a request for an interpreter from Mr. Garza?
Madam Chair, no, I did not.
Do you have your request, Mr. Garza?
I can get to it on the computer because I have my email account and I can show it to you. And I can show you that I did address it to him and to you and everybody else, yes. But I don't have it in front of me.
I did not receive an email
Well,
from you that
we-
requested an interpreter.
I'm willing to go back on that later on and we can talk about it. That's not a problem.
I'm not going forward with you saying that you need an interpreter and we did not provide one.
And I'm telling you, since it's not here, I'll just skip it so we can go forward.
That's unacceptable
Why is it unacceptable?
because you're misrepresenting whether or not
Only
you
if I
have-
don't provide you with the email later on, which shows that I sent it in. If you'll
I'm
let me show
not-
it to you now, I can, if we can get to a computer and the internet, because it's on the internet, it's on my email account, and it's there. So we could solve this problem right now.
You're putting us in a difficult position because you're asking me to go forward with something that I don't know whether it's the case or not, and then you're going to hold it against me later. And we have no way of
I'm not going to hold it
knowing.
against you. We'll just settle it later. There won't be any holding. If I made a mistake,
If
I'll
we're
be
going to
honest
settle
about
it later, I'm not willing to continue this again because the last time that we were here, you demanded that there be 11 members present, and you would not go forward with presenting your complaint.
Madam, that is only partially the truth. The reason I demanded that there be 11 people present for the full truth, madam, is so that I wouldn't be thrown into rigged procedure for votes to count against me from people that weren't
That's
here.
the reason why you demanded it?
Correct,
but
because
I'm not lying.
without the 11 members being present, each one that was missing would have voted an automatic no against me. And when I asked Mr. Nee about that and the fact that it made everything rigged, he never answered that, and he tabled this matter. Now that the rules have been changed to where a majority of who's sitting here, I had no problems with that.
Member Wolf?
I'm a little uncomfortable as the disability representative on the task force. I'm a little uncomfortable when somebody asks for accommodation and we did not provide it, that we move forward, because that would be a violation of the ADA in every way, shape, or form. And so I take it very seriously when somebody says that they requested any kind of accommodation at all. And if we didn't get it and they need it and they want it for what they're here for, then they should be provided it. So I would, I wanted to just say that I feel very uncomfortable moving forward if you requested an interpreter and we didn't get a communication about it.
DCA 3.
Through the chair, if the complainant is requesting an interpreter as an accommodation for disability, I haven't heard that claim made yet. You might wish to ask if that's the case.
I agree with Member Wolf. The problem with what is happening is that when I ask, what I'm being told is you won't provide one, so I'll go forward. And that's a very difficult position to put us in. So if you need one, we're going to have to get you one. And that's why I was trying to figure out if you had asked for one. But to say that you need one but we won't provide it places us in a difficult position.
Okay.
Because that's not we
What if
want
I
to
was-
provide you with what you need.
I understand and I appreciate that and I agree and I fully do. And I would have liked for there to have been provided one. However, because there could have been a mistake either on your side or my side until this gets rectified, I'm willing to waive the fact that I don't have one and proceed, because this matter has been going on since December for an IDR. And so I can waive that because that's not a problem with the interpreter. However, I would like for us to discuss whether or not you did receive that email or not, because, I did send it, and I do want to be sure that things are getting sent back and forth. And I don't want you to not have faith in me. It is not my nature to try to get over, misrepresent, or anything like that. It never has been and never will be. And that's the truth. Same thing with the ADA. We may have a difference of opinion on what was said with the ADA officer. But I have my paperwork. I'll be happy to look at yours, and then as reasonable adults, we can come to a reasonable decision. So, if you'd like-
Your choice of words, your carefully chosen words, that you're waiving your right because we may not have provided one, places us in a difficult position.
Not any more difficult than the choice of words that I received from the prior chair when I asked about my due process.
You don't have a right to have 11 people present.
No, that wasn't the reason I
there's
asked for
nothing I
the
can
11
do
people to
about
be
that.
present. It was
I
to provide the
understand
due
why,
Well, then if you do,
sir.
Why are you conflagrating?
Why are you doing it?
Because I'm proving the point that the procedure was rigged before. And that's why it's been changed. And it's been changed because you guys know that it was rigged. And when I told you that it was rigged before,
Mr.
and asked
Garza,
Mr. Nee
Mr.
about
Garza,
it, he never responded.
Mr. Garza?
Yes, ma'am.
We cannot guarantee that there will be 11 people here. Do you need an interpreter in order to have your case heard properly?
No. I can present my case properly.
Then please proceed. You will have 5 minutes.
Thank you. All right. This case concerns the fact that I went to the Haight-Ashbury Medical Free Clinic and got denied medical care, and the fact that I am requesting my medical records so that I can prove that I was denied medical care. In the interim, in the 9 months that have passed, I have gotten a decision from licensing and certification that, yes, I was denied services and that they broke the HIPAA law. HIPAA law refers to personal health information, my personal health information. PHI is how it's referred to. The HIPAA law clearly states, and I have it, that I am entitled to my medical records without having to sign a HIPAA release, clearly. However, everybody is misrepresenting that fact and trying to state that I have got to sign a medical release to get my own records. That is not true. I can point out the law here. Also, I must sign a release for my records to be released to somebody else or for them to receive my records from somebody else, but not for me to receive my own records. I'm entitled to a copy and everything of my own records. And per Haight-Ashbury's own release here, it's all I have to do is, you know, it's the same thing. They say that I don't have to sign to not receive treatment or anything along those lines. So it's exactly the same thing. The law states that I'm entitled to my medical records simply by me asking for them or a copy of them. I can read it specifically to you. Section 16524, right of access, otherwise provided of this section, the individual has a right to access or inspect or obtain a copy of his protected health information about the individual designated record set. So I'm entitled to that. You know, it doesn't say I have to sign a HIPAA release form or anything like that. Also, here is the thing from Haight-Ashbury that says, I understand I have the right to revoke this authorization at any time. I understand that the authorizing of this disclosure of this health information is voluntary. Voluntary, meaning I don't have to sign. Voluntary. On their own form. And yet I was denied my health records. Also, I have off the website from the Privacy Right Clearinghouse that speaks to Impala and medical rights and HIPAA. Do I have to submit a written request for my medical records? HIPAA does not require a written request. However, if your provider requires a written request, you must be given notice of this. So it's only asking about a written request, not a HIPAA release. And when I sunshined them, that was my written request for my medical records. So that's pretty much what I have to say. I'm entitled to everything I've asked for. My medical records are not protected under HIPAA in the fashion to which they're leading you to believe. They know it, I know it. I now have a violation of the HIPAA law from licensing and certification, the agency that regulates them. And I also have a violation for, you know, the denial of services, not providing services. So I don't really think they have anything to say, but I'd like to listen because I've got the paperwork to prove them wrong.
Thank you. Is there anybody in the audience to present facts and evidence in support of the complainant? Seeing none, is the respondent present? You have 5 minutes.
Yes, good afternoon. So...
Pull the mic a little closer to you.
Okay. I did get a copy of the complaint, and Mr. Garza has requested, he did request on, actually it was before December, but he did request a copy of his medical records. First, he asked why. I think he wanted the medical records regarding the denial of services. We sent him a letter on that information that he was denied services due to, actually the letter was sent out to him. He should have a copy, and I could give you guys a copy as well. November 1st, due to the inability to form a consensus about ongoing treatment for both your primary health care and mental health, we regret to inform you that we couldn't continue services with him. He was aware of that. He's gotten a couple of letters. I don't know if I need to give those to you because we had to start this over. So about that, when he did require a copy of this and the entire record, we asked him to sign a release because under HIPAA for medical records, he does need to sign a release. He has access to them, but he does have to sign. It is a requirement of our agency that you can request it verbally, but it has to be in writing so that we can verify that we sent out a copy of the medical records. And we asked Mr. Garza that he would not sign. He sent an email back and forth to our healthcare operations person, and we, again, let him know and mailed to him, and I have a copy. We mailed to him a release for him to sign and send back, and we would be more than happy to give him a copy of his medical records. I have a copy of his medical records today if he's willing to sign a release of information. We have continued to try to get him to sign, and we have had no success. That is the HIPAA requirement. That is a requirement. I'm the compliance director, and so we need that signature to give him a copy of his entire medical record.
Thank you. Is there anybody, I'm sorry, were you done? Yeah. Okay. Is there anybody in the audience to present facts and... Oh, I'm sorry. I think she did, but may not have been in the... Could you identify yourself again for us?
I am Denise Williams. I'm the compliance director for Haight-Ashbury Free Clinics.
And as a point of order, jurisdiction was found in this back when it was first heard. Is there anybody in the audience to present facts and evidence in support of the respondent? Seeing none, the matter is with the task force. It's another HIPAA.
I'll go first.
Member Wolf?
Okay. Okay, first we have to find out whether Haight-Ashbury Free Clinics is what our jurisdiction is under with regards to this nonprofit agency under Sunshine and under 12L. So this is a nonprofit organization that is not a city agency. It receives over $3 million in funds. And under Section 12L of the Administration Code, a nonprofit that receives $250,000 or more in grants from the city is governed by that section. So the Sunshine Ordinance does not, they don't have to comply with Sunshine.
But the 12L.
But 12L, yes. So looking at 12L and what they're required to disclose and make accessible to records, in 12L 5A, public access to records, the only records that's listed here of scope are financial records. Whereas a financial information packet should be more or less be created and should include, at a minimum, the most recent budget as already provided to the city in connection with the nonprofit organization's application for whatever money it gets from them or some contract. Its most recently filed state and federal tax returns, except those that are privileged, any financial audits, and that's it. And then there's just some instructions on how they should be made available. So with regards to medical records are not covered under 12L. Haight-Ashbury Free Clinics is not covered under actually our jurisdiction at all that I can see.
You mean under the
Under 12L.
only 12?
Only 12L. If they had been like Department of Health, then it'd be a completely different story. But this is a private or a non-city agency nonprofit, so I really don't see how, I don't understand how this case got through jurisdiction. I don't know that I was here. I can't, it's hard for me to figure out the dates on this. DCA 3, the date of your memorandum is January 17, 2010. Is that correct?
Through the chair, that is correct. This item actually was previously before the task force, and I believe it was in January. And there was some, I don't believe I was here for that meeting, but my understanding from having reviewed the minutes, I believe, was that the task force considered the matter concluded. Mr. Garza requested from the previous chair that it be put back on the agenda, and the chair agreed to do that with the understanding that the task force preferred to hear the matter on its merits.
Can you just follow me, read the memo that you wrote with me for a second?
Sure.
Because at the top in the heading, it says January 17, 2010.
Oh, it could be 2011. Sorry about that.
It should be 2011?
I think it is, yes.
Okay, all right.
Sorry about that. I missed that part.
Okay, I just want to make sure I wasn't going nuts. Okay, so I'm just a little confused about how this got past jurisdiction. Somebody can enlighten me.
The task force has jurisdiction to hear open records issues under 12L. So it doesn't have to be under the sunshine. They are subject to 12L, and we can determine public records issues under 12L.
Okay, all right, I follow you. Okay, without identifying the actual details of the complaint. I mean, I think it would have been worthwhile. The scope of the complaint doesn't meet jurisdiction necessarily. I mean, I'm happy to go through the exercise, but
I think we already found jurisdiction we've determined.
I understand
it, right?
that.
Okay.
I'm just saying for the future, I think we should.
It is something that the clerk could, mention in the future to the complainants if it's about medical records. But again, it might be something that we have to determine here, depending on what it gets through.
That's fine. That's fine. But I'm ready. That's really all I have to say. Is I made my presentation. I don't see that we can do anything about it. It's not in our jurisdiction. Well, it's not in our authority, our scope.
Well, they don't have. They're not under the Sunshine Ordinance. Only subject to the nonprofit section of it, which is 12L. So, is there any other discussion?
We have jurisdiction. The issue is that they have not. There's no evidence that they violated the disclosure or public document provisions of 12L.
Right.
Can I interject something?
Comment? No, not at this time, but you will have a chance. So, no additional discussion? All right, and this time the respondent and then the complainant will have 3 minutes for rebuttal. Does the respondent have additional comments? Let the record reflect that the respondent did not have additional comments. The complainant will have 3 minutes.
Thank you. In January, and I believe April also, because I have both tapes, when this was tabled against my wishes and I was offered that Hobbesian choice, and I asked Mr. Nee why he was doing this and didn't answer and didn't respond. And in April also, the CEO of Haight-Ashbury got up, and I saw on the tape that they fall under Sunshine, and that it was in their master contract. So for Mr. Wolf to present that it's only about issues of 12L, I find very disingenuous. Very disingenuous. Also, the fact that Sunshine supersedes, supposedly, all other laws when I'm asking for my own medical records, which I'm entitled to. You know, and for that not to be looked into, you know, over 12L, because Sunshine supposedly supersedes all other things. And I believe it was also in April when the chair said that, you know, I could subpoena the master contract to show whether or not they were, you know, under Sunshine. And I think I told Mr. Nee quite clearly that he was inane and that he'd left me no option, because if I was to believe him that I was only entitled to financial records under 12L, I certainly couldn't get their master contract to prove that, yes, they did fall under Sunshine, which is in their master contract, which is what the CEO stated on the tape, and I have those tapes. So for it to be pushed over here into 12L when they have Sunshine requirements and Sunshine obligations. This is the Haight-Ashbury that receives $3 million a year. I was denied health care, and now all of a sudden they don't fall under Sunshine when I'm asking for my own medical records? I guess I don't need the Ethics Commission to screw me too.
DCA 3.
Through the chair, there was another of Mr. Garza's matters that went to, I believe, it was either Complaint Committee or Compliance and Amendments Committee for the enforcement portion of after the order was issued. And Chair's Costas Committee, I believe, and the question had arisen about whether Haight-Ashbury Free Neighborhood Clinic was subject to Sunshine, because Mr. Garza had made this statement previously. And it seemed like a strange thing to me that they would be subject to Sunshine, and so I requested the contract that they signed. The contract that they signed has the standard clause that all city nonprofit contracts have, which says that they're subject to a specific provision of the Sunshine Ordinance, which governs the bidding documents where they obtain the contract. There's no other provision in the contract that says they're subject to Sunshine generally, however. This issue did not come up, is my understanding, in that particular matter, because it had already been determined that they had made a violation, and the task force committee was not going to revisit that issue. But it is an open issue in this case.
So somebody else want, is there anybody else that can, is there anything else to say about this case?
Well, we'd have to take public comment.
Right, okay. I'm just
So is
asking
there any
members.
public comment on this matter? Any general public comment on the matter itself? Seeing none, public comment is closed. Is there a motion? Then this matter is concluded based on the fact that the Haight-Ashbury Free Clinic is only subject to the nonprofit portion, which is 12L, and it doesn't mention medical records. However, it does fall under the federal guidelines, and they do have your medical records here, but it would require signing a HIPAA.
The federal guidelines do not require that, madam.
It's not required? Well, we don't have jurisdiction over that, so I can't. We don't have jurisdiction over that, so I'm being told that there's a dispute whether it's required or not, but we don't have jurisdiction over HIPAA, so this matter is
May I ask you
concluded.
one more question then? If it
Yes.
was required, then why do I have a copy of my own medical records that they gave to me the first day I went in there and I didn't sign the form from them?
I don't have jurisdiction over HIPAA.
It was just a simple question. If it was required,
I don't know. So
It's not required under sunshine. We don't cover HIPAA, we don't cover.
no,
federal-
I understand.
Yeah,
They
so-
receive over $3 million a year, and they're not covered under sunshine. I
Right.
understand.
That's right.
Except 12L. Member, sorry, Member Clerk. Mr. Clerk, would you please call the next item?
Item number 9 is continued hearing on complaint filed by Marlon Crump against the Police Commission for allegedly violating Sunshine Ordinance Sections 67.15D and 67.25.
The complainant, Mr. Crump, I want to double check that the respondent is still not present. Are you here? Okay, you were not here before, but okay. No, earlier when I asked, there was nobody present. So, yeah, for Mr. Crump's case. Oh, all right. We had had a discussion. Mr. Crump even came up here, but he is present. I wanted to make sure that you knew what was going on before we began. You have 5 minutes.
Okay, wait. So before I begin, I was kind of troubled because I didn't know. I mean, you as soon as I walked in, you had X.
We did indeed have you up here speaking.
Okay, so what was it? This is my 3rd time here, and the last 2 times that I was here, Lieutenant Timothy Falvey, every time he spoke, he was going back and forth. It's like his story wasn't getting straight about, as opposed to Mr. Joe Marshall, the Vice President of the Police Commission, interrupted my public testimony a few months ago. Now, I believe you said earlier that, I'm make sure my ears are clean, there's no wax in them, that you guys viewed the video, and that if you saw the video, you would clearly see him. The moment I'm speaking, he starts stuttering about, oh, no, that's not what I meant about, I just want to make sure and then Masuko nudges us, tell him to be quiet. That's exactly what happened. So how can anybody, a public official, public figure, whoever, blatantly lie on national TV as a public broadcast hearing about what he said the previous public testimony hearing before? The Commission Rules of Order specifically says, right there on the item agenda, that he himself proposed, I was there the year he actually proposed it, was that they were not allowed to engage in the public comment. At the same token, no police commissioner is allowed to do the exact same thing. Now, maybe in some cases where maybe they'll make like a brief discussion or something like that, but it's like I said earlier, I don't have time for this anymore. I said this over and over. The man lied. Not only did he interrupt my public comment, but he lied on public television. So that's like, I kind of say that as a form of perjury. You're on national TV, you're a public official, governmental authority figure, and I don't care how he feels about me or anybody else. The truth is the truth. So I don't care how you evade it, I don't care how you dance around it, I don't care how you try to camouflage it, I don't care how you try to, stall it, however you want to word it. But the bottom line is the man lied not only to my face, but to millions of viewers who saw sfgod.tv. So, like I said to Chris Rustum when he sent me that email, I respectfully declined their request for continuance, period. Because for one, I don't appreciate being lied to. It's the same thing when a cop doesn't want a suspect lying to them obstructing. I feel the exact same way. Tell the truth. His face is on TV, his words are on TV. There really shouldn't be any reason why. There really shouldn't be any reason why she even be here. And I understand that you guys want to, view the tape and do the research and then conduct the final analysis on whether or not he, in fact, violated my right as a member of the public to testify. But public testimony. But same token, it's sad that I had to go into a public meeting and feel like my words and my testimony have to be dictated all because someone has mixed feelings or whatever his intentions or motives for being. But I even gave him the opportunity in that email, give a public apology, not just to me, but the kid. Now I dropped the entire matter. They wouldn't even do that. So what does that tell me? That tells me a lot, that they might as well give me the middle finger. A little simple, I'm sorry, and I would have been at home right now watching TV or doing my writing or research or whatever. I don't have time to be going back and forth to prove something that's in blatant black and white. Dr. Joe Marshall, Vice President of the Police Commission, blatantly interrupted me while I was speaking. Now, I've been coming to those meetings for a very long time. I've always given them respect, even though I know some of them were full of it, but I was giving respect no matter what, because I let my personal feelings get involved with what I'm doing. So, not to, sinking you out, Mr. Chan, but you see me at those meetings long enough to know, you see me at those meetings many, many times. You see me, so I just had to single you out. You was over there quiet and stuff. But that's all I have to say at this point. I'm getting ready to make a huge transition, and I don't have time to be coming back to these meetings. It's the last time I'm coming to these meetings. And regardless of what the respondent has to say, the video does not lie. Thank you.
Thank you. Is there anybody in the audience to present facts and evidence in support of the complainant? Seeing none, will the respondent please approach? If you could identify yourself, and you'll have 5 minutes.
All right, good evening. My name's Lieutenant Eric Ventero. I work for the San Francisco Police Department, currently assigned to the Legal Division. I'm here on behalf of the San Francisco Police Commission to defend Dr. Joseph Marshall, our Vice President of the San Francisco Police Commission. I'm filling in for Lieutenant Tim Falvey, who really wanted to be here tonight, but couldn't be here tonight. He had some pre-approved time off, which has been approved for several months. Lieutenant Falvey did request a continuance via email on July 12th. That's well in advance of the 3-day before the meeting requirement. In fact, it's 14 days. Lieutenant Falvey did also participate in both the police commission meetings, which are included in this complaint. He participated in a jurisdictional hearing regarding this complaint on June 14th. He presented arguments on behalf of the police commission and Dr. Joseph Marshall at the June 28th, 2011 Sunshine Ordinance Task Force meeting. I have met with Lieutenant Falvey on several occasions prior to this meeting to prepare for this meeting here tonight. I have reviewed both the DVDs. I've watched them online. They're public record. I have copies of them here in my pocket. I've watched them several times, and I've even brought them here with me tonight in case any of you haven't had an opportunity to view these DVDs, because I think they speak for themselves. I want to put on the record that there is no new testimony. This meeting was continued for the sole purpose of allowing members of the Sunshine Ordinance Task Force to review the videos which were submitted. I have a copy of the letter from the San Francisco Police Commission to Chris Rustum dated June 21st, in which Lieutenant Falvey sent the charter of the City and County of San Francisco and two DVDs of the incidents in question. Here's a letter right here. Okay, also I have a letter from the San Francisco Police Commission dated May 23rd, 2011, to Mr. Chris Rustum from Lieutenant Tim Falvey, which has the direct email link to watch these videos online and a pretty good synopsis of the incidents, which makes it pretty clear that there was no violation. Okay, I wanted to go over some key facts and some points that I think are very important. Okay, at the March 23rd, 2011 meeting, Dr. Marshall merely asked if the author of the letter had made a complaint with the OCC, and that was after Mr. Crump was done. He had left the podium after the public comment section. On April 6, 2011, at the Police Commission meeting, Mr. Crump appears to be done before Mr. Marshall says anything. Mr. Crump said, quote, "I just wanted to address that to each and every one of you, there And to that concern of Mr. Marshall for making that insensitive comment to me a couple of weeks ago, and I felt very disrespected, unquote. He then grabs his paperwork and appears to be done. It's at that point, Dr. Joe Marshall says, if I may, I did not necessarily mean to make the complaint. Quote, if I may, I did not necessarily mean him to make the complaint. A complaint to the OCC does not have to be made by the individual. Anybody, any citizen can make the complaint, unquote. He's merely clarifying for the public that any of them could make a complaint, which is his job as the San Francisco Vice President of the San Francisco Police Commission. It's all about accountability and transparency. At that point, Mr. Crump came back to the podium, or he finished with a comment that stated, quote, but I'm done with that. Thank you for having me speak that testimony, unquote. And that's all he said. He was never cut off. He was given every opportunity to speak. I think the video speaks for itself. If there's one thing I've learned by being a San Francisco police officer is evidence speaks for itself. I have the DVDs with me tonight, and I think they pretty much speak for themselves. And if you've had the opportunity to view them, I think you will clearly see there was no violation. So that is all I have at this time.
Thank you. Is there anybody in the audience to present facts and evidence in support of the respondent? Seeing none, the matter's with the task force. I don't know. I watched the video, and I watched both of them, and there's a couple of issues. It is true that in the first video, Mr. Crump finishes his discussion and walks away from the podium, and he is then called back, and they ask, was a complaint filed? And then they sort of demand that he hand over the letter. Is that so? My concern here is not, it's about what is abridging. Mr. Crump had explained that he was reading the letter because the 14-year-old had had a terrible incident with some police officers, and now the police commission is demanding this letter. So I'm not sure, I don't think it rises to the level of, say, violation along the lines of interrupting. But that's the first meeting. And then the second meeting, he's explaining that he didn't mean that the 14-year-old had to. But my concern here is that, if you're coming before the police commission and they're demanding that you turn over the letter, that can be somewhat intimidating. I don't know if that's something that you want to address. I don't know if you watched the video. Member Costa?
My recollection from the video is that Mr. Crump didn't turn over the letter. Is that right?
It's off camera.
Okay. Mr. Crump, do you remember?
Okay. So let me make it more simple. The first time that I spoke about when I was advocating for the kid, it was off camera. Joe Marshall then, in a very insensitive manner, even his facial features speaks to many elements. He says, "Well, did he make a complaint?" I mean, that was his exact facial features. Then the next meeting.
Did you hand over the letter in that first meeting?
Yeah, I did, only because what's his name at the time, Jeff Gaudon, the interim chief had, I think one of the commissioners had actually told me to direct the matter to him, and so I showed him the letter, but I told him he couldn't keep it because this is the kid's personal property. So what I did was, I gave him contact number for my comrade Junebug, who's happened to be the co-founder of Family Project of Port Magazine. So in other words, I gave him all the contact information to him. So I'm not sure if it was so much as demanding, but I guess more like maybe if I'm concerned about, oh my God, this kid was, traumatized by a police officer in this SO hotel. So let's see if we can get to the bottom. And that is how I took it.
Okay, thank
But,
you.
Okay, thank you.
Yeah.
Is there any further discussion on the task force? Member Snyder?
Mr. Crump, I'm sorry. I have just one question. In your complaint, you alleged both the 6715, which is about the abridgment of the speaking. You also alleged 6725, which is a records request. Did you ever make a records request to the?
No, I did not.
Okay.
For many reasons. I mean, 'cause I figured, I've already heard so many testimonies today about how there's so many barriers in the person getting, documentation. I didn't want to go through all that because, I'm not going through all that.
So what you're alleging is the abridgment of your speaking at the meeting. It's not a records request issue.
No,
Right,
absolutely
fine.
not. Yeah.
Is there any further discussion? At this time, the respondent and then the complainant will have 3 minutes each for rebuttal. Does respondent have 3 minutes?
Thank you. Okay, I think it's obviously clear that there is no violation of 67.25. There was no Public Record Act ever made, and it's also clear there's no violation of 67.15D as far as the abridging. Mr. Crump had every opportunity to speak. He was never interrupted or cut off. By his own admission, if you viewed the tape at the second session, he said he was done with that. I think it's important to note that Mr. Crump made some very serious allegations against members of our department. Primary duty of the San Francisco Police Commission, one of the members of the commission is an OCC representative. Their job is to investigate any type of police misconduct. If you come up to the police commission and make any type of misconduct like that, it's going to raise the attention of all the members. And of course, they're going to inquire about if an OCC complaint has been made. If you view the tape, you do see Mr. Crump hand over the letter to Chief at the time, Go Down. Go Down was seated right over on that side. That is in the tape. I viewed the entire thing. And it was only for the purpose, and that wasn't forcibly handed over. It's for the purpose of investigating these very, very serious allegations. That's the police commission's job. Like I said, a member of that police commission is a member of the OCC. So they're very simply doing their job. That's all I had.
Thank you. The complainant will have 3 minutes.
I'm laughing, but it's really not funny. I mean, it's not really hilarious. But for the officer to come up, the officer just came up here, and he's basically trying to, that's what it seems to me, compiling both events all into one. I'm talking about two separate meetings. The meeting where he blatantly, as I'm speaking, he engaged, we're trying to interrupt, I'm trying to recount what he, quote unquote, clarifying. If you watch the video, you will see Masuko nudging him to tell him to be cool, because he was in violation. That's why Masuko nudged his elbow. So for him to come up here and try to discredit me when it's already on tape, it just shows you that who I'm really dealing with. And as far as me bringing, serious allegations against the department, every single complaint, not just with my own issue, my dark issue with them, which ironically Timothy Falvey was a part of, but that's a different discussion, has always been true. I have never filed a OCC complaint or allegation against an officer if it wasn't true, never, because it's not who I am. So as you can see, they're not getting their story straight. They keep going back and forth, the same thing as Falvey did. I mean, so I'm not sure if any of you are lawyers or anything like that, but you don't have to go to law school, you'd be a legal scholar to figure that one out. I'm like, the video itself shows, unless that's true, the accurate video, shows Marshall trying to engage with me nervously by saying, oh, no, that's not what I meant. I'm like, but that's what you said. I mean, his face was speaking it to itself, his words. So what more proof do you need? I mean, so regardless of what he's talking about, I mean, of course he's on their side. That's how they work. I mean, they all sit together. I mean, that's a common fact. But the bottom line is he should have at least waited till I finished public comment to say that. He did it during my public comment. Big difference. A huge difference. So, like I said, I'm done with the issue. I'm tired of talking about it. As I feel like I'm, speaking to the wall, or I'm talking to myself. Because I don't like the fact that I'm telling somebody the truth, and they're like, so I'm done with that. But he's clearly, misinterpreting the truth, regardless if he's doing it intentionally or unintentionally. Those are two separate meetings. The meeting that I was speaking, that was criticizing Marshall, that's when he interrupted my comment, not when I came up to him about the letter addressed. Two separate incidents, events. So that's all I have to say about that. Thank you.
I have a question, Mr. Crump.
Member Coughlin?
I haven't seen the video, Mr. Crump, but when Dr. Marshall,
all right, you didn't see the video?
Hang on a sec. When he interrupted you, how long did it take for his interruption about?
Well, that's I'm actually glad you actually mentioned that, Miss No Beers. I'm sorry, I misinterpreted your name. Huh? Oh, Kaufman, I'm sorry. My estimated time was about 5 seconds.
Did you get compensatory time for the time that he took away from you?
No, I did not.
So you didn't. Are people allowed to speak? How many minutes at the police commission?
You're allowed 3 minutes. Now,
3 minutes. So
3 minutes.
you got 3 minutes less 5 seconds.
Pretty much.
Is that what you're saying?
Right. Well, I mean, the principle of the matter is he was not supposed to interrupt a member of the public under the commission rules of order, which he himself, ironically, helped propose.
Well, if you interrupt them, you have to give them. You have to give them the time that you took from their public comment.
You got to tell it to them.
He did not do that?
No, he did not.
Mr. I'm sorry, Erickson, is it? I didn't get your last name. Can you speak to that?
Sure. Absolutely. Okay, I'm well aware this is two separate incidents. I brought 2 DVDs right here of each incident. I've reviewed them several times. The second incident he's talking about occurred on April 6, 2011. And per Mr. Crump, he said that Dr. Marshall interrupted him for 5 seconds. After that, and the comment that Dr. Marshall made was made after it appeared as if Mr. Crump was done. Mr. Crump had made the quote. He said, Mr. Crump appeared, he said, quote, "I just wanted to address that to each and every one of you there and to that concern of Mr. Marshall for making that insensitive comment to me a couple of weeks ago, and I felt very disrespected." Okay, he then grabs his paperwork as if he's done and is about to head off the podium. A couple seconds, and that's when Joe Marshall makes the comment, which he does because he cares, and he wants to make sure an OCC complaint was initiated. That's where he goes on to clarify about the OCC process. Okay, after he made that comment, which takes 5 seconds, Mr. Crump comes back and ends with, quote, "But I'm done with that. Thank you for having me speak my testimony," unquote. He has more time. He walks off the podium. If he did have more to say, he was not interrupted. He was not cut off. He was not abridged. He had every opportunity to continue on, but he clearly, by his own statement, said he was done. And you can see that on the DVD, on the video.
So what you're saying is that the extra 5 seconds was available to him if he wanted to take it, but he chose not to? Is
Absolutely.
That what you just said?
There was no bell ringing in the background. There was no buzzer going off. He could have kept speaking.
I see. Okay. Thank you.
Thank you.
Member Wolf?
Mr. Crump, ask you a question. I did see the video, but what I'm concerned about is separate from the video is what your complaint says. Okay? Your complaint, and I have it in front of me in your own handwriting.
Yeah.
It says, Joe Marshall asked me, following my public comment, a rather insensitive question. Quote, did he file a complaint? Question mark, unquote.
Right.
On April 6th, I criticized him for it. Marshall attempted to recant during my public comment.
Right.
So it's you're talking about the second incident, right?
Yes.
Okay.
Yeah.
During your I'm just if you wouldn't mind going there with me.
Sure.
Had he not had he not interrupted you,
Mhm.
how different or where else would your public comment have gone?
Well, I mean, I probably would have came back the next week and criticized him for that. But, the principle of the matter is if he had not interrupted me during the public comment, I would never follow a sunshine ordinance grievance. I wouldn't even be here. But it's a principle of the matter. I mean, it's like, you implement a rule that you expect every member of the public to follow, then you yourself should be following it yourself. I mean, because if the shoes on the shoes on a different foot, he did the exact same thing. He did the exact same thing. I have no doubt in my mind he would do the exact same thing. So this is not really to so much as punish him, but to teach him a lesson as well as any other member on the board that this is a public hearing, so you should respect the person's testimony regardless of how you feel about them. I mean, that's the whole purpose of you even implementing the rules in the first place. I'm like, what makes him any better than anybody else? That the same rule applies to everybody else. That was my entire argument. But every time that I hear them sending new people in, representatives, regardless of who they are, trying to, fabricate and try to manipulate the whole process and evidence by saying, oh, he was saying this or he didn't say that, that's a slap in my face, basically. And like I mentioned before, like last week, this is not about me. This is about the kid. This is what led to this process in the first place. Here's a man who's supposed to be the founder of a youth organization.
I think we're going beyond the scope of the question.
Okay, I'm sorry. I'm going a little bit. You're right.
I
apologize.
Can we go back to the task force, please? Is there any more discussion?
Right. So that was just my. I'm sorry. I didn't mean to go overboard.
I understand, but we can't. We have to.
I understand.
If you could take a seat.
Yeah, sure.
Or no more. Is there any more discussion? Is there any public comment on this case?
Members of the task force, excuse me, Ray Hartz, Director of San Francisco Open Government. As you know, I have my own history with the police commission and the police department. Current President Mizuko was found in violation of my rights by basically telling me I wasn't allowed to criticize their policies. I said, you're violating my constitutional rights. And he stood right there and said, no, I'm not. And it stopped me dead because the simple fact was I thought, who is this guy, and does he really believe that he has the right to limit what I'm here to say? I was amazed to find out later he was a practicing attorney, a member of the California Bar, a former prosecutor. And I'm thinking, what? The guy doesn't even know the Constitution enough to know that he doesn't have a right to stop somebody in a public meeting making comment that is a violation of the Constitution and so forth. I've also had at least 3 experiences with Dr. Marshall, and when Dr. Marshall would tell people, oh, you can talk about the substance of this, but you can't talk about how we handle it or other things. And I'll tell you right now, their practices have been such that they've gotten away with this for a long, long time. Now, I haven't seen this video, so you would be the ones that would have to look at that and say, did that rise to a level where the individual speaking was intimidated or interrupted? And that was part of the conversation we had in my case, which is, what do I have to do? Do I have to fight him? Or do they have to have the sheriff drag me out before it really abridges my right to speak? And I think that one of the things I would like you to keep in mind is that when any member of the public gets up, they're doing something that most people list in one of the top 10 things they hate to do, which is public speaking. And to have a member of a public policy body sitting in a dais above you and then saying something to you in a way that it could be intimidating is a power play. And I think that if it looked to you in the meeting that it was done in such a way that the complainant was interrupted, And I know the Sunshine Ordinance says they have a right to reply, but they're supposed to wait to reply until after the person's finished. Not interrupt them in the middle, because when you're making a statement, you usually have it well thought out, and if somebody stops you in the middle, it interrupts your train of thought and very often throws you off your game. So basically, I think that people should be allowed to continue when they're done with their conversation. The person on the commission has the right to make a comment. That's in the Sunshine Ordinance also, and that would be the appropriate time. So the question also would be, is that what he did, or did he interrupt in the middle when he should have waited until he was finished and then had his or made any comments that he wished to make?
That's what I said.
Thank you. Is there any additional public comment on this case? Seeing none, public comment is closed. The matter is back with the task force. Is there a motion? I will say this was difficult to determine whether the police commission was interrupting out of concern. And I would say to the representative here for the police commission that it's a delicate balance when people are standing before the police commission, depending on what someone says. I realize Mr. Crump is known to the police commission. They were friendly with him. They called him by name. But it is difficult to know when they're concerned and when that might trigger some reaction in a member of the public that does interrupt their public speaking. Member Wolf?
Yeah, I found this kind of difficult because it was happening so quickly during that time. But I do understand Mr. Crump's concern. I'm not quite sure, and maybe I didn't watch it well enough, but I wasn't quite sure that you were, or Mr. Crump was ready to continue to speak. I got the feeling that he was kind of done. So it wasn't kind of clear to me. And so I can ask the police department, I can ask Mr. Crump. I'm going to have to make my own decision at some point or another. What I think is important, though, is that I think Mr. Marshall was a little quick to make a response, and I think it would have been appropriate to ask if the person was done. We frequently do if we're not quite sure. I would urge the EOT committee to engage the police commission, remind them of this particular section, explain to them what some of our experiences are, and and kind of take it down that line. I don't quite. It doesn't rise to enough for a violation for me, but it rises enough to at least remind them and address them that they are there to represent to the public's concerns. That an open meeting is a short time, a few minutes, that a member of the public gets a chance to address them once a month or more. And that they've got to be given every opportunity for that. So that's it.
Is there a motion? Seeing no motion, this matter is concluded. Mr. Clerk, will you read the next item? I'm sorry, Mr. Clerk. I do want to remind the members in the audience that DCA 3 will be leaving in about 5 minutes. If for some reason that concerns you with your case, we can continue it, but he will be leaving in 5 minutes. We do have an attorney on staff, but it's not the city attorney. I mean, as an appointed member. Mr. Clerk, can you please read the next item?
Yes, Madam Chair. Item number 10 is continued hearing on complaint filed by Alicia Gamas against the Department of Public Health for allegedly not providing her with certain documentation and also for allegedly violating open meeting laws.
At this time, the complainant will have 5 minutes to present a case.
Point of order, did you not move, Mr. Wooding?
After the complaints that were...
After 10 or before
after 10, after the complaints that were moved from last month.
Hi there. Just a quick point of information. Have the task force members had an opportunity to review the last hearing for some of them who weren't present, or should I begin where we left off, or should I begin anew?
Well, briefly to recap, the Noise Ordinance Task Force, they did submit a letter admitting. Do people recall the last? I don't think we have to go into quite as much detail of the back and forth that you went on, but perhaps you would like to
reintroduce a bit.
Do a summary of your interactions and the fact that it may sunset.
Sure. Beginning in October of 2010, this all arises, as many of the complaints before you do, from a different substantive issue that then involves documents in public meetings. The issue began in October 2010 when a noisy restaurant opened next door to me and in the same building as one of the people who are here tonight. At that point, I began a number of inquiries with the department regarding their implementation of the noise ordinance. I originally requested, as I began to understand the noise ordinance and see disparity between the implementation of the noise ordinance and the code, I began to ask questions about how it is that the department arrives at a specific interpretation. Was never provided with any such foundation for the actions they take, or the implementations that they claim, or the legislative history they claim, legislative history being something that's actually entered into record, not just a matter of one individual's recollection of, undocumented meetings. At a certain point in time, I had the opportunity, was asked to, for a duty I have, to take a sunshine ordinance training and public records laws training. During that training, I diagnosed a number of violations. I opened up the website of the Noise Ordinance Task Force, and it was a little, case study in failure to comply with any of the the public open records laws. I diagnosed that although I had not necessarily phrased my questions technically perfectly, that the department should have been providing me with information along the way, never had, and it had been many months. I then made I had been working with someone in the mayor's office trying to get information. He had been trying to facilitate things. When I got information that was non-responsive to any of my requests, I made a sunshine records and request, and that is how we arrived here. During the last hearing, Mr. Rivard, who is here for the department, presented his case or his response to it. I will just say that since that time, there have been other requests. For example, my neighbor who is here requested documentation regarding any follow-up, or actually follow-up on a noise report that he made on April 4th. Regarding in specific there, Mr. Rivard had asked the restaurant to, there is a note on the noise survey that says, sent letter to restaurant requesting improvements. My neighbor asked specifically about follow-up. The letter was never provided, and no response was ever provided regarding that follow-up, so the issue continues. They continue to not provide information. And the underlying issue, the substantive issue that caused the need for information in the first place also still remains. It's been a long haul, and I'm eager to help arrive at the right conclusion tonight. One of the things that was brought up last time by Task Force Member Wolf was that the department has acknowledged the violation of the public meetings laws, and that I'm not quite sure whether they acknowledged the violations of the records laws. And I'll stop there.
Okay. Is there anybody in the audience to present facts and evidence in support of the respondent? Of the complainant. I'm sorry.
Hi. I need you to see this was in my head. I'm a cancer survivor.
The first time I lost my hair is when I was going to chemo. 9 months ago, I complained about the noise, and I lost my hair again because of stress. Not only do the Grub have very loud music, the compressor is loud. I'm below, about the restaurant, below the compressor. So, from the compressor, the loud music, and also when they turn on their fan from the kitchen, not only it makes this sound, zzz, it vibrates my whole floor. It makes me dizzy. And every time they slam the door, it shakes my whole apartment. They smoke even though the inspector had told them not to smoke, they've been smoking on the back of my apartment. The problem I have is I asked them, when I came back from the vacation, they already put the compressor on the rooftop. And I asked my landlord, when I called my landlord, do they have the right to put the compressor? My landlord said, I never gave them permission. I never told them anything. So at first, I tried to work with the owner at the Grub restaurant. For 3 months, I put up with them. They come to my apartment at 10 o'clock, 11 o'clock, 12 o'clock, 1 o'clock in the morning, 2 o'clock in the morning. So imagine my own home. Instead of sleeping, they call me, knock on my door. They want to see the compressor. What shocked me is that I took the picture of the compressor. 3 months later, nothing was done about it. There's no soundproof or nothing. The first time I saw the inspector, Tom Robert and Richard Lee, I cannot run. So my roommate ran and asked them, how come you never check up on us? We live about the restaurant. They just look at us, well, it's done deal. And I was really upset that he did came to my house. When he came to my house, I swear to God, he said his equipment wasn't working. The equipment went up to 93. Even though the windows were closed, the compressor were running. That's without the fan from the restaurant turning on. That's without the sound there. But even though he reported that it was only 1442 dBA, it says here, note the perceptible vibration and rattle in the duct. That's the vibration we've been hearing. He said, I later sent to George Nafra requesting improvement in 4/5/2011. We gave them every paperwork I had to my landlord. I never got any paperwork from them. Guess what? What gives them the right to give these people the noise permit if they don't have mechanical, plumbing, electrical permit? I called the building inspector. They had nothing. They have no right to put that compressor on the rooftop. There's no mechanical, there's no electrical, there's no plumbing. In the meantime, when I showed to Tom about my ceiling were all cracking.
Your time is up if you could wrap it up.
Okay.
Quickly.
It fell. The ceiling fell. I could have got killed. I could have got killed and hurt. The building, it wasn't for building inspector, we wouldn't be in this mess. I tried to get a report from them. I only have one report. And they've been coming to my apartment in and out, in and out, in and out. They had to go through my stair to get to the rooftop. Only two now. What is that? And we're not even allowed to look at that report. So I don't know what to say to you, but, you know, I don't want to keep losing my hair. I already got a stroke. I'm a cancer survivor. Thank you.
Thank you.
Madam Chair, I just want to disclose that this person who just testified, she didn't identify herself. I'm not asking her to, so I'm not going to identify her either.
Yeah, that's okay. My name is Morningstar Vance. I live on 756 Valencia Street, about 758 Valencia, which is Grove, and I've been living there for 20 years.
Okay. So I know this person as an acquaintance through various social events, but I don't believe my knowledge and acquaintance of her will bias my decisions in any way. I just wanted to disclose that.
Thank you. The respondent will now.
Can I just disclose something also?
Yes.
I recused myself last time because I've done a lot of noise work with Mr. Rivard, and now that I've heard the woman, Miss Sylvester, speak, I had the same problem with my house, and I'm sort of conflicted as to whether I should recuse myself or not. I found Mr. Rivard to be very helpful in measuring noise, and I understand the problem the woman has is she wants to know their standards and procedures that they use. Is that right, Ms. Sylvester?
Well, Member Cawthon, do you feel that you would be biased?
I feel I would be objective, but I just wanted to mention my background on this issue.
DC3, before you leave, if she recused herself last time, is it more appropriate that she recused herself this time?
Once there's been a vote on recusal, the member is recused and should not participate in the meeting.
Is there anything that we have to do because we didn't because she heard this half of the meeting?
No action has taken at this point. There's been no discussion on it. I think you can proceed.
Thank you very much. I'm sorry, Member Cawthon. We'll have to recuse you again. Member Chan?
I want to make a disclosure too. We've met in a couple of occasions and a lot of other meetings because I'm part of the American Legion. I think she's part of the American Legion too, but it would not affect anything.
Thank you. Member Cawthon is recused and has left the dais. The respondent will have 5 minutes.
Good evening. I'm Tom Rivard for the Department of Public Health. So there's quite a few issues there. It's kind of hard for me to pull it all together in 5 minutes. I'll do the best I can. With respect to...
I'm sorry, can you stop the clock for a second? Can you turn up his microphone a little bit? I noticed that the acoustics change when the air conditioning comes on.
Go ahead.
Thank you.
Is that better?
Yes, much better.
Good.
Please restart the time.
Okay, Tom Rivard for the Department of Public Health. There have been requests for documents. We provided the documents that we had as they became available. More importantly, we even produced documents. We generated new documents that were explanatory and informed many of the legal questions and interpretation issues that Ms. Gammas was concerned about. There may be some concern about timing, whether or not we got the documents to her in the time frame that she thought she should get them. I can say that for the most part, we thought we were operating with the best of intention. We had informed her that at least the most important final document, which is a complete review of the guidelines for restaurant construction, new construction, was provided. She was informed that it was being generated, that it was being worked on. She wasn't given drafts, incrementally as we were making decisions on a daily or weekly basis, but she was informed that the document was being generated and that she would get it when it was done. That's an internal document, not a noise task force document. It's a Department of Public Health document. Prior to that, there were no really definitive documents that described how we interpreted the new ordinance. There was the ordinance itself, which is in many ways very explanatory, but in other ways subject to interpretation. The ordinance itself gives the Department of Public Health the authority to interpret the ordinance and to interpret any issues associated with it. I think that's sort of my overview of the document issue. With respect to the noise task force, it is true we did not know that we were a policy body. We never noticed our meetings to anyone other than the members of the task force. We posted the minutes and the agenda as I had time to do it. It's pretty much an employee-only task force. We don't have any staffing. We do what we can. I can barely pull the group together. It's wide, it's diverse, and it's not well attended. I do the best I can, And if I'd have known that I had a duty to notice them, I would have done it. I've noticed the last meeting, which is going to be September the 15th. And quite frankly, I think we could have benefited from some public participation. I think that some public comment and some public input might have helped us accomplish some of the more challenging goals and objectives that we had. But on the balance, we did what we thought we were supposed to do. I mean, I pretty much, a large portion of the work rode on my shoulders. Because, it's really hard to bring 7 or 8 different departments together to get them sent. Many of them never sent representatives. I did what I could. We're committed to noise control. We're committed to remediating noise problems. But remember, we live in a noisy city. We're in a city that's an entertainment-based city. We have restaurants. Restaurants inherently make noise as part of a mixed-use sort of neighborhood. And it's very challenging to craft middle ground, and we constantly work hard to do that. I've offered Morningstar to call me. I've offered her to email me her specific complaints. I've been in her dwelling. She showed you the document, my inspection form. She certainly has received, she's gone through our files. I have documentation that she's been through our files. So it's not like we're trying to hide anything. It's just that, people are looking for interpretations that suit their point of view. And those don't exist because, the department has to do what it has to do in order to implement its function. And, if there's some questions you have, I'd be happy to answer them.
Thank you. Are you concluded? Okay. Is there anybody in the audience to present facts and evidence in support of respondent? Seeing none, the matter is with the task force. If I could just ask you one question, Mr. Rivard, because it will impact you said that your last meeting is September.
September the 15th.
I was reading your minutes, and it actually says that you have the option of deciding to continue on at that meeting, that you may vote to not sunset in November. Is that accurate?
The board would have to enable us. The Board of Supervisors would have to enable us to continue beyond that.
But there's the possibility that you could ask. It's not an automatic sunset date.
We could ask to extend, but frankly, the membership of the task force no longer wishes to put in the energy to continue it.
Okay, I just wanted to make sure.
We could.
Okay.
That would be. I could go to them and say, can you guys squeeze in another meeting?
Okay, thank you. And task force member Wolf.
Mr. Rivard, before you sit down. So the task force was more or less started when the ordinance was revised, correct?
That's correct.
Okay. So you said in your testimony just before that there was basically no documentation, guidelines, or anything to kind of help you. You kind of like were doing it by the seat of your pants.
No, the ordinance was written.
Right.
And the language is clear to
Okay.
me.
Okay.
But it is subject to interpretation on the part. Others can read words.
But you mentioned that there wasn't any documentation that was available.
That's correct.
Okay, but since 2008, has any documentation? Has notes been taken? Has memos been written? Have you made recommendations to the Board of Supervisors or to other various departments? What's the work of the task force? Is it just discussion?
The work of the task force for the first 2 years was not focused at all upon the ordinance. The work of the task force was focused really upon things like motorcycle noise enforcement, things like backup beepers on garbage trucks,
But how did you enforce those things? Did you go out and stop one motorcycle at a time?
We
or?
brought the police department into our meetings,
Okay.
and we asked them to how could they help with an enforcement program, and we suggested that they try to do that, and they agreed to try.
Okay, was there any documentation?
There's the minutes, there's the agenda and the minutes.
Okay, but there's no other communications involved in like developing a plan or a set of guidelines, or this is how we interpret the ordinance. You know, I mean, for like the sunshine, when you read the sunshine, I'll take the sunshine ordinance, for example. You read the ordinance and it reads pretty clear, but there's a lot of underscore that's in there. There's a lot of interpretation you can make, and we go through it every time we meet. The city attorney's office created what's called the Good Government Guide. That's supposed to help make more light on the sunshine ordinance. Okay, so I'm asking about something like that. What would help the police department, the Department of Health, or this department, or the building inspection department help enforce the ordinance from your task force is by your interpretation, and with all the members of the task force having a discussion about that interpretation, it would seem to have, and I could just imagine it being memorialized. So that's kind of asking, is there anything that memorializes, you know, like, or make any recommendations that were made to the Board of Supervisors regarding changes or?
No recommendations were made regarding the ordinances to the board. We didn't. We were supposed to make a presentation to the board annually, but we never did it because, quite frankly, we hadn't made enough progress.
Okay, so when you
think of this as a very fragile task force.
No, I understand that, but I'm more. Yeah, okay, I understand. So, I mean, if I were to, again, if I were to ask you for documents, you say you probably don't have any, but here's my minutes and here are my agendas.
My minutes, my agendas, I can't think of anything that would be really helpful. I mean, I probably have some emails to the police department saying, I'll meet you to do some motorcycle enforcement at Fisherman's Wharf, but that's not really the kind of things that Ms. Gamez was asking about.
I understand. Well, from what I can gather from what she was asking for, you know, protocols that justified how enforcement is done. I mean,
I think she's looking for restaurant-related enforcement work.
Well, okay, so fine. I mean, when I used to be a peace officer, and there are certain protocols that I had to go through in order to be able to process a particular violation, and I had to be taught and trained how to do that. So if the task force is making an interpretation or is overseeing and trying to get everybody involved to understand that how the ordinance is supposed to work, I mean, to have it all done, it just sounds very arbitrary to me.
What sounds arbitrary?
It sounds like everybody can develop their own interpretation. There's no written guidelines. There's no written protocols on how to perform enforcement.
That's correct.
Really?
Yes.
I don't understand how
That's why we just finished generating a set of guidelines to try to push that issue a little bit further.
But I don't understand how you can then apply the ordinance at all.
We had an ordinance since 1972.
I know, but
there were no guidelines for that.
But that was based on zoning, was it not?
Yes.
And planning is very involved in zoning, and the zones are very specific.
That's correct.
Okay, so there you have more involvement. Here, this is much more ethereal to me.
I don't think it's much more ethereal.
Well, it's not specific as to particular kinds of locations or interactions that.
All I can respond to you is that there are no guideline documents other than the one that we produced about a month and a half, 2 months ago.
Okay.
Okay. There may be things that are out in the ether that I can't remember. I can't say unequivocally that you couldn't find an email from one staff person who I don't know to some other staff person, or that within the Entertainment Commission there may be amongst them they might have discussed it. but I don't have anything that I can provide.
Let me ask another question. I report that there's noise in my building, totally residential building. I call the police department.
Right.
Okay. How do they apply the new ordinance? How are they supposed to apply? And if they apply it one way, and then I disagree with the way they applied it, who do I come to the task force?
The police do not apply generally the noise control ordinance as part of their work.
Who does?
They go out and do enforcement, but they don't know how to work the ordinance.
Okay.
I mean,
if I may, just for one moment, some of what you're saying is addressed by the fact that it hasn't been treated by Sunshine at all. So there is nobody to ask them for the documents or to make these kinds of demands. So since there's no Sunshine at all.
Okay.
The ordinance was written before the Sunshine.
I'm talking about your task force
No,
operations in general.
2008 we're talking about,
Right.
not prior to the revision, the reform.
So if you, for example, we have to write different things and the public makes demands on us, but since you didn't have the public, some of the things that Member Wolf is asking about
might have come up.
Yeah.
They probably would have come up.
Yeah, it just seems, I just am a little befuddled, that's all.
Member Costa, did you have?
Just to clarify, so even if there weren't written guidelines, the sort of guidelines that were developed at these meetings nonetheless. Is that correct?
No,
Through discussion or?
The guidelines were developed not at the task force, but within the Department of Public
Within
Health.
the department.
Okay, we did bring them to the task force, the draft.
At meetings of the task force.
At some of the later meetings. I can't remember exactly which meeting, but it's in the minutes when they were provided copies to look at.
So when Ms. Gomez made a request about the sort of interpretation of the of the ordinance or of these guidelines, whatever, did you provide her with those minutes or point her to that agenda item as like sort of that being the moment that this interpretation was established?
Well, the interpretation wasn't established. That was being shared with the noise task force. Okay, I tried to share with them the things that we were working on within the department. The Department of Public Health makes the decision as to how the ordinance is to be interpreted. I tried to be open with the other members of the task force about the things we were working on. Whether or not, if Ms. Gammas had been at the meetings, she would have gotten a copy, probably seen it there. We had told her that it was coming and we were going to give her a finished copy when it was done. Okay, she didn't have the benefit of the drafts. Of course, the drafts look very little like the finished product because much of the drafts were amended and changed.
Thank you. Is there any other discussion at this time?
Ms. Gamez? Okay, so as best as I can try to ascertain, there's no documentation from the task force.
Well, my request was not limited to the task force.
I understand that, okay, but we're here and your complaint is against the task force.
No, it's broader than that. I asked the department, and then the task force, the complaint regarding the task force is that it was the meetings were never open to the public as they should have been. However, I requested to the department.
Hold on one second. Mr. Rivard, is the task force under DPH, correct?
No, it's not.
It's not under DPH.
It's under the environmental health part of DPH, but it's created by the police code.
It's created by the police code. It's a Board of Supervisors Noise Task Force.
It's under the environmental health. This is from your website.
We support, environmental health supports the task force, but they don't, the task force does not have its own website.
No, but this is from the Department of Public Health. It says it's under your environmental health and OSH.
In our memorandum, it says the Noise Ordinance Task Force is a body created by the DPH.
Yeah, this is the Department of Public Health's website, and this is what the Noise Task Force is. And it's under, it provides consultation services and assistance to the Director of Public Health.
Yeah, it was created by DPH as directed by the police code.
Well, that would be that would be incorrect. The task force was created by the police code, by an action of the Board of
Supervisors.
And that website
Okay.
doesn't describe exactly what happened in a manner that would be germane for you.
This is not
But-
correct. Okay. All right. Thank you, Ms. Gamez.
Could I speak one thing real quick? Section 2918 of the police code says the Director of Public Health shall convene and coordinate an interdependent departmental task force for the purpose of coordinating and da-da-da-da-da. It's under the Director of Public Health.
Okay. That's helpful. My concern right now is based upon your complaint. We already are, I think, we'll talk a little bit about public meetings and the lack of them, and I think we're all pretty much on the same page on that part. But let's talk about the documents that you requested. And I'm not sure that, because most of your requests were made to Mr. Bhatia.
Who is Mr. Rivard's superior.
Right.
Mhm.
I'm not,
Okay.
I'm familiar with him. I'm wondering whether Mr. Rivard is the correct person to be here to answer the questions.
Well, I did, Mr. Rivard was CC'd on everything. I don't know if that's material for you. And then also, he was named on the Sunshine.
I understand that.
Okay.
The question is knowledge.
Oh.
Okay, we require a respondent to have knowledge of what the complaint is about.
Right.
If the respondent that's here is not knowledgeable, then the department didn't send the right person. And if you're directing, it's why it's a little hard for us when a complaint comes against a department, because departments are not people.
Sure.
And Sunshine applies to people having documents. So the question is who's this being directed to, and on a regular basis that is supposed to provide you with these documents. It looks like it is Dr. Bhatia.
Mr. Rivard is the, when I had a conversation with Dr. Bhatia, I sort of educated him on it, and he deferred, everyone defers to Mr. Rivard on the noise ordinance. I think the department has probably sent the person who is most knowledgeable about it.
I just want to refer to, it looks like a May 2nd email.
Do you have an approximate?
Well, I'm reading it from notes, but
Okay, I'll leaf as you speak.
This was May 2nd page.
We don't have the full.
Yeah, I don't know. Well,
But go ahead. I may be familiar enough.
Okay, so basically it says you ask a question, quote, can you please respond as to each part of your department's procedures and how they relate to or depart from the noise ordinance? For example, you acknowledge that you disregard the noise ordinance's definitions of residential property. Please explain on what authority you, period, close quote. And on the same day, Mr. Bhatia replied some written answers, which have been paraphrased here in my notes. As we've consulted with the Office of the City Attorney, confirmed that our approach is abiding by the terms of the noise ordinance. The second bullet, question 1 and 2, staff used the noise measurement methods as specified in the ordinance. The ordinance is clear about these methods. And 3, Grubb has met the performance standards specified by the ordinance with a viable, acceptable set of methods. Department is not proscriptive with regards to the methods, only performance standards. Okay, so to me reading that, it sounds like, have you received any documents with regards to that kind of information? Through Mr. Bhatia? Because that's where most of the discussion back and forth is.
Right. I'm not sure if I'm fully understanding.
Well, let me ask you this. Have you received any documents?
I have received mostly my own emails with the department, but some other things, a noise survey, sort of although they've come out many times, they have produced only a handful, like literally 2 reports, noise reports. So when you explained that when you were a police officer, you had they only produce 2 of reports out of many written reports when they've come out. That is among it. My question regarding, Dr. Bhatia's response regarding implementation according to a certain code section, he doesn't name the code section, and so I don't know what he's talking about, because they don't. If you actually look at the code and you say, you apply, he says in one of his emails, probably referenced there, we applied a mixed-use standard, which means there are only 2 standards, a low one for residents and a high for commercial. They apply what they call a mixed-use standard, which is actually the commercial standard, to what would be defined as residential by the code section. And I've asked them to provide any basis for that sort of what they call interpretation. They have offered none. Mr. Rivard described that as having come from the legislative history, but the legislative history, as he described, actually was a history of moving away from zoning definitions into a standalone.
We know most of that. Mr. Rivard, let me ask you something. If you look on page 102 of our agenda, do you have that?
No, I don't.
You do or don't?
I do not.
You do not. I just want to show you, and I can't, there's this reference, it's probably in the previous agenda, but the reference that our legal counsel has pulled from the emails on page 102, if you look at the 3 bullets, and it says, the first bullet says, we've consulted with the city attorney and have confirmed that our approach is abiding by the terms of the noise ordinance. That wouldn't necessarily just be a verbal response. The city attorney probably would have put in writing that, you're doing this right, you're doing this right, you're doing this right in writing. Is that something that you know about?
Those are privileged communications between the department and the city attorney's office.
How is it privileged?
Because they're ongoing conversations that we have, sometimes by email, between the department and the city attorney's office. It's my understanding that city attorney communications, when we're trying to understand the law or interpret it, are privileged.
You would have to cite a section of the Sunshine Ordinance for that to be.
Well, I rely upon the guidance that I receive from the city attorney's office. I do what I'm told on that issue.
Okay. The way it works is we assume everything to be public unless otherwise cited that it's not. That's how the ordinance is written, and that's how we keep everything
Maybe we do
public.
need the city attorney's office to be here.
Okay.
If I may, I think that you're getting into some minutia that would be, again, they pretty much violated the entire Sunshine Ordinance. So we're gonna have to find a violation that's related to the entire thing. I mean, they're making recommendations. I'm not making an accusation that you knew, but I mean, it is what it is. You were created under an ordinance, and whether the people who created this particular body knew that that's what they were doing or intended. I mean, that is what they did. Mm-hmm. So, they're in violation, and we, one of the hard parts about it is that we don't, Mr. Rivard had made reference to perhaps there may be some kind of emails between him and somebody else. We don't know, but someone's got to address this bigger than us.
I understand that. The reason why I'm going down this road is because it's not specific to the task force that these questions are. Ms. Gamez continues to say that she's being referred to Mr. Rivard by Dr. Bhatia.
Right.
Okay, but the enforcement, according to Mr. Rivard, is handled by DPH. So, if the question to Mr. Rivard is he aware or does he know of any documents not within the task force but that exist anywhere, DPH or what have you?
We generated a complete restaurant enforcement guidance document, which was provided to Ms. Gamez.
Okay.
Yes.
All right. Let's not. We don't want to have side conversations, but I'll ask for Ms. Gamez's response on that in a moment. I just because
I emailed that to her.
Okay.
I think Dr. Bhatia and Mr. Rivard have both been on notice. He's been here. Mr. Bhatia responded to the complaint.
Mm-hmm.
So even if you find that there are documents, I mean, they still violated the documents. So if we could try to, it's a big, huge scope of.
Well, if you look on page 100, there's the beginning of the list.
So my concern is, we're going to have to send this somewhere to try to
I think this is
determine that it's not just documents. I mean, the Board of Supervisors needs to be notified that whatever they receive has had zero public input. Whether it's intentional or unintentional, it is, and they acted on that belief. So we definitely are going to, need to notify a variety of people of all of these violations. We may or may not be able to name specific documents, but someone needs to start monitoring it. And I think if both of them are going to be involved, both of them people that you're, Dr. Bhatia and Mr. Rivard. And they've both been on notice. I mean, Mr. Rivard's here, but if you look on page 101, it says, Mr. Bhatia emailed response to complainant, so everybody is aware.
The complaint on 111 names Dr. Bhatia, so he's part of the complaint.
So if I'm just trying to focus us on the fact that we're going to have to find a big, broad, and think about, we're going to find a lot of sections in violation and try to think about where we can send that and how we can move this forward. I feel like we're going to have some kind of violation. But Member Washburn?
I'm wondering about...
Microphone.
I'm sorry. Just making some determination about specific sections that were violated and then send this to compliance and amendment, giving the department, Dr. Bhatia and Mr. Rivard, some time to develop a plan for addressing this. And also, what's occurred to me is, has this happened
anywhere else?
Anywhere else? Because I really truly believe this wasn't intentional at all. But I just wonder.
Yeah.
Are there other task forces in this city operating?
All right. So I'm gonna ask you two to sit down and relax. I think what we need to do is, as a body, should we? Well, let's see. Where are we in the process right now? We have to get to public.
Well, we don't have a motion, so we could have public comment if we had a motion. Otherwise, we'll do rebuttal and then public comment.
Let's do rebuttal. And then we'll talk about the items I want to hear.
Does anybody else have any questions to that? Okay, so we're going to do rebuttal. It's respondent and then complainant. You'll each have 3 minutes.
If you have anything more to say.
If you have anything to say in rebuttal. Although if we're going to make a motion, I'm reluctant to do this immediately. If we know we're going to make some kind of a motion.
You got to provide them with rebuttal first.
Before we make a motion?
Oh, yeah.
Okay.
Mm-hmm.
Go ahead, Mr. Rivard, I'm sorry.
I think a few things I think that would be helpful is that if that if you're able to separate the fact that there's the noise task force, which didn't have the proper amount of public input, for sure. I mean, I certainly agree with you on that, and it's regrettable. And then there's the documents requests that have been made that are not related to the noise task force at all, but are related to how the Department of Public Health enforces the noise control ordinance. I think that we did a pretty good job of providing the documents that were requested around how we do our work. Quite frankly, there weren't many to give in the beginning. There was the ordinance itself. There were some conversations that I had multiple conversations, or at least one conversation with Ms. Gammas on the phone, I think two. We've made ourselves available to Ms. Vansel. We've tried to be, so that part, I think, the document provision part, I think that we've done a good job on. I don't think we've done a good job on the noise task force in terms of the sunshine ordinance, and I think that we probably have some ideas about what we could do to mitigate that. We certainly, if to the extent that we were to move forward with any amendments to the ordinance, we'd have public hearings about that, either through the Health Commission or through some other avenue. The department itself would generate multiple public hearings to receive public input prior to making any recommendations to the board for any changes in the ordinance, because we realize that there hasn't been adequate opportunity for that to happen. And we'd be happy to cooperate with your, with the Sunshine Ordinance Task Force in terms of trying to craft some sort of approach to that. But I don't think there's any, other than we did create a new document, which we provided to Ms. Gammas, that really answers the bulk of the questions that she had. So she has a detailed written document, 4 pages long, probably 2 of high detail about the issues she was concerned about.
Thank you. The respondent will have 3 minutes.
I'd like to begin by saying, first, let's please not make the assumption that this was unintentional. I would ask you to take the fact that there is a public website that was not acted on, and that they were posting agenda and minutes but not having public meetings, are probably more symptoms of the fact that someone knew that they should have been having public meetings, but they just didn't bother. In the conversation, and I recall only one that I had with Mr. Rivard, he informed me that, I explained to him my understanding of what I had read in the code and asked him how could you possibly arrive at the determinations you're making given this? And he explained to me that if the code said what I said it said, that it would matter, that he wrote the code is what he thinks it is, and if the code says something different, it doesn't matter. I asked for an appeal. I asked how to do it, and he said there is no appeal process under the noise ordinance. So you, Task Force Member Wolf, when you asked the question about if I had an objection to a determination, what could I do? The answer is nothing. Mr. Rivard had absolute authority and imagined himself to have no opportunity for anyone to object. And he was quite clear on that with me. So whether it was an intentional or unintentional failure to observe open meetings with the task force doesn't matter, I think, because he was very clear that he was enjoying absolute autonomy on how he imagined the task force, the noise ordinance. I asked for documentation to provide any basis for the changes he was making. He has never provided any. The procedures that he described, and actually, I'll correct myself, I don't recall whether you emailed that to me, but I do recall finding that it had been in existence for over 2 months when it was finally given to me. It was in the minutes of reference in the minutes of the April task force, and it was provided to me sometime soon before, I think, the first hearing that I attended here. Again, Mr. Rivard has made certain determinations that are harming, for example, Morningstar's life and health and well-being. It took an extraordinary amount of effort to have him revisit that, and he did for some period of time say he would come out and do more tests. He has since rescinded that request or that offer, and he is now refusing to come to Morningstar's apartment and retest. For example, another issue is the noise survey that he did in Morningstar's apartment provided no documentation, no citation for how that noise survey found compliance. It just found compliance. I asked for information regarding what code section would find this in compliance. The code section sent by Dr. Bhatia through the mayor's office representative, actually the test was not taken in compliance with that section. That section requires that you test with windows open. The windows were closed when he tested. That section applies exclusively to residential property. They have already made the determination that that property is commercial. Therefore, that section shouldn't apply at all.
If you could wrap it up.
Yeah, and so the point is, there is a long history and a continuing history of noncompliance, of refusal to hear public, and I would say, in my treatment, contempt for public comment.
Thank you. The matter is back with the task force. I'm sorry, you spoke on behalf of the. You spoke on behalf of the complainant, so you can't speak at public comment. But it's not public comment now.
Okay, that's what I'm doing.
No, we're not having public comment now.
No, it's the.
You. Only one person can speak. You spoke on behalf. I'm sorry.
It's just rebuttal. It's just one person. That's all.
Matter is back with the task force.
Hold on, I'm trying to get a thought here.
Yeah, I see him. Member West?
I have one question for the chair, which is, for the task force generally, which is that if the complaint is brought against the Department of Public Health, but the Noise Ordinance Task Force is actually a body under the Board of Supervisors, would the complaint have to be refiled?
No, read the complaint.
Okay.
The
complaint is against two people.
Okay, thanks.
Okay.
Member Wolf?
All right, so I think what we need to do is we need to at least go over what's on page 100 at the bottom. I think the listing of all these codes are correct. Is there anything that may be missing? I mean, it's so comprehensive, you know, it almost. We can just move on those. And
is
then
there public access in here? Is that?
Public testimony at meetings.
Is that what that's under?
Are you asking me if it's listed here?
Because there's also 6713 barriers to attendance prohibited. I'm not sure
Okay.
about that.
If you want to add that.
67.9 is agendas and related materials, public records.
What's 67.7?
Agenda requirements, regular meetings.
Yeah, and then 67.7-1 is public notice. Doesn't that cover?
Public notice requirements.
Doesn't that cover kind of 9? 67.9?
Well, this is about having 67.9 is about having agendas of meetings and any other documents on file with the clerk of the policy body. Records are subject to disclosure.
Agenda posting is covered also, or maybe better by the Brown Act, which DCA 3 laid out on 101, page 101.
I think we should include those in addition.
Yeah,
Yeah.
that's what I was saying. But I'm just saying for the ordinance, Gotcha. Because there are items not contained in CPRA. Just want to make sure we get all of them, and it's.
Well, since 67.9 applies specifically to policy bodies,
okay,
it talks about they can charge a duplication fee.
Okay. So it's an active.
It's
active. All right, then we have 62 page, the top of page 101. Is there anything else?
Well, the other thing that I'm not sure. I guess as it goes to compliance and amendments, there are procedural things like closed sessions. I mean, they haven't violated a closed session. In a way, they have because they've all been closed, but they will be subject to that. So I just want to make sure that we include, in our meaning of what you're going through in the specific numbers that, they're under the entire ordinance. They're subject to all of the rules and regulations therein. And so that's going to apply to closed sessions. It's going to apply to all the little things that sometimes you might not necessarily find a violation of, but they're still required to follow them. The index of records,
well,
the seriatim meetings.
I understand that, but when you take into account like 6721, it was a request for records. They did provide. They did, do some diligence in providing some records. So, you can't throw the entire kitchen sink at it because there was some activity. It wasn't like, Well,
I just want to make sure that the idea is that they're subject to the entire ordinance, but specifically these violations, if that's... Okay, then we'll do it that way, although I would like to add 67.9.
Okay, I have 9 and 13. Okay. All right, and then on the top of 101, we have CPRA, California Public Records Act, Section 6253, which is also more or less repeated in the Sunshine Ordinance. And then the Brown Act itself, which regards open meetings. And that's the basis, these two items are the basis of the Sunshine Ordinance. Is there anything else?
Yeah, there's one more.
What's, okay.
67.29-7, that the mayor and all department heads shall maintain and preserve in a professional and business-like manner all documents and correspondence, including but not limited to. Since I believe that Dr. Batia falls under department head?
It falls under what?
The department head category?
Yes.
Okay.
That's my understanding. Okay.
Anybody else?
Is that it? All right. So I want to.
Are you going to make a motion?
Yeah, but the thing is I'm thinking. In my motion, I want to address only the activity of the task force itself. As far as any other documents are concerned, I would prefer if that be dealt with in a separate motion with separate discussion.
I'm not quite clear on.
So I see that there are two, as Mr. Rivard has suggested, the request for documents is really more from the Department of Health, not from the task force itself, because of the way I've been reading Dr. Batia's comments. It's more about his interpretation and how his department deals with these items versus not referring. He doesn't just refer to the noise task force in every communique. He, basically answers the questions and then goes on to say at some point on May 4th, your comments are noted. I will have no further responses. He just.
I understand what you're saying. You're saying that the Department of Public Health already knows it's subject to the Sunshine Ordinance.
Right.
So you're saying that you're going to make a motion. I think you can do it in one motion. A motion for the Department of Public Health with the records, unless you want to break it
I-
into two because you want the compliance and amendments to hear it in two.
Yeah, I think the
All right,
compliance
let's-
and amendments need to deal with the noise ordinance task force separately, and that, because that's just an element unto itself.
Okay, I suggest that you begin with the documents, the DPH. Do you
No,
wanna
I'm going to
with that?
begin, and I think it's
Okay.
easier to do the other way around.
Whatever
So
you're prepared
I'll
to
find, I move to find a violation of the noise ordinance task force in section 67.6. Well, I'm going to have to do it to you, Mr. Rivard, since you represent the task force. So this is in violation of 67.6, 67.9, I'm sorry, 67.6.7, .7-1, .9, .13, .15, .16, .21, .22, .25, .26, .27, .29-7. I know it sounds like a lot, but it's just because if there's not been any compliance. It just covers the gamut. That's all. It's just a big bucket. And then further, California Public Records Act of the Government Code, Section 6253. And then again, the California Government Code is the Brown Act, Sections 54953, 954, 954.2, and 954.3. And that would be referred to compliance and amendments.
Member Wolf, would you, I'm sorry, would you repeat if you named Mr. Rivard?
I named Mr. Rivard.
Thank you.
And the Noise Ordinance Task Force. With a recommendation to the Compliance and Amendments Committee that a letter be considered to that would end up being a recommendation back to us, a letter to the Board of Supervisors and the mayor with a concern that the ordinance is being enforced without any guidelines, and that any recommendations, plus any recommendations that were made to them, that they have correspondence with the task force, if there was any correspondence. And I believe I've heard in Mr. Rivard's testimony that there were no recommendations made to the Board of Supervisors at all, right? So, but we don't, the question is that Mr. Rivard is here, but Dr. Bhatia is not. And so we don't know on that end, since the claim is that the ordinance was written by Dr. Bhatia, and he's the one that is making the rules around it. We don't know. So that's it for the Noise Ordinance Task Force.
Is there a second?
A second.
Is your discussion on the motion? Member Costa?
I just want to make sure that we definitely feel like this is something that needs to go to the Compliance and Amendments Committee. If it's going to end up being something that has to come back here, that we not just sort of take that action and say that we're going to write the letter now as opposed to after the Compliance and Amendments Committee, especially because, just one other point, it sounds like they're set to sunset the task force in September, and I think so it might just be an issue of timeliness.
Yeah, one thing I was thinking when I was about that is that what is your intent to have the Compliance and Amendments Committee monitor? What would you want them to monitor? Are you asking the Noise Ordinance Task Force to provide some documentation that they've coordinated to begin the Sunshine Ordinance?
Well, I think it would be, now that they're aware of it, that they are following the proper procedures. I mean, probably EOT could be involved too, but I think people are well aware. It sounds like from some of the communications, people are well aware of how Sunshine works. So I think it's just a matter of compliance amendments saying, okay, let's make sure you're doing this, 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 and this, kind of a punch list, and making sure that they've at least through November, and then if there is any like prior agendas or minutes or anything, other documentation that needs to be provided.
So I would like to make just a friendly amendment to add that in addition to those violations, sending it to the Compliance and Amendments Committee with the idea that we want to see some sort of specific documentation that you're acknowledging and making the people like the Board of Supervisors and the Director of the Public Health that this is going on, some communications, that would be something that the Compliance and Amendments Committee would need to see, not another back and forth argument, but something that we could see that people are being made aware of what Member Wolf just said. So I'm not exactly sure how to put that in the motion, but with documentation that the Sunshine Ordinance is, that you're
complied with.
It's not that it's being complied with, but that you've made the people you report to aware that you haven't done it, that you've been in violation. So I'd like to see the Noise Ordinance Task Force tell the Board of Supervisors and tell the Department of Public Health that no public input has been going on and you're concerned about it. So the Compliance and Amendments Committee, we find these violations, but we need to see how they're being, we need to see some real documentation of how they're being fixed. And one of the things that is a concern is that the people they're reporting to need to know that this was a mistake that had occurred and that it needs to be repaired. So maybe we could add to the motion the violations and
That was kind of my...
a notice that this has gone on to the people you report to.
So you're asking that the Noise Ordinance Task Force send out the notice?
Yes.
I see. Okay. So the question is I don't know that we can order that. We can make the notice. We
So
can
we can send it to
notify,
the
we can
compliance.
send out a system-wide communique, that a memo that DCA3 can draft, that this occurrence has happened,
Then
and that people should be aware of it.
I would agree with that. We can, I would make that my amendment if you're
Okay, yeah,
open to
I'm
it.
fine with that.
So then it
That's-
would be to find a violation of all these things, send it to Compliance and Amendments with a notice from us, the task force, that this is going on to the Board of Supervisors and the Department of Public Health. I mean,
Well,
what does it say
I
that
was
they-
saying,
to the Director of Public Health, who is Barbara Garcia.
okay. And I would say to Board of Supervisors and the mayor,
Yep, we can.
they should be made aware of that.
Did you get all that, Chris?
Um,
And does the second accept?
Okay.
And the maker of the motion?
Yeah,
Yeah,
I'm
okay.
fine. So that's it. So ready for public comment, and then we can get to the next part.
Is there public comment on the motion?
Public comment on the motion. I don't know if you want to go back into a lengthy conversation about how to amend the motion, but if you're going to notify the mayor and the Board of Soups that as a policy body, the Noise Ordinance Task Force hadn't been actually holding public meetings, but they somehow developed agendas and minutes that were retroactively posted on a DPH website. I'm not clear how they could be posting an agenda and putting on the agenda, well, but the public's not welcome to come. You know, I don't get that part. So on page 100 in Mr. Threet's instructional, the jurisdiction says NOTF is a body created by DPH and that it is, in fact, a policy body. I'm hoping this task force has the institutional memory to remember that I've been here before about various subcommittees of various advisory bodies, the Department of Public Health, who have a long, long, nasty record of agenda and minutes violations. Similarly, the Mayor's Long-Term Care Coordinating Council also asserts over and over, oh, we're not a policy body, we're a passive meeting body. And I know that your proposed revisions to the ordinance is going to take away, hopefully, that distinction between passive bodies, advisory bodies, and policy bodies. But DPH violates over and over and over agenda requirements. They lump things together in a great big single item without sufficient detail to explain to the public what is actually going to be discussed, because they camouflage that on the agenda. So if there's some way that you could amend your motion to alert the mayor and the Board of Supervisors that this is a long continuing practice of the Department of Public Health and possibly a management style that is preferred by Dr. Katz, Barbara Garcia, the leadership of DPH, that they just think they can get away with this, right? You need to let the mayor know in the strongest possible terms. It's an institutional problem at DPH. Thank you.
Thank you. Is there additional public comment? I'm sorry, Morningstar, you spoke on behalf of the complainant, so we can't have you as public comment. Is there additional public comment? Seeing none, the matter's back with the task force. Is there discussion on the motion? Mr. Clerk, will you please call the roll on the motion?
Yes, Madam Chair. On the motion, Member Snyder. Snyder absent. Member Cotton. Cotton recused. Member Manny.
Aye.
Manny, aye. Member Washburn.
Aye.
Washburn, aye. Member Costa.
Aye.
Costa, aye. Member Wolf.
Aye.
Wolf, aye. Member Chan.
Aye.
Chan, aye. Member West.
Aye.
West, aye. Member Johnson.
Aye.
Johnson, aye. Madam Chair, the motion passes. We have 7 ayes.
Member Wolf, did you want to make the second motion?
Oh, actually, I was hoping somebody else
Oh,
would.
you want somebody else to
Because
make it?
yeah, this is the part I prepared for.
You want to make I can make. I'll make a motion to. I'll entertain the motion. I'll make a motion to fine the Department of Public Health and Rajiv, as I say it, Bhatia, Dr. Bhatia, in violation of 6721, 6722.
Hold on.
Oh, so we have to do one more motion.
So we're not quite finished. Sorry. 67.
What is it? It's 6721, 6722. That's the oral public information. 6725 is the immediacy of response. 6726 governs the withholding of records, and 6727 governs justification for withholding of records. I don't know if you want to put in the California Public Records Act, but I think DPH knows that it's covered under sunshine, so it's a little bit different from the other one.
Right.
Is there a second?
Second.
Discussion? Is there public comment on the second motion? Seeing none, public comment is closed. Mr. Clerk, will you, I'm sorry, it's back with the task force. Is there any discussion? Mr. Clerk, will you please call the roll on the second motion?
Yes, Madam Chair. On the second motion, Member Snyder. Snyder absent. Member Cotton. Cotton recused. Member Manny.
Aye.
Manny, aye. Member Washburn.
Aye.
Washburn, aye. Member Costa.
Aye.
Costa, aye. Member Wolf.
Aye.
Wolf, aye. Member Chan. Chan, aye. Member West.
Aye.
West, aye. Member Johnson.
Aye.
Johnson, aye. Madam Chair.
Before you.
Well, I failed to say that to send it to compliance and amendments. I don't know if you want to.
I think it's obvious.
recall, was the intent because it was following the second one. I don't know if you want to revote or can you do that without objection? Okay,
We have 7 ayes, the motion passes.
thank you. Can somebody tell Member Coffin?
Okay.
Are we losing a quorum?
I don't think so.
We have one more case that we had somebody wait here a really long time who we actually moved ahead. So I'm hoping we can keep our quorum for.
Should be able to. I think we have 7.
Family's got to go.
7,
Dave
but
left.
Bruce and Kaufman.
Family's leaving.
Bruce and Member Kaufman are both here.
Mr. Clerk, will you please call the next item?
The next item is
Before we do that, I just want to make sure that everybody following that item knows we have to leave here at 11. We may not get to your complaint. The next one is Mr. Wooding. It's item number 21. In the beginning of the meeting, we moved that up.
Madam Chair, it's 23 and 24.
Item number 23.
Is there any, you want, the task force, I'm sorry, Mr. Wooding. The task force is requesting that I ask people if they would like to continue now. Anybody that's following Mr. Wooding?
I'd like to continue.
Oh, you would?
Yeah. Well, I want.
No. Oh, no, I'm sorry. I'm asking other people if they'd like to continue to the next meeting. We are going ahead with yours, but I just want to give them the opportunity. Seeing.
Maybe I should sit down.
Well, you can wait and see if we can get to it, although I doubt it. So I didn't want you to have to sit here through this if you didn't want to when we continue it. The next meeting's after that. It's August 23rd. We can try to call a special meeting, but I cannot guarantee it because I'd have to try to get everybody here.
August 11th?
Again, we do have to get to Mr. Wooding. So this is one of those things where we can try to call a special meeting, but we couldn't do it right this minute. So I couldn't give you an answer till after Mr. Wooding's case, which I do not know how long it will take. I apologize to the people who've been waiting. Is that microphone on?
Can you hear me? Yeah, okay, great.
Did you read the item? We have to read the item first. I'm sorry, Mr. Wooding.
Item number 23 is determination of jurisdiction on complaint filed by George Wooding against the Recreation and Park Department for allegedly withholding correspondence.
Thank you very much. Good evening, Chair Johnson and task force members. I'm George Wooding. Because RPD has not contested jurisdiction of this Sunshine complaint, and because Deputy City Attorney Threet indicated in his instructional memo that the task force has jurisdiction on this complaint, I ask that in the interest of time, the task force introduce a motion waiving a lengthy debate about jurisdiction and vote now to find you have the jurisdiction and move on to hear my complaint. Thank you.
So,
the others didn't.
So just move to find
The others
jurisdiction.
were all continued.
Is there a second? Member West has moved to find jurisdiction. Is there a second? Is there any public comment on the motion to find jurisdiction? Seeing none, public comment is closed. Mr. Clerk, could you please call the roll on jurisdiction?
On jurisdiction, Member Snyder. Snyder absent. Member Cawthon.
Aye.
Cawthon, aye. Member Manny.
Aye.
Manny, aye. Member Washburn.
Aye.
Washburn, aye. Member Costa.
Aye.
Costa, aye. Member Wolf.
Aye.
Wolf, aye. Member Chan. Chan, absent. Member West.
Aye.
West, aye. Member Johnson.
Aye.
Johnson, aye. Madam Chair, we have 7 ayes. The motion passes.
We have jurisdiction.
Go on, finish. I was, Madam Chair, I think I might have to recuse myself on this item. I am on the board of directors of an organization that's being evicted by Rec and Park, and I'm not quite sure that I can, based upon what I've read through here, even though we're not mentioned, that much of the subject matter seems somewhat the same regarding their kind of behavior. So I would request that I be recused.
If you feel that you need to be recused, I understand that, but you do realize it's not about an eviction.
No, I know that, but
okay, I'm just making sure that we're on the same page.
I'm just party to an issue that much of this discussion that's been presented here.
Okay, is there a motion to recuse Member Wolf?
So move.
Is there any public comment on the motion to recuse Member Wolf?
Might I just ask if Member Chan and Member Snyder are still present?
No, they are not.
I would strongly urge this body to ask Wolf to recuse himself. I think he is fully capable of judging Mr. Wooding's case on merits. I would like to suggest that moving down to a clear form of this body is not in the best interest of the public, nor Mr. Wooding. And I think Mr. Wolf has shown time and again his impartial ability to judge issues on their merits. So, Mr. Wolf, I am asking you to unrecuse yourself.
Is there additional public comment on the motion to recuse Vice Chair Wolf? Seeing none, public comment is closed. Vice Chair Wolf.
I would just say my only concern is that if I continue to participate and there is a positive finding in favor of Mr. Wooding, that Rec and Park could question that. And I'm concerned about that, considering how intensely entrenched I am on the issue that I'm dealing with. That's my only concern. It's a matter of, protection of your justice. That's what my concern is. I would prefer to protect the result and have it not be tainted than to have the result be a good one and then it be its validity questioned. That's where I'm coming from on this. And it's only because I've served on the board of directors for this organization for a decade. So
You prefer to be recused?
To me, it's in my kind of own wisdom in knowing how things might work, and depending upon, the results of this particular case. I mean, there's so much information and so many issues in dealing with this. I don't know. Really, it's up to you guys. You're going to vote.
We can't know if you're.
It's your wisdom to know whether I'll be doing the right thing or not.
Member Costa?
Right.
Do we have the commitment of the rest of the members to stay throughout this matter so as to keep a quorum?
Yes.
Member Cawthon, do you believe you'll be able to stay to complete this particular case?
Why do I look tired?
No.
I'm planning to stay.
Okay. All right. To me, it sounds like Member Wolf is uncertain, which is rare.
I am uncertain.
And so although I wish that it was much earlier and that we had more people here, I would say it's better to recuse if you're uncertain.
Well, I am uncertain. I mean, I hoped that maybe I hear from the complainant about what he thought, but I didn't hear that. But I will do the job, but I. Okay.
Okay, I personally think that this is a specific issue with broad overtones about actions of the Recreation Park took over and emails they did regarding speech at the Commonwealth Club. I think you can look at it that simply. It also goes to larger actions they could be taking throughout the city. I would like for you to stay. I don't know how you'll vote. I don't know how anybody here will vote, but it's clear to me if, I have a very good chance of losing with a bare bones minimum. I don't want to lose. I didn't wait all this time to lose. I don't know if this goes to August 23rd. I don't know what's going to happen. This is the first time I've ever been here. I would prefer to be heard and have it voted on. And you have the appearance of someone who's been very fair all night long. So I would say that I would like to see you continue.
Is the respondent present?
And the two items are completely separate.
Do we have to hear from the respondents? Do we have to complain it? Just with all due process, if do the members have further discussion on the motion to recuse? Is there further public comment on the motion to recuse? You can't speak again, though. Sorry.
What about my evil twin brother?
You could try to look like one of the Clarks. Mr. Clerk, you're going to have to make the call. The motion is on the. I guess it's up to us if we feel that Mr. Vice Chair Wolf needs to be recused, unless we haven't actually recused you, so you could withdraw.
I didn't make the motion.
But you suggested?
I suggested it. I said that I felt that I need to be recused.
Microphone, please.
Who made the motion?
Question for the chair.
I felt I needed to be recused. I felt it was important for me to express that. Usually there would be a call for a motion for recusal and then so on.
I believe they're separate items.
Well, the motion is on.
I'm the maker of the motion. I'd like to withdraw it and suggest that we hear that matter.
I'll accept as the seconder.
Mr. Clerk, did you have something that you wanted to add?
No, Madam Chair.
Can we do that?
Well, I don't understand what just happened.
Member Washburn would like to withdraw her motion to recuse.
Okay, so then she withdraws it. The
second
agrees,
agreed.
Then it disappears. And there's no motion to recuse.
So we found jurisdiction.
We found jurisdiction.
And Mr. Clerk, I've forgotten if you did read the next item of the hearing.
The next item, Madam Chair, is hearing on the complaint filed by George Wooding against the Recreation and Park Department for allegedly withholding correspondence.
The complainant will have 5 minutes, and then the respondent, Mr. Wooding.
Thank you, Madam Chairman. To summarize the key points of this case, in my July 5th Sunshine complaint, I noted, I was a panelist on the Commonwealth Club's May 11th forum about Golden Gate Park. On June 3rd, I first contacted RPD requesting any correspondence, emails, or other documents pertaining to the May 11th forum. I asked for all correspondence between RPD employees Sarah Ballard, Phil Ginsburg, Elton Pond, Stacy White, and Mark Buell to or from each other and or exchanged with Commonwealth Club officers, staff, directors, and volunteers. On June 8th, Olive Gong, RPD's custodian of records, responded by email indicating RPD staff had searched but found no responsive records. In your packets, enclosure 3 of my July 5th supplement shows that on June 9th, I followed up with Ms. Gong indicating her response was unclear, asking her to identify which staff had searched for documents and what specific documents were reviewed. Ms. Gong never responded to my June 9th email and never indicated which staff had searched for records. She responded on June 9th saying only, "We do not have any further documents in response." She didn't direct me to any other RPD staff as I requested. On June 10th, I submitted a second follow-up request asking for the names of all RPD staff she had asked. I also asked about the process RPD used to determine there was no responsive records. As of today, Ms. Gong has also not replied to my June 10th email. Around June 10th, I spoke with Ms. Gong by phone. She verbally told me again that there was no corresponding documents. I'd spoken with her by phone twice since then. She continues denying any records existing. During our July 20th phone call, I felt she was trying to persuade me to drop my Sunshine complaint. On June 20th, Ms. Gong left a message on my answering machine asserting there were no records. Also in your packets, my July 19 supplement to the task force shows, in Figure 1, Sarah Ballard's RPD, Director of the Policy and Public Affairs, wrote to the Commonwealth Club on April 20th from her city email account the day after calling the Commonwealth Club on April 19th. In Figure 2, Ms. Ballard sent a second email on April 20th, again using her city email account, to a second Commonwealth Club member, attempting to discredit the forum's panelists and trying to influence the content of the panel discussion. In Figure 3, Recreation and Park Commission President Mark Buell alleged on April 25th the forum's proposed panelists were biased. Buell CC'd both Phil Ginsburg, RPD's general manager, and also Jim Chappell. Figure 4 is a response from the Commonwealth Club to Mr. Buell and to Mr. Ginsburg at Ginsburg's private email address, suggesting Ginsburg may have received other emails about the May 11th forum. Figure 5 is an email from Susan Hirsch, director of the City Fields Foundation and CEO of Hirsch and Associates, claiming the forum's panelists were only representatives of people who oppose change. Given the evidence presented in these 5 emails, it is unlikely there are not other emails in RPD's internal email system or in personal email accounts between Mr. Ginsburg, Mr. Buell, Ms. Hirsch, Ms. Ballard, and other RPD employees that should be produced. And given the evidence of these 5 emails, it's shocking Ms. Gong's July 19th response to the task force included a June 9th email from Ballard to Gong in which Ballard claims I have nothing in response to Gong's June 6th email to RPD staff requesting any records. Given Ballard's 2 April 20th emails, it appears Ballard may have potentially and purposely misinformed and misled Ms. Gong. It seems clear RPD has violated Sunshine Sections 67.24, 67.26, and 67.34. I asked the task force to order the Recreation and Park Department and its commission to search their records again and produce all communication I had initially sought to obtain. Thank you.
Thank you, Mr. Wooding. Is there anybody in the audience to present facts and evidence in support of the complainant?
Catherine Howard, Golden Gate Park Preservation Alliance. We were appalled when we learned that a city department had used the weight of its position to try to influence or even cancel a public program. This evening we received this July 25th memo and we want to respond to it. The emails that are in that package, which are also in your package, but they're very hard to read, so we were able to blow them up and make it easier to read, make it clear that the Department of Rec and Park felt the panel would have a serious impact on rec and park business. I would like to read excerpts to illustrate that their involvement was considered part of recreation and park business. From Sarah Ballard, April 20th, from her government email address. Mr. Lawley, thank you for help yesterday suggesting I connect with Mr. Curtis to discuss the city's concerns with a member-led forum. This is figure 1. As we discussed, the headline summary of the talk and panelists suggest an overall tone that is more likely to incite an audience than it is to rationally discuss the facts and merits of Recreation and Parks' current direction. And I'm skipping a little bit. The Recreation and Park Department has faced over $45 million of budget cuts in the last 6 years. Instead of continuing to slash services to the public, the department has attempted to increase our earned revenue streams, which will enable us to continue to serve the people of San Francisco. We understand there is a legitimate debate about amenities and special events in parks. We feel this will be near impossible given the current makeup of the forum panel. And I'd like to explain that the forum panel was Jim Chappell, former head of Spur, Anthea Hartig, the president of the Western Office of the National Trust for Historic Preservation, myself, Mr. Wooding, and Mike Lyons, the conservation director and general counsel for environmental matters for the Golden Gate Audubon Society. She continues, I write in hopes the Commonwealth Club will see that this is a deeply biased panel that has no interest in discussing facts. I am hopeful that you can cancel the panel and perhaps work to put on a more balanced forum that focuses on problem solving. In an era of shrinking resources, it is impossible for the Parks Department to continue to provide the same level of heavily subsidized services to the public without thinking creatively about how to fund and deliver the services. And she signs it, Sarah Ballard, Director of Policy and Public Affairs, San Francisco Recreation and Parks. This is clearly her doing public business. There is also, figure 2 is another email when she continues this conversation with the Commonwealth Club, and she says, I look forward to hearing from you, and again signs it, Director of Policy and Public Affairs. Figure 3 is from Mark Buell, the President of the Recreation and Park Commission, and Mr. Phil Ginsberg, the General Manager, is copied. Greg, I have been informed the Commonwealth Club is hosting a panel on May 11th entitled Golden Gate Park Under Siege, claiming that there are plans for privatization and industrial development. I assume these relate to a water plant and providing additional food vendors. I find the title inflammatory, the participants biased, and the fact that no one from Rec and Park invited. As president of the commission, I'd like to urge the club to alter the title. And there's a few more emails which show that the department was engaging in department business in trying to censor and cancel this panel. Thank you.
Good evening. I'm Nancy Werfel. I support Mr. Wooding's complaint and believe that the Recreation Park Department has violated the Sunshine Ordinance and Government Code 6252E. Clearly, there is evidence of emails to the Commonwealth Club and others from Sarah Ballard in her capacity as Director of Policy and Public Affairs, and Mark Buell in his capacity as President of the Commission. Both individuals intended to use their positions of government power to influence and or intimidate a private entity, the Commonwealth Club, to cancel or to alter the title of a panel discussion about Golden Gate Park, or to insert a member of Rec and Park's department onto the panel. The fact that these emails were determined by Rec and Park, quote, not to be records, unquote, and therefore to not need to be retained, does not agree with the definition of records as defined in the Public Records Act. Page 68 of the Good Government Guide defines public records broadly as, quote, any writing containing information relating to the conduct of the public's business prepared, owned, used, or retained by any state or local agency, unquote. The Rec and Park Department's record retention policy provides examples of documents that are, quote, not records, unquote, and thus do not need to be retained. They include, quote, phone messages, documents generated for the convenience of the person generating them, and miscellaneous correspondence not requiring follow-up or departmental action, unquote. Follow-up action was requested by Ms. Ballard, who wanted the panel discussion to be canceled, and Mr. Buell, who urged the club to ask a department representative to be on the panel. Both Ms. Ballard and Mr. Buell were acting in official capacities and were writing emails in the conduct of the public's business by clearly referencing their government positions. Therefore, the public records they created were destroyed illegally according to Government Code 6252E. These documents are records because Rec and Park Department was conducting the public's business by trying to defend their approach to, quote, delivering services, unquote. This complaint should also include the illegal destruction of public records. The record retention policy for Rec and Park does not refer to a category of documents that are used to intimidate the public, so perhaps they felt free to destroy them. Thank you very much.
Good evening again. The May 11th Commonwealth Club meeting was to discuss the public's business, but Mr. Boyle, Mr. Ginsburg, Ms. Ballard, and others strong-armed themselves onto the panel of May 11th. Any information relating to the public's business are clearly public records by definition in CIPRA, specifically CIPRA section 6252C. So any emails to Ginsburg's and Buell's private emails dealing with the public's business are public records. Mr. Threet's instructional memo should not be citing the foreign jurisdiction of Arizona and Wisconsin law that I mistakenly brought up in my own complaint. I am so sorry to have introduced an error. The July 25th memo that Ms. Gong suddenly coughed up yesterday says that RPD didn't retain the records is preposterous. As Mr. Threet noted, did in his instructional, did RPD search for backup tapes? I know that Mr. Wolf is an ISIT whiz. Is anyone really here tonight believing that when you hit the delete button on a personal email, on a city email account, that there's not an audit trail on a backup tape, or that DTIS can't find it? If I am a city employee, and I'm giving you a hypothetical. Let's say I engaged in a crime, and the city decided to search my emails. Are they telling me that via Ms. Gong's email that they would never be able to find my email records? That is not believable. All they'd have to do is pull in a forensic auditor with the computer expertise of Mr. Wolf, and they would certainly find those emails. They're not deleted. They're just being hidden. In Mr. Threet's suggested analysis for section 67.26, he suggests you should determine whether RPD withheld records by failing to provide private emails. But Mr. Threet conveniently neglected to have you determine whether emails were withheld by failing to provide public emails that have to be available in some kind of audit trail of the city's email system. Mr. Ginsburg is responsible for the actions of Ms. Gong. Ms. Gong's sudden memo saying that Category 4 records don't need to be retained does not specifically say that they have been deleted. She just says that they have a policy. That policy, Category 4, does not address emails. Are each RPD staff members allowed to determine the retention of their emails independently? Are all 37,000 city employees allowed to independently decide what is the definition of business utility?
Thank you, Mr.
Gong should have raised.
I'm sorry. Thank you. Are there any other people to present facts and evidence in support of the complainant? Seeing none, the respondent will have 5 minutes.
Good evening, honorable members of the Sunshine Ordinance Task Force.
What is that?
My name is Olive Gong, custodian of records for Recreation Park. My name is Olive Gong, custodian of records for the Recreation Park Department.
Is that on the mic? Thank you.
Hello, hello. In response to Mr. Wooding's complaint, I have asked staff if they had any documents in response to his request, and all staff have responded to me that they do not have any records regarding the Commonwealth Club program of May 20th, 2011. That is the response from staff, and I have let Mr. Wooding know this by email. The only records that I have are my asking staff if they have records, and they all responded that they do not have records. And I let Mr. Wooding know this July 19th. On the same day, July 19th, Mr. Wooding sent a letter to the Sunshine Task Force saying that he had emails from Rec and Park, but my staff have said that they do not have these documents, and per our department's record retention and destruction policy, we do not keep these documents because they fall under Category 4. Category 4 says no retention required. Documents and other materials that are not records as defined by Administrative Code Section 8.1 need not be retained unless otherwise specified by local law. Documents and other materials, including originals and duplicates, that are not otherwise required to be retained are not necessary to be functioning of the continuity of the department and which have no legal significance may be destroyed when no longer needed. It also says that with limited exceptions, no specific retention requirements are assigned to documents within this category. Instead, it is up to the originator or the recipient to determine when the document's business utility has ended. So that is why our department does not have any of these emails. Well, at least that's what staff has indicated to me, that they do not have any records, and the records were not retained. That's all.
Is there anybody in the audience to present facts and evidence in support of respondent? Seeing none, the matter is with the task force. Member Wolf?
Okay, there has been several references to Administrative Code Section 8.1, but nobody has provided exactly the content of what that is. So it's a fairly short paragraph. I'm going to read it. I think it's important that everybody know it. Section 8.1 of the Administrative Code, it's labeled, quote, records, unquote, defined. Quote, records, comma, unquote, as used in this chapter shall mean such paper, book, photograph, film, sound recording, map, drawing, or other document, or any copy thereof, as has been made or received by the department in connection with the transaction of public business, and may have been retained by the department as evidence of the department's activities for the information contained therein, or to protect the legal or financial rights of the city or county or of persons directly affected by the activities of the city and county. Okay, so that's the context that Rec and Park is putting on the as citing their reasons for being able to, or not being able to produce these records, or refusing to produce these records. Whether they're destroyed or not, we don't know, except by the email interaction with Ms. Gong that nobody has anything. Okay, so with that, even though what's interesting to me is in their retention policy under Category 4, in the very first sentence, this is documents and other materials that are not, quote, records, unquote, as defined by the section I just read, 8.1, need not be retained unless otherwise specified by local law. Well, the Sunshine Ordinance supersedes local law. So that's where the authority of the Sunshine Ordinance comes in at this point. Whether we will need to determine whether these documents are public documents, and if they are public documents, then they must be presented. The fact that the complainant has produced the documents from a third-party source is only evidence to show that there is documents. Now, this body, this task force, and I don't think anybody, maybe Ms. Cawthon was here, and maybe Member Washburn was here. I wasn't. I was off the task force at that time. But there was a case brought before members of the public regarding against the San Francisco Public Utilities Commission around the peaker plants. And there were communications that were made between the San Francisco Public Utilities Commission and Cal ISO. Cal ISO is the California Electrical Grid. They are the body that makes the regulations for electric generation companies. SFPUC came in here. The director, Ed Harrington, came in here, and they all claimed that they had no communications at all. But the public members, the complainants, had brought emails that they had gotten straight from Cal ISO under the California Public Records Act. And so then you can imagine what the result of that case was. So this is, I mention that because you have somewhat the same kind of situation here. And unfortunately, we don't necessarily have a kind of a database set up of past orders and determinations based upon the kind of category of information like this would be, which I'm trying to express as somewhat the same exact thing. Then, I wanted to see if I just wanted everybody to know about that particular instance that came before the Sunshine Ordinance Task Force, because it's meaningful. The question of the context is not important. So let's not get caught up on the context of whether the Commonwealth Club, this, or Rec and Park has any concerns. Of course, they have concerns, obviously, by the evidence that the complainant has brought forward, but that's not what's of concern here. The complaint is against Rec and Park for not producing the documents. So I want to narrow the focus of the of what we need to find as far as if there's a violation or not with regards to that. So we don't get caught up in a very lengthy conversation about the context, which we don't have much time for. So with that.
I do want to point out to Rec and Park, so many things have been said. I have so many pieces of paper, and it's very late. This may have already been said by the complainants, but public records is also defined in the California Public Records Act, which is state law. So Administrative Code Section 8.1, nor the Sunshine Ordinance trumps it. And it's 6252E. Public records includes any writing containing information relating to the conduct of the public's business. I'm not going to go on because Sarah Ballard is absolutely using Ms. Ballard is using her title and her full title and her full address at City Hall, including her email. Mr. Buell makes a representation that as the president of the commission, that is the public's business. And it is totally offensive that you would come up here and say, no retention required based on Administrative Code 8.1. That's my business. Now, so the content itself of what they said is not necessarily, whether it's inflammatory or not, but it is definitely, even though, for example, in Mr. Threet's instructional memo, he discusses if it's on private email, is it considered public business? But if I represent myself in my private email as the chair of the Sunshine Ordinance Task Force, I am doing the city's public business. So getting around it, and in addition, Mr. Ginsburg is a highly visible department head. And Section 6729.7, correspondence and records shall be maintained. The mayor and all department heads shall maintain and preserve in a professional and business-like manner all documents and correspondence, including but not limited to letters, emails, drafts, memorandum, invoices, reports, and proposals, and shall disclose all such records in accordance with this ordinance. So to write inflammatory statements about the citizens of San Francisco and then delete them and then say they're not part of the business, of the public's business, I'm not sure that necessarily falls under the Sunshine Ordinance, or how exactly if they're deleted, there is a violation, but I'm not sure that we can order documents, but
the fact that the fact that the complainant has presented evidence of use of city communications, the question then becomes, now that they have been presented and they're publicized, that they should be retrieved, that these folks must produce them. Now, member of the public, Manette Shaw, is correct that there obviously has got to be a backup somewhere. There's always something backed up somewhere, but this is something that the task force has not yet been able to get its fingers into yet, because the city's just about is going through a major transition. So we're not quite there yet as trying to be able to retrieve those emails. What I would do, though, is I would review the San Francisco Public Utilities Commission case, which is more or less the same exact thing as this. The problem is the question, the only question that can come up with is with regards to activities. This is an activity with an outside entity, an outside nonprofit membership organization. It's the business between the Public Utilities Commission and CalISO is definitive. That's governmental. So, and and it has to do with regulations and regulatory items. So, my concern is if I go back to what they're citing with regards to Section 8.1, the very last sentence talks about persons directly affected by the activities of the city and county. Okay, so, to me, I consider these records to be public. They, the public was going to put on a presentation regarding Rec and Park. Rec and Park activated themselves to try and protect themselves, and used, and here it says to protect the legal or financial rights of the city and county it seems in some way, shape, or form, that's what they were trying to do. So I'm not convinced by Rec and Park's assertions that these documents are not public and should not be retained. From there, the question is, one, they didn't present the documents. Two, did they destroy them? Three, by their retention policy, was the communications part of, business activities? Those are the questions that we need to ask.
We have 5 minutes, and they may come and kick us out. And people need 3 minutes to respond, 3 minutes to respond. I'm not sure how the task force.
I just wanted to
Member Coughlin.
point out the the Sarah Ballard email to the Commonwealth Club. I mean, she identifies herself as Sarah Ballard at sfgov.org. If that's not done on city business, if that's not city business, she shouldn't even have used her public email. Pardon me, I'm really tired, but I think this is a clear violation of the records retention policy. I think we had a case with Supervisor Peskin, and he apparently destroyed emails, or he couldn't find them, regarding something about parrots, if anybody remembers. But we found him to be in violation. So I would move that we find them to be in violation. I mean, since we're so short, we have so little time, I would just move to find them in violation.
Well, I do want to continue with the process. I'm inclined to also to make a motion to find violation, but let's move forward with the response by the respondent first, then the complainant. The respondent first. It's all right, I understand. So the respondent will have 3 minutes, and then the complainant will have 3 minutes to respond. Mr. No intimidation by the public, please. We're going to make it all.
I guess I can't speak to the content of the emails. I can only say that I asked staff for documents, and staff has consistently responded, and I have not received any documents regarding the Commonwealth Club program of May 11th, 2011. Yeah, that's all I can say.
Thank you. Complainant? Yeah. Can you hold on 1 moment so the clerk can set the clock?
No need, Madam Chairman.
We have 3 minutes.
To waive my time in interest of you having the time to review this, my only request would be that people like Ms. Ballard would be named in anything, as opposed to Rec and Park employees. I'd like specific employees mentioned in any judgment or ruling. Thank you, I'm done.
What's the complaint? Who's named in the complaint?
It's Olive Gong is named as the contact, but
it's Mark
the
Buell,
complainant
it's
is
Sarah
filed
Ballard.
against the department.
Whose name? Do you have it?
Yeah, Philip Ginsburg,
What
Mark
page?
Well, Sarah Ballard, 225.
Thank you.
Mm-hmm.
Okay, just so we make sure. I have one question for Ms. Gong. Were you aware of these interactions that were going on with the Commonwealth Club? No, I do not have any. Okay, I'm sorry, could you speak into the mic?
No, I'm just custodian of the records, so I just do administration, and I don't know anything about the content of these meetings.
Okay, thank you.
I'm not involved in them.
Thank you.
Ms. Gong, don't go away. Ms. Gong. What do you, I mean, as custodian of records,
Yes.
what do you consider your job to be?
Well, what my instructions have been is that when we do get public requests, that I take them, and then I send the request to the staff that may have the documents, and then they respond to me. So
Okay.
that's just my job.
Are you, was there any search done of backup emails, or
I did not do any search.
you did
of
not do any?
backup emails, no.
Okay.
That's not I have never been asked to do that.
You've never been asked to do that. Okay. All right, and that's it. Thank you very much.
I'm going to make a motion to find violation of, is this what I'm looking for? I'm sorry.
I'd be happy to second the motion. I would be happy to second the motion. My only concern would be sort of calling the question in any haste would not allow us a thorough opportunity to have a motion that sort of includes all the potential violations that are going on here. I don't know. I don't want to slow down the process, but I also don't want to be hasty and less than thorough. That's my only concern. Because we do need.
I'm not going to continue it.
Right. Then it's all.
Unless there's.
Go
I have
for
I'm going to make a motion to find the people named in the complaint. Where? I moved it so I could. Phil Ginsburg, Mark Buell, Sarah Ballard, and Olive Gong in violation of 67. Well, definitely 6727, failure to justify the withholding of records. Yes, but they cited to Administrative Code 8.1. It's not. It's. You're saying that they provide something, but it was wrong.
Has to be a proper citation, no?
How are they going to know whether it's correct or not?
Until they cite it.
Yeah. They think it's correct.
I see, because they're saying that they have to.
Their interpretations is what they presented. We can say it's wrong. So I'm saying they presented they cited regulation and their retention code. That's not a failure of not citation. Doesn't mean it's correct. But they didn't fail. They didn't fail to cite.
Okay. One other question before we make the motion is: was there also a complaint that this was not responded to immediately? Was this responded to within 10 days? Okay.
Well, wait.
Because there's immediacy.
Oh, wait a minute.
No. It's an
this is-
IDR. It's 24 hours unless
Okay.
a request for 10 days is made. That's the question. So, Ms. Gong, the question is, when you received the IDR, did you respond within 24 hours?
By the end of the next business day.
Yes. Well, there's only one complaint.
This says that you responded on June 8th to the June 3rd complaint.
Right.
And on July 20th to the June 10th complaint.
Yes. It says on the top, immediate disclosure request.
It says 6725, 6726 withholding kept to a minimum, and 6721 what section of 6721? Is it E that governs the
What issue? What topic?
turning over the documents?
721B.
This one. But it really has to do with the IDR first. Because if you do this
Okay.
one, then you're overriding.
So 25, 26. And Ms. Gong, did you send this request to Sarah Ballard and Phil Ginsburg? So I'm also going to add 6721C because they didn't speak to the complainant about perhaps they could get this information from the Commonwealth Club. They didn't assist the requester in finding where the documents might be.
I might add that the, hold on, I want to see its original letter.
It's late, I can't.
Okay. I was questioning how he was making contact with the different.
Is there a second to the motion?
I'll second.
Second.
Is there discussion? Is there public comment on the motion? Seeing none, public comment is closed.
You want to refer this to a particular committee?
Yes, and refer this to the Compliance and Amendments Committee.
I'm sorry, I did want to comment on the motion. Can you make a friendly amendment that RPD be ordered to immediately produce those records within 5 days?
No. Isn't
All
it?
right.
It's 5 days after the order of determination, whatever our standing rule is.
Okay, fine.
Yeah.
Clerk, can you please call the roll?
On the motion, Member Snyder. Snyder absent. Member Cawthon.
Aye.
Cawthon, aye. Member Manny.
Aye.
Manny, aye. Member Washburn.
Aye.
Washburn, aye. Member Costa.
Aye.
Costa, aye. Member Wolf.
Aye.
Wolf, aye. Member Chan. Chan absent. Member West.
Aye.
West, aye. Member Johnson.
Aye.
Johnson, aye. Madam Chair, we have 7 ayes. The motion passes.
Thank you. I apologize to the clerks because we do not have time. We have to leave at 11. So there may possibly be a special meeting we have to discuss. So, okay. Thank you.
Madam Chair, I would like to do what we can for the the complainants against the MTA to see if we can pull together a special meeting.
That's my hope, but of course we have to ask them if they're available. Then we have to find a date that the room is available and that Mr.
Right.
Rustum is available. So I will be contacting Mr. Rustum. Also, I know we all know this, but I think that we have to put forth some sort of an effort. Mr. Rustum, can you please read item number 37? We're just
Yes, Madam Chair. Item number 37 is announcements, comments, questions, and future agenda items from the task force members.
We need to put forth some kind of an effort to shorten the meetings. Now, I do not know. I tried with the orders of determination. I tried with the bylaws. There are a number of things that I would like to do that I don't know necessarily. For example, the orders of determination are already our orders. I'm not sure we should have a rebuttal. Maybe they could come and speak, but I'm not sure how. But if you have ideas, we could put them on the agenda. We could present them, but also just take that into consideration as we. I don't want in any way to curtail the discussion. So I hesitate to say we're going to have a time limit, because all of a sudden we may end up continuing a lot of things, just because we don't feel confident. So I just want to bring that. Member Wolf?
I just wanted to ask Chris, are folks, when they file a complaint, are they asked if they want to waive 45-day rule?
Through the chair, no, I do not.
You do not. You may want to start. We used to do that.
Yes,
and that helped a lot sometimes. It might just, some folks may say, yeah, I don't need to do it next month. You can wait 2 months. You can wait 3 months.
But this, through the chair, this exactly happened in Mr. Wooding's case. We told him he could waive his right to have.
Yes, we did ask Mr. Wooding if he wanted to waive his right, just as I did with Pastor Gavin, to be the first on the agenda. Mr. Threet, or DCA Threet, and Mr. Resteman, I am potentially Vice Chair Wolf, are going to work on getting the agenda out a little bit sooner. This was a difficult agenda for me because there were promises that the previous chair had not promises, but statements made in the meetings that certain things would be on the agenda. And so it was kind of a combination of me trying to put some things on there and keeping the previous statements consistent. But I really don't know whether to say it out loud or not, but I overheard one of the members of this panel discussing negative comments, again, by an elected official here. So I really want us to try to tighten up as much as we can while we still have the opportunity. So if you have suggestions, we can talk about them if we get a chance. And I apologize about the ethics regs, but we have to get those to Ethics Commission, or none of these things are going to have a set thing that we could point to say. Is there a motion to
move to adjourn?
Second.
The meeting is adjourned.